Okay, you can for an inquiry on a certain memo. Lord, in the meanwhile, the land tribunal was not constituted. It was not constituted. So therefore, I moved this honorable court seeking an interim direction that he shall not create any third-party interest or develop the property till such time the land tribunal takes up the matter and decides his claim.
Whether land tribunal committees are constituted,
It is,
Constituted.
I'm
And
told
then
they're
we-
constituted.
you have a remedy, all efficacy remedy before the land.
So therefore, I have to move the land tribunal now.
Of course.
In the meanwhile, let the
No. And you will go and tell the land tribunal that the High Court has already granted injunction or any prohibitory order that has to be examined by the land tribunal independently.
correct. Well, look, till such time they take up this interim
such
arrangement.
time? Why such time? When the committee is constituted, why you're maintaining a writ petition here?
Well, at the time when I moved this.
No, then now it is rendered infectious.
I understand, my lord, but
One request I can entertain. I'll ask the land tribunal to expedite if any interlocutory applications are.
please,
But,
please.
This petition is filed taking directions against respondents not to change the nature of the land, on the premises that now the matter is seized before the land tribunal pursuant to a remittal order passed by the Honorable Apex Court.
Only in respect of
29 guntas.
29
I
guntas.
understand, my lord.
Insofar as 29
29
guntas is
guntas in survey number 1/11.
audit, insofar as 29 guntas is concerned.
Lord, insofar as the other two survey numbers are concerned, I'm not interfering with the orders.
Now
I'm only seeking 29 guntas, which is not granted. Let them not do anything till such time the land tribunal takes up the matter.
That's
That is
already-
all is a simple
that's
relief.
already-
No, I think, no. His statement was that what is granted also you're objecting.
No. 29 guntas.
Was
Illa.
objected. My lord, it
Illa.
went up to
I'll
Supreme
make a
Court.
statement across the.
Audit. Work out.
And my lords, there is an order of
Allala.
permanent injunction which is confirmed by this honorable court in RFA, including this 29 guntas.
Including 29.
Yes, my lords.
Work out.
Inquiry. So therefore, 29 guntas better.
The Honorable Apex Court's order rendered in civil appeal 7657/7658 of 2017 relates to only 29 guntas of land
In 1/11.
in
Survey.
in survey number 1/11 of so-and-so village, Yashwantpur, Hubli, Bangalore,
Excluding the 25 guntas, which is already granted.
including 25
ಅದೇ
guntas,
ಹೊರತುಪಡಿಸಿ ಅಂತಾನೆ ಇದೆ.
excluding 25 guntas, which is now conferred by the land tribunal on the private respondents. Next, learned AGA has brought to the notice of this court that land tribunal is constituted and is functioning. If that is so, if that is so, petitioner has to seek appropriate remedies, reliefs at the hands of the second respondent land tribunal, where the subject matter of the petition now stands seized in the light of Apex Court order, reserving liberty to petitioner to file appropriate applications in accordance with law. Petitions stand disposed of. If such applications are filed, land tribunal shall ensure that the applications are heard in accordance with law after notifying the other.
Please.
The land tribunal may be time fixed, my lords, because it is much of
So ಏನಾಗಿತ್ತು ಅಂದ್ರೆ ಈ ಪೆಂಡೆನ್ಸಿ ಇರೋದ್ರಿಂದ ಅವರು ನೋಟಿಸ್ ಮಾಡ್ತಾ ಇರ್ಲಿಲ್ಲ. I moved the land tribunal last week. They said, since the matter seized in this writ petition.
Lords,
Please.
even, my lords, after the order of the, so Apex Court, I made an application in the year 2023.
ಇದು ಆಗಿದೆ ಬಟ್ ಅದು ಇಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ ಫೈಲ್ ಅಲ್ಲಿ. ಅಲ್ಲಿ ನಾನು ವೆರಿಫೈ ಮಾಡಿಸ್ದೆ.
Yes, sir. Hebar, sir. Have a quarter.
I seek password.
Password,
Please.
audit password.
Hearing for petitioner, my lords. My lords, senior counsel Srivatsa has argued this matter. Today is before Gulbarga bench, my lords. They may I seek a shock accommodation, my lords.
Now still number?
4, my lords.
Yes. Work out.
A date may be given, my lords.
Whatever, 2 weeks not my fault. Next,
My lords, any short accommodation, my lords, I think, within.
fine.
This matter may not, the government has proposed for construction of school and hostel in respect of the said survey number. The request of the petitioner is already rejected.
ಇಲ್ಲ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಇವ್ರ ಜಾಗನ ಸ್ಕೂಲ್ ಬಿಟ್ಕೊಟ್ರು ಸ್ಕೂಲ್ ಬಿಟ್ಕೊಡಿ ನಮ್ಗೆ ಜಾಗ ಬೇಕು ಅಂತ ಹೇಳಿ ಬಿಟ್ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಎದುರುಗಡೆ ಇರೋ ಭೂಮಿ ನೀವ್ ಹೋಗಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇವಾಗ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಸ್ಕೆಚ್ ಎಲ್ಲ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ endorsement? Where is it?
Therefore, today morning I obtained the inspection.
All right, collect the endorsement.
ಎಸ್ಟರ್ಡೇ ಇದು ಒಂದು ಕೇಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಇದೆ ಸರ್ವೆ ನಂಬರ್.
ಇದ್ರಲ್ಲಿ endorsement ಇದೆ. Your claim is rejected, you have to challenge that order. Let him produce it, let us see.
Similar matters ಕೂಡ ಡೈರೆಕ್ಷನ್ ಆಗೋಗಿದೆ.
ಹೌದು.
ಅದನ್ನು ಕೂಡ ಎಲ್ಲ ಆಗಿ ಆಗಿದೆ. ಅವ್ರ ಕಲ್ಟಿವೇಶನ್ ಎನ್ವೈರನ್ಮೆಂಟ್ ಆಫ್ ದ ರಿಕ್ವೆಸ್ಟ್ ಎಲ್ಲ ರಿಜೆಕ್ಟ್ ಆಗೋಗಿದೆ.
Then you
Sketch ಇದೆ.
pass one more order, taking note of that.
We take note for all respondents.
Yes, SCGP accept notice to respondents, list it on so and so date. Next. Yes, ready?
Again, the order passed by the deputy commissioner, presented petitions. The deputy tahsildar rejected to effect mutation and points in the names of respondent 3 to 6, my lord. Again, that respondent 3 to 6 filed the appeal before the assistant commissioner. The assistant commissioner also,
Based on what? You are asserting a mutation based on what document?
myself, madam,
Ah,
they are claiming the mutation on the basis of gift deed.
Huh?
Gift deed executed by their grandfather.
ah.
Based upon that gift deed, the respondent 3 to 6 filed a suit against the petitioner's father and others for the reliefs of permanent injunction in respect of the property got under the gift deed.
Where is the decree?
Last of kindness, I have produced the documents, further documents, additional documents I have produced. Kindly look. Exhibit. Decree, madam.
Now that suit is decreed.
Yes. Document number 3, my lord. Kindly, you last of kindly. Document number 3. That was the suit filed by the respondent 3 to 6 against Ramaya.
Suit is
Chandra.
dismissed.
Decree.
Suit is dismissed.
Who dismissed?
Ah,
They filed the suit for the permanent injunction based upon the gift deed executed by their grandfather. Suit came to be dismissed. Against the judgment and decree,
all
they
right.
filed the appeal before the learned.
That is also dismissed.
That was also dismissed, my lord. The deputy commissioner, without considering that, the respondent 3 to 6 approached the deputy tahsildar to effect mutation and punish on the basis of this gift deed.
No, but in the suit, only sale deeds were subject matter. Gift deed was not the subject matter.
Subject matter is the gift deed in
No,
this
but-
suit.
Gift deed, correct.
Yes, my lord.
Now, how we are entitled to this property?
Now, there was a partition between Appaya and Ramaya and Appaya, my lord. Under the Panchayati Palapatti on 21/19/90,
All right, take notice.
1990, my lord.
Take notice on private respondent.
Now they are trying to sell this property based upon this order, my lord, because the deputy commissioner directly ordered to effect mutation and punish.
Prior to that, whose name was entered? Yaar ಹೆಸರು ಇತ್ತು?
ನಮ್ಮ ಹೆಸರಲ್ಲಿದೆ ಪಾಣಿಸ್. Panis mutation and panis affected in our names.
Based on what?
Earlier, my lord.
Based on what? Inheritance kata?
No, based upon the partition. In the year.
Anjanappa.
Yes,
Anjanappa was.
Anjanappa, yes, my lord. Anjanappa and others,
All related, respondents are related to you.
yes.
ಅಲ್ಲ ಬರೀ ಅದು ಇಂಜೆಕ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ. Whether gift deed title is held to be proved here.
Avuru, they filed the suit, Ramesh and respondents, 3 to 6 filed the suit for the reliefs of permanent injunction based upon the gift deed executed by their grandfather, Appaya. That suit came to be dismissed, holding that there was a Panchayat Palapatti on 21/19/90 between Appaya and his brother Ramaya. and 1 acre 6.5 guntas allotted to the share of Ramaya, remaining 1 acre 6.5 guntas allotted to the share of
Who is
Appaya.
Appaya?
Appaya is the brother of Ramaya, my lord. Now, last can you say what this Appaya did
ಬರ್ಕೊಡ್ರಿ.
after the
ಬರ್ಕೊಡ್ರಿ. ಆ ರೆಲೆವೆಂಟ್ ಪೋರ್ಷನ್ ಓದ್ಬೇಕು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ. The counsel for petitioner. Petitioner represent the branch of Ramaya while private respondents 4 to 6 represent the branch of Appaya. On closer examination of the findings recorded by a civil court in OS 114 of 2005, it is evident that the partition between petitioner's father Ramaya and respondent's and sister Appaya is upheld in a bare suit for injunction. The trial court has also taken cognizance of the fact that Illali Appaya respondent yaru, these are grandchildren, sa yaru.
Appaya, Appaya is the grandfather of respondent 3 to 6 months.
Fact that Appaya, who had only half share in
Yes.
terms of partition,
Yes, my lord.
could not have gifted the entire extent,
Entire extent.
contrary to the allotment made in the family partition.
Yes, ma'am.
These significant details are not dealt by assistant commissioner and deputy commissioner.
Yes,
Ibruna concurrent order. Assistant commissioner allow.
Deputy commissioner passed against order, but deputy tahsildar and assistant commissioner.
Imparವಾಗಿ ಮಾಡಿದ್ರಾ?
Nam parvati.
Deputy are not examined by deputy commissioner while setting aside the order passed by the assistant commissioner.
Yes,
Second
ma'am.
respondent, assistant commissioner. Petitioner reasonably apprehends that private respondents are trying to meddle with the property only on the strength that the entire extent is now ordered to be reflected in their name. Therefore, this court is of the view that petitioner is entitled for some protection. Pending consideration, the order of the first respondent deputy commissioner is stayed till next date of hearing. The honored AG is directed to accept notice to 1 to 3. Issue another notice to respondents 4 to 6.
Yes.
Let's kindly pass on.
Password, audit, password.
I'm 14%.
Audit, password. ಯಾರ್ರಿ ಪಾಸ್ವರ್ಡ್ ಕೇಳಿದ್ದು?
I asked for pass on.
14% is 14%. Elli?
I'm Vijay Kumar, sir, R3.
You are from Bangalore or?
I'm from Bangalore.
Audit, right. Password. Next,
You taken later.
seal number 8.
It will be taken later. Okay, I understand. Oh,
Yes, sir. Rashikarappa.
I appear for the petitioner. Lord, is the purchaser of 1 acre of land, and certain proceedings have taken place between the purchaser and another person before without impleading me as a party, my lord. And I came to know this about this order only recently. Immediately I obtained the copies of the order and I have challenged that order. And I was not a party before the any of the courts before the either the assistant commissioner or the deputy or the tahsildar.
What's the date of the order?
And date of the order is 27/8/2011, Annexer A, my lord.
Order, take notice.
Agli, sir.
Honored AG is directed to accept notice to 1 to 4. Issue a major notice to 5 to 10. List it in B group. Issue notice on main matter as well as on I1 of 24. Next.
Permission because I was not a party.
ಅದು ನೋಡೋಣ will. Yes, Krishnamurthy.
Please. This case, my lord, sir.
21/2025, my lord, this court directed the ADLR and JDR to file an affidavit, my lord. Affidavit is pending, my lord. The ADLR is not well, my lord.
Not keeping well.
Not it.
ಅಲ್ಲ ಇದರಲ್ಲಿ
Along with document.
ಅಲ್ಲ I file a memo of that order, my lords. They are playing with this petitioner, my lords. He is a poor person. One or the other way, they are harassing as against the interim order passed by this honorable court. They have passed this order, my lords. I will read that portion, my lords.
ಈ ಮತ್ತೆ ಮಾಡಿದಾರ?
ಹೌದು, ಮತ್ತೆ ಮಾಡಿದ್ದಾರೆ. ಈಗ ಅಫಿಡವಿಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳ್ತಾ ಇರೋದೇನಂದ್ರೆ ಸಬ್ಜೆಕ್ಟ್ ಟು ದಿ ರಿಸಲ್ಟ್ಸ್ ಆಫ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ ಆರ್ಡರ್ ಅಂತ ಹೇಳಿದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದರಲ್ಲಿ ಹೇಳ್ತಾ ಇರೋದು ಅಲ್ಲ, ನಾನಿಲ್ಲಿ ಅಲಾಂಗ್ ವಿತ್ ದಿ ಮೆಮೋ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿನೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಓಡಿ ದುರಸ್ತಿ ರದ್ದತಿ ಆಯ್ತು. ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಅಂತಿಮ ಆದೇಶಕ್ಕೆ ಒಳಪಟ್ಟಿರುತ್ತದೆ. ರದ್ದತಿ ಮಾಡಾಯ್ತು, ಇನ್ನು ಇಲ್ಲಿ ಏನಿದ್ರು ಇದು ಅಂತ.
File affidavit.
File, file.
Extend everything.
You place it on record. We'll initiate inquiry against.
ರೈಟ್ ನಾವು ಫೈಲ್
File it, serve on the other side, sir.
ಅಲ್ಲ, ಅವ್ರ ಹತ್ರ ಕಾಪಿನೇ ಇದೆ ಇದು.
Yeah.
ನಾನೇನು ಬೇರೆ ಕೊಟ್ಟಿಲ್ಲ, ಆರ್ಡರ್ ಮತ್ತೆ ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಷ್ಟೇ.
Record, counsel for petitioner to substantiate that respondent authorities contrary to interim order granted by this court
4(9) ಗೆ ಪಿಟಿಷನ್ ಹಾಕ್ತಾರೆ.
has disposed of the revision adu.
ಹೌದು,
Has disposed of revision.
ರಿವಿಷನ್
The copy of documents are now placed on record.
ಆನ್ 21/11/24.
Now placed before this court. Same is taken on record. Same is taken on record. At the request of learned SCGP, release this matter. For everyone, the ಯಾವಾಗ ಹೇಳಿ date.
Affidavit is ready.
Order. 11th.
11th.
Will decide on. Then ready? None appears. List it on so and so date. Next, 11.
Lords, in this, your lordships told me, I have given it a thought, my lords, if they want to withdraw, let them withdraw, because in my case, they are already there. My lords, and only thing, my lords, the impugned orders are fraudulent orders. Therefore, they have to be set aside, my lords. That is my request.
Set aside already in 2024 order ಈಗ.
Service is not,
Huh?
service is
ಎಲ್ಲ
not,
preliminary ಎಲ್ಲ ಆಗ್ಬೇಕಾ ಈಗ.
ಇಲ್ಲ,
grant you some
ಅದಕ್ಕೆ ನನ್ಗೆ ಅದಕ್ಕೇನೆ ನಾನು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಗೆ ಕೇಳಿ.
I'll grant you some protection.
Yes, ma'am. Because against respondent 8, even this honorable court has not quashed the criminal case, my lords.
become one side, another are 8.
What is the gist of that order which was created? A created order ಅಲ್ಲಿ ಏನ್ ಬರ್ಕೊಂತಾರ ಅವ್ರು?
Annexure E, my lords.
Huh?
In that, in annexure E,
Subsequently, my lord, the very same order has been referred by the deputy commissioner. And my lord, he says he summoned the records, he has verified, and he has said it is a valid order that has been passed. Your lordships can see the latest order that came to be passed by the learned deputy commissioner, my lord, at page 132.
my lords, may I,
Here it's a case, my lord, where at an
Ready,
earlier,
sir. One ನಿಮಿಷ ಇರ್ರಿ. I'll hear and I'll come back. Yes, yes, madam.
my lords, annexure E may kindly be seen, my lords.
Early page
page 103,
100?
103. This is the order which was created.
ಇದೇನಿದೆ ಜಿಸ್ಟ್ ಏನಿದೆ ಹೇಳಿ.
This ಏನಂತಂದ್ರೆ, eighth respondent who was no way concerned to the land of the petitioner's father. He got it created in the name and got it forced with the signature of the Tahsildar. He says that he got 5 acres, 4 guntas by virtue of this fake order.
And our rate is not related to you?
No, no,
It's not related.
no,
ಆಮೇಲೆ ಪಡ ಅಂತ ಆಗಿದ್ದು ನಿಮ್ ಲ್ಯಾಂಡ್
none land.
your father's property.
He filed for restoration of that. Now, my lords, he claims 5 acres, 4 guntas, and others 3 more acres. He says Bagairav come. 3 more people who are also not connected to my family.
This is held to be a created document.
This is a created document. What the Tahsildar also says subsequently in order, my lords, the deputy commissioner, in the first instance, even AC also grants stay order of this fake order. Subsequently, it is without any reason, without any reasons forthcoming, they vacate the order. And if the petitioner's father approaches,
And where is that report submitted by then Tahsildar
in
saying
the,
that it is
in
not?
page number 105, annexure F.
Yes. Now, what is the settlement that they have arrived at? now?
Yes. My lords, what they have done is when they my father's, they claim that my father's second wife's children, that is a respondent number 26 to 29.
Ah.
They claim that they are my father's, and I filed against them only suit for partition. It was going on. 22 to 26. They are my co-sharers.
Yes,
Yes.
please.
When the matter partition was going on,
What is the
This-
settlement? What is the settlement?
settlement is not there. My lords, what has happened? This Krishnappa sold it to another Krishnamurthy, that is at annexure. Sale deed is at
Yaro, the one who had got it, R8,
R8.
R8.
He sold it to Krishnamurthy. That is
Ah,
at page
Krishna-
number, my lords, B, annexure B, page number 54.
R8 sold to R11.
Yes, my lords.
And what about R12?
R12 is now for subsequent purchaser from the
And what happened to your preliminary decree?
preliminary decree. It is there at annexure A.
ನಿಮ್ದು suit decree ಆಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ. ನನಗೆ what the court has said is declared that page number 46. Declared that plaintiff is entitled to
Half
get
share.
half share and also plus 1/6 share in half share of father's share. Against 22 to 26 respondents herein.
ಎಲ್ಲಿದೆ ಅದು ಡಿಗ್ರಿ ಎಲ್ಲಿದೆ?
I have produced mail of page number 46. The operative portion of the judgment ending. Annexure A starts from page 30.
FDP ಹಾಕಿಲ್ವಾ ಇನ್ನು?
ಹಾಕಿದೆ. ಅದು ಆದ್ರೆ ಇದರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ the petitioners in the second debt petition, that is my co-sharers,
Yes, sir. Ready, sir? Now who are you?
Lord, I am the eighth respondent.
Yes, sir. What right you got in this property?
Lord, it is my specific case before this honorable court as well as before the revenue authorities that at the instance of my father, my lord, entry which came to be made in the state in the name of Pada had been restored. We made an application, my father, my lord, at an earlier point of time had made an application for restoration because this land, my lord, came to be taken over by the state during the year 1939-40. There is no forfeiture order. Subsequently, my lord, without there being a forfeiture order, revenue records disclosed Sarkari Pada. That had to be restored in the name of the original party. We made an application, got it restored, and thereafter, my lord, in respect of the entire extent of land was not restored. Only 5 acre, 4 guntas of land, my lord, came to be restored in the first instance. Subsequently, my lord, after getting the land restored, revenue records came to be entered in my name. And insofar as
So you are
create-
relying on annexure E, that is held to be a fraudulent document.
My lord,
Go
the
ahead.
deputy commissioner, my lord, at the time of passing the order that.
No,
your
no,
lordship
Tahsildar
can-
statement that I have not passed this order. Author says that she has disowned this order. She says it's not my order.
For a moment, my lord, your lordships could see.
And how deputy commissioner says that it is her order when she has submitted a
My
report.
lord, when he summons the records and sees that
Already, it
everything
requires
is,
consideration. That is, it requires consideration.
that's one aspect.
And there is a partition suit. There is a decree in
My
her
lord,
favor.
there are as many as 4 suits, my lord, filed by various parties, my lord, pending before various courts, including the suit that has been filed by me.
And let the government secure records. We want to know while this mutation was reflected in the RTC, pada anta baribekadre, whose name was reflected in the ownership column anta you secure records.
Thereafter, my lord, the criminal proceedings, they allege that they have taken place against me has been quashed by this honorable court.
No, as against 8 respondent is not quashed, my
No,
lords.
after the, my lord, quashing of the proceedings against other respondents, insofar as the 8th respondent is
Now,
concerned,
according
my
to
lord,
you,
a B report has been filed.
As per annexure E, this land is again restored to you. Is our argument correct?
Please, my lord.
Barcode. The counsel for petitioner, learned counsel appearing for new yaರಿಗೆ ready, sir?
8th respondent.
Respond number 8. And learned SCGP appearing for respondents. Shanti Bhushan, new yaರಿಗೆ?
Please, my lord, I appear in 11.1 for the 6th.
I only I'll permit to withdraw.
Please, my lord, please, then I.
Because they are there in this, my lords, therefore.
ಅದೇ ಎಲ್ಲದಕ್ಕೂ ತಕರಾರು ಮಾಡಬಾರ್ದಾಗಿತ್ತು ನೀವು ಸುಮ್ಮನೆ ಎಲ್ಲ ನಿಮ್ದು ರಿಟ್ಟಿದೆ. ಐ ಸೆಡ್ ದಟ್ ಯೋರ್ ಇಟ್ ಇಸ್ ಮೇಂಟೈನಬಲ್ ಅಂದ್ರೂ ಗಲಾಟೆ ಮಾಡಿದ್ರಿ. ಏನ್ ಬಂದ್ರಿ? So the case on hand raises serious concern in regard to creation of an order which is evidenced at annexure E. While petitioner contends that this petition land is an ancestral property and on account of action of the government, the land was notified as a pada land on account of default of payment of revenue of arrears, respond number 8, placing reliance on order dated 25/1/2020 claims that he got this land restored at the hands of the Tahsildar, jurisdictional Tahsildar Doddaballapur. Petitioner's father, aggrieved by this order, preferred an appeal before the Assistant Commissioner and specifically contended that this order is a fraudulent order and not passed by the authority. It is quite disturbing to note that Tahsildar, the then Tahsildar, who was in charge of Doddaballapur division, subdivision, has also submitted a report indicating that she has not passed this order, evidenced at annexure E. Next, while petitioner asserts that it is her father's ancestral property, respond number 8 is also contending that this property was originally owned by his ancestors and therefore is entitled to seek restoration. Though report was placed before the deputy commissioner overlooking this report submitted by the then Tahsildar has dismissed the revision filed by the petitioners.
Not by
father.
me, by the co-sharers,
Has dismissed the revision filed by petitioners
co-sharers.
brothers.
Right.
Allah.
22 to 26 respondents. They are my father's second wife's.
The stepchildrens of petitioner area who had in fact challenged this order by way of an appeal and revision, by way of an appeal before Assistant Commissioner and a revision before Deputy Commissioner. Next, in the light of conflicting claims, London SCGP is hereby directed to secure the original records and also make a statement as to who was the owner when this land was ordered to be forfeited only by way of a petition. Relevant records at that relevant point of time shall be also furnished, as there are rival claims by petitioner and respond number 8. Next paragraph. Till then, the impugned order dated 25/1/2010 passed by the Tahsildar by annexure E is stayed and parties are hereby directed to maintain status quo in regard to entries in RTC pending consideration of the caption petition. It is open for respondent number 8 and private contesting parties who claim to be the subsequent purchasers to file statement of objection and support their claim. Next. List it in B group after completion of pleadings. Connected writ petition, their petitioner is permitted to withdraw the writ petition.
My lord, service is not yet completed.
ಯಾವ್ದು
Milords,
ready?
First case.
milords, 9 and 11 only,
ಏನು
service milords,
9-11 ಹೋಗ್ಬೇಕಾ?
9 and 11. Respondents 9 and 11 have to be served.
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ತಗೋಬೇಕು.
ಉಳಿದವರೆಲ್ಲ ತಗೊಂಡಿದೀವಿ, they have
ತಗೊಂಡಿದ್ದಾರೆ.
appeared, served.
Issue emergency notice to respond on 9 and
6 and 7, 9 and 11.
6, 7, 9 and 11. We have to be paid during the course of the day. Next.
Appear for the petitioner in this matter, my lord.
Yes, sir.
This, I have challenged the order passed under order 79.
Yes.
Section 79.
Entry order ಕೊಟ್ಟಿದೀವಲ್ಲ?
Interim order has been granted in this matter. Page number 27 is the order. Page number 27, second para, the lordship can see. Finally, it has to be disposed of.
ಎಲ್ಲಿ ಹೇಳ್ತಾರ ಅವರು?
Second para,
ನೋಂದಾಯಿತ ಅಂಚೆ ಮೂಲಕ ಹಾಗೂ ತಹಶೀಲ್ದಾರ್ ಮೂಲಕ ನೋಟಿಸ್ ಕಳುಹಿಸಲಾಗಿದೆ. ನೋಂದಾಯಿತ ಅಂಚೆಯು ಸ್ವೀಕೃತವಾಗಿರೋ ಬಗ್ಗೆ ಮಾಹಿತಿ ಇರುವುದಿಲ್ಲ. ಪ್ರತಿವಾದಿಗಳಾಗಲಿ ಪ್ರತಿವಾದ ಪರ ವಕೀಲರಾಗಲಿ ವಿಚಾರಣೆ ಹಾಜರಾಗಿ ಯಾವುದೇ ದಾಖಲಾತಿಗಳನ್ನು ಪಡಿಸಲು ವಿಫಲ ಆಗಿರುತ್ತಾರೆ.
ಸರ್ವ್ ಆಗಿದೆ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಏನು ಇದೇ ಇಲ್ಲ, ಅಬ್ಸರ್ವೇಷನ್ ಇಲ್ಲ. ನಮ್ಗೆ ನೋಟಿಸ್ ಬಂದಿಲ್ಲ ಆಕ್ಚುಲಿ, ನಮ್ಗೆ ಗೊತ್ತಾಗಿದ್ದೆ ರೀಸೆಂಟ್ ಆಗಿ. ಗೊತ್ತಾದ ಕೂಡಲೇ ಇಮಿಡಿಯೇಟ್ಲಿ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಇಟ್.
Yes, madam. What should happen to this order if it is passed behind the back? It's a non-est order, it goes. Then it falls under 13(2). The act of, ಎಲ್ಲಿದೆ Act 56 of 2020? ಸಿಕ್ತಾ? ಎಲ್ಲಿದೆ ಅದು? ತೋರಿಸಿ. Yes, Mr. Girish.
ಇಲ್ಲ,
ಅದೇ ರೀ 13(2), it was under ordinance ಅಲ್ವಾ?
ಹೌದು.
2020 ordinance. Now it has become an act ಅಲ್ವಾ?
it has become an act.
Then it is incorporated in the act ಇಲ್ಲ?
Act itself, it has been.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ ಅದು? ನೋಡಕ್ ತಯಾರಿಲ್ಲ, ಏನು ನೋಡಕ್ ರೆಡಿ ಇಲ್ಲ.
ಅದು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ಇನ್ಕಾರ್ಪೊರೇಟ್ ಮಾಡಿದ.
ಅದೆಲ್ಲಿದೆ ತೋರಿಸ್ರಿ ಅದು, because it's all interpretation of 13(1) or 13(2). Now we have to say that your case falls into 13(2) and not 13(1). ಕಡೆಗೆ ಆರ್ಡಿನೆನ್ಸ್ ತಗೊಳ್ರಿ ನೋಡ. ಗಿರಿ.
The 79B with the effect from the date of consideration. You know, section 13(1).
ಈಗ ನೋಡಿದ್ದು ಆಕ್ಟ್ ಕೆಳಗಡೆ ಇದು ಸೆಕ್ಷನ್ 12 ಈಗ ಸೇವಿಂಗ್ಸ್ is under section 12. I think section 12 and 13 repeal and savings. ಆ ಸೇವಿಂಗ್ಸ್ ಅಲ್ಲೂ ಬರುತ್ತೆ ನೋಡಿ 13(2) ಕೆಳಗಡೆ ನಾಟ್ ವಿಸ್ಟ್ಯಾಂಡಿಂಗ್ such repeal anything done or any action taken under the principal act as amended by the said ordinance shall be deemed to have been done or taken under the principal act but seem to be done in accordance with law ಇರಬೇಕು. Then only it is saved. If an order of under section 79(a) and (b) is done in gross violation of principles of natural justice, there is no inquiry.
Correct. There is no inquiry.
Nullifying the sale deed is without inquiry. So it is an honest order. So 13(2) is not applicable.
It is
Plus,
not-
it is also not saved under section 12 also. So we have to interpret 12 and 13(2). ಎಲ್ಲಿದೆ ನಿಮ್ದು ಏನು ನೋಡಿಲ್ಲ ತೆಗೆದಿಟ್ಕೊಳ್ಳಿ ಎಲ್ಲದರಲ್ಲೂ ಆರ್ಡಿನೆನ್ಸ್
Crashing, direct ಆಗಿ ಕೇಳಿದೀವಲ್ಲ.
ಅದನ್ನು ಕನ್ವರ್ಟ್ ಮಾಡೋಣ ಕೊಡಿ ಕೇಸಲ್ಲಿ ಗಿರಿ ಅದು ಆರ್ಡಿನೆನ್ಸ್ ಕೊಡಿ 2020 ಆರ್ಡಿನೆನ್ಸ್ ಕೊಡಿ. And this petition ಬರ್ಕೊಡಿ
Repeal and savings.
is by the owner of the land in question assailing the order of the Assistant Commissioner, order of second respondent Assistant Commissioner who has nullified the sale deed obtained by petitioner on the ground that she is not an agriculturist and that her non-agriculture income exceeds the prescribed limit under the original under the principal act. Under the principal act, this order by NHLD is impugned in the caption petition. Next, the inquiry initiated by second respondent Assistant Commissioner invoking section 79(a) and (b) prima facie is found to be fundamentally flawed. And this fundamental flaw is in fact acknowledged by the Assistant Commissioner himself in the course of the order impugned before this court. Para 2 would be relevant. Therefore, this court deems it fit to call out the said relevant paragraph which would have a direct bearing in the light of the 2020 ordinance. In the light of 2020, in the light of Karnataka land reforms bracketed amendment ordinance 2020 and also the ordinance being incorporated under the act under the Karnataka Act number 56 of 2020. Next. While the Karnataka Land Reforms Amendment Ordinance adu hearing after short Ordinance 2000, while the Ordinance 2020 was promulgated, and the sections 79(a), (b), 79, 79(b) and 79(c) were omitted from the Principal Act. While omitting these relevant sections, the section 13 of the 2020 ordinance also saved all those cases which were disposed on or before publication of the ordinance 2020. And also provided and also indicated that cases which were pending on the date of publication of the ordinance 2020 and consequential thereof would abate. Next, this court would deem it fit to cull out the savings provided under ordinance 2020, which reads as under. Next, since this ordinance is now incorporated in the Principal Act under Karnataka Act 56 of 2020, this court deems it fit also to take note of section 12, which are the saving provisions, and section 13, which deal with repeal and savings. Section 12 of Act 56 of 2020 reads as under. Similarly, section 13 of Act 56 of 2020 reads as under. Next, any quasi judicial authority, while holding an inquiry, has to adhere to the principles of fairness and is required to follow procedure provided under the Act or statutes. Under the Principal Act, the Assistant Commissioner was conferred with authority to hold an inquiry in regard to purchase of agricultural lands by ineligible citizens. In the case on hand, the second respondent Assistant Commissioner, acting under section 79A and B, has initiated an inquiry. The least that was expected from second respondent Assistant Commissioner was to hear the petitioner and then pass appropriate orders. The principles of justice, so and so. The culled out portion of the order impugned clearly demonstrates that that petitioner was never notified, and the inquiry was not conducted by providing petitioner an opportunity to substantiate that she was eligible to purchase an agricultural land. Assistant Commissioner, in the course of his order, has acknowledged that that notices will never, that the office has not verified whether notices were served on petitioner. The repeal and saving clause, which is called of the Act 56 of 2020, protects, saves all actions of the Assistant Commissioner done under the Principal Act. Therefore, the order impugned in the present case on hand. Now, therefore, the question before this court is as to whether the order impugned in the present writ petition is sustainable, as it was passed in gross violation of principles of natural justice. Only those actions of the second respondent which are done in a manner known to law are saved under section 13(2). Since the order impugned is in gross violation of principles of natural justice, the impugned order does not get the protection under section 13(2) of Act 56 of 2020. The order impugned also does not fall within 12(1) of the Act 56 of 2020, which provides, which protects all the cases which are finally disposed of before the promulgation of Karnataka Land Reforms Amendment Ordinance 2020. The case finally disposed of means, and has to be necessarily understood, that an inquiry was conducted in a manner known to law and an order is passed adhering to procedural fairness and the mandate provided under the said statute, which was invoked by second respondent assistant commissioner. Even under section 12(1), the order impugned is not sustainable, as the same is passed in gross violation of principles of natural justice. Next, now the effect of a non-honest order is that it does not, that either it falls under 12(1) of Act 56 of 2020, nor it falls under the savings provided under section 13(2) of the Act 56 of 2020. Next, in that view of the matter, only on the ground that the action of second respondent assistant commissioner in nullifying the sale deed, invoking section 17(a) and B, is not sustainable as it is a non-honest order. Therefore, this court is more than satisfied the action undertaken by assistant commissioner under the order impugned is not saved in view of the omission of section 79(a) and B from the Principal Act under the 2020 ordinance. In that view of the matter, the impugned order is liable to be set aside. For the foregoing reason, this court proceeds to pass the following order. Writ petition is allowed. Bench order is hereby quashed and set aside. The Astalva set aside. Folder ಮಾಡಿ ordinance ಇದೆ. ಇದು
But 1939, the land was granted. After the death of my father, it was not extended the RTC. I made an application for the ACS that is the Tahsildar to see that whether the grant is true and also conduct the survey. Tahsildar has conducted the survey and has been put to the AC. AC is only to give a term. It is pending.
It is not for a common. Kindly see the order. The petitions ಕೂಡ ಯಾವುದೇ earlier grant ಆಗಲಿ ಒಂದು ಆರ್ಟಿಸ್ಟ್ ಕೂಡ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. We are searching for the record. It is not for the common. Make submission. Make sure he has the order.
Can I take one line of the observation of the page 15? All the Gurpagadi Kama Suranava Gurpagari, Rupaya, Indirectly, KFT 30 for 1937 38, Inam from the more into 5 Sagodi City, Yedoba, ಮಂಜೂರಾಗಿದ್ದು ಸದರಿಜನ ಕಂದಾಯ ಪಾವತಿಸಲು ಬಾಕಿ ಇದ್ದ ಕಾರಣ ಆದೇಶ ಸಂಖ್ಯೆ 245 ಶೀಲಿಗೆ ದಾಖಲಾಗಿದ್ದು ನಂತರ LMF 58/48/49 ರಿಸ್ಟೋರ್ ಆಗಿದ್ದು only to mutate by names ಇದೆ
My instructions are my lord. Register maintain ಮಾಡಿದ್ರೆ ಅದರಲ್ಲಿ 2 acres 1 acres ಅಂತ ಓವರ್ ರೈಟ್ ಆಗಿದೆ. ಅದು ಬಿಟ್ಬಿಟ್ಟು ಬೇರೆ ಏನು ಕಾಣ್ತಾ ಇಲ್ಲ. ಅದಕ್ಕೆ the petition produced the document which was attached. Another week. My lord. These are all orders, my lord, subject to the securing the records, my lord. These are all orders. Petition. ಅಲ್ಲ ಇವಾಗ ಈಗ 2 ಎಕರೆ ಅರ್ಲಿಯರ್ ರಿಜಿಸ್ಟರ್ ಪ್ರಕಾರ 2 ಎಕರೆ ಅಷ್ಟೇ ಗ್ರಾಂಟ್ ಆಗಿದ್ದು 12 acres ಅಂತ ಓವರ್ ರೈಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. RR ನಂಬರ್ ಅದೆಲ್ಲ weeks may be granted, my lord. Otherwise, my lord, weeks may be granted. I will statement of operations because I received the paragraph.
Report saying that it is only to be restored. Now, that one has to be, to pay our report. As the law clerk.
Single paper ಇಲ್ಲ, grant ಕೂಡ paper ಎಲ್ಲೂ ಸಿಗ್ತಾ ಇಲ್ಲ. RTC petitioner at least ಅವರೊಂದು ಫೋಟೋ ಕಾಪಿ ಕೊಟ್ಟು ನಾವು ಅದ್ರ ಮೇಲೆ ಸರ್ಚ್ ಮಾಡ್ತೀವಿ. ಅಲ್ಲ ಮತ್ತೆ thereafter it was restored back to the government matter. Thereafter it was re-granted with the case of petition. ಅಲ್ಲ ಕೆಲವೇನಾಗಿರುತ್ತೆ
see to maintain the records. Too much of a demand. No. ನೋಡ್ರಿ ಇದು ಏನಿದು SDO MMRS 53C 143/1949-50. ಇದು ರಿಸ್ಟೋರ್ ಆಗಿದೆ ಇದು.
ಆ ಟೈಮ್ ಅಲ್ಲೇ ಅವಾಗ ಏನಾಗಿದೆ ರೀಗ್ರಾಂಟ್ ಆಯ್ತಲ್ಲ ಅವ್ರಿಗೆ 2 acres ರೀಗ್ರಾಂಟ್ ಆಗಿರೋದು ಅವ್ರು 12 acres ಅಂತ ಓವರ್ ರೈಟ್ ಆಗಿದೆ.
ರೀಗ್ರಾಂಟ್ ಅಲ್ಲ, ಅದನ್ನ ಅರಿಯರ್ಸ್ ಲ್ಯಾಂಡ್ ರೆವೆನ್ಯೂ ಕಟ್ಟಿಲ್ಲ ಅಂತ ಅವರು ಪಡ ಅಂತ ಮಾಡಿದಿರೋದು, ಅದನ್ನ ರಿಸ್ಟೋರ್ ಮಾಡಿದ್ದಾರೆ. ದೇರ್ ಇಸ್ ದಿ ಮ್ಯಾಟರ್.
2 acres ಅಂತ ಇದು ಅಂತ ಡೌಟ್
You can't.
ಸ್ಟೇಟ್ಮೆಂಟ್
ಯಾಕ್ರಿ ಇದ್ರಲ್ಲ ಪ್ರೈವೇಟ್ ಇಂಡಿವಿಜುವಲ್ಗೆ ಯಾವ ಊರಲ್ಲಿ ಇದೆ ಇದು ಲ್ಯಾಂಡ್? ಆಯ್ತು, ಇದು ಬೆಂಗಳೂರಲ್ಲ. ಬೆಂಗಳೂರು ಇದ್ರೆ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. Somehow you want to get over all these grant orders. ಸ್ವಲ್ಪ ಕಾರಣ ಸಿಕ್ಕರು you want to lay a claim. That is not correct. If fraudulent ಇದೆ ಅದನ್ನ ನೀವು take action. Sir, in 1938, do you expect an agriculturist to maintain these records? ಹೇಗ್ ಮಾಡ್ತಾರ್ರಿ? ಯಾರು ಮಾಡ್ತಾರ್ರಿ? ಯಾರ ಹತ್ರ ಇರೋದು? 1938 ಆಗಿರುತ್ತೆ.
ಟ್ಯಾಕ್ಸ್ ಕಟ್ಟಿರೋದು ಅದು ರೆಸಿಪ್ಟ್ ಕೂಡ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ ಆಮೇಲೆ
Alright, ಇದು ಪಾಠಡ್ ಅಂತ ತಗೊಂಡಿದೀವಾ? Matter is treated as partnered. Leave this matter on. Let them find what they want. Next. Yes, sir. ಏನು ಖಾತಾ ಚೇಂಜ್ ಮಾಡ್ತಾ ಇಲ್ವಾ? What is the date of grant? ಇದು ಫ್ರೆಶ್ ಇದೆ ನೋಡಿ, ಇದರಲ್ಲೂ ಡೌಟಾ?
24 ಗ್ರಾಂಟ್ ಫಸ್ಟ್ ಟೈಮ್ ಇಟ್ ಇಸ್ ಲಿಸ್ಟಿಂಗ್ ಮಾಡಿದ್ರೆ ಟೇಕ್ ಮಾಡಿ.
Will dispose of. Alright, you take, please instruct them to act on this petition is filed.
2724.
Order sheet will ಬರ್ಕೊಡ್ರಿ. Leonard SCGP accepts notice to respondents. Next, in the caption petition, mandamus is sought against respondent. Both respondent Tahsildar to mutate petitioner's name based on official memorandum dated 27/6/2024 and consequential Sagolu check dated 10/7/2024. Next, petitioner moved an application seeking regularization of unauthorized portion of the land, unauthorized moved an application asserting that he is in unauthorized occupation of land bearing survey number 33. His application was referred to the committee. Committee, after securing reports at the hands of Tahsildar after due inquiry, recommended to regularize petitioner's unauthorized occupation to an extent of 1 acre 17 guntas.
Second time also the grant. Total is 2 acres 34.
To an extent of
1 acre 17.
yeah, total ಹೇಳಿದ್ರಲ್ರಿ.
Total survey number is 2 acres 34. First it has been regularized, then entry is there. So name in 1 acre 17. Second grant is still showing Sarkari fees. Second grant, second regular.
ಇನ್ನೊಂದೇ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಕೊತೀರಿ ನೀವು?
Not special.
ಏನ್ರಿ ಹಿಂಗ ಮಾಡ್ತಾ ಹೋಗ್ತೀರಾ? ಅದೆಲ್ಲ ಲ್ಯಾಂಡ್ಲೆಸ್ ಪೀಪಲ್ ಕೊಡೋದು. ಇದು ಸೆಕೆಂಡ್ ಗ್ರಾಂಟ್ ಇದು. ಇಲ್ಲಿ ಯಾರು ಹೇಳೋರಿಲ್ಲ. Your officers are thoroughly corrupt, I'll tell you. How it fits into landless person category once there is a grant? ಇದು ಸೆಕೆಂಡ್ ಹೇಳ್ರಿ, ಈಗ ಸೆಕೆಂಡ್ ಮಾಡ್ಬೇಕಾ? What is the extent? To an extent of 1 acre 17 guntas. Petitioner alleges inaction on the part of fourth respondent Tahsildar in not executing the change of khata based on these two documents. Original of the records this court has noticed that petitioner applied for regularization of 1 acre 17 gutas. Committee has considered and issued an official memorandum on 27/6/2024. Tahsildar acting on this recommendation / official memorandum has issued Sagolichit, which is evidence that annexure B1, B2, B2, not better. Since there is next, petitioner has acquired a legal right to seek change of khata based on these two documents. Equally, fourth respondent is obligated to effect change of khata by taking cognizance of the official memorandum wide annexure B1 na, and consequent Sagolichit issued by Tahsildar wide annexure B2. Since there is inaction, this is a fit case for a mandamus slice. The petition is allowed. The respondents are hereby directed to take note of official memorandum dated so as per annexure B1 and consequent Sagolichit issued wide annexure B2 and execute change of khata in favor of petitioner in the RTC pertaining to petition land. Next, this exercise shall be accomplished within a period of 3 months. Manjunath, what is this? 2024 ಅಲ್ಲಿ additional land ಕೊಡ್ತಾ ಇದೀರಾ ನೋಡಿ. ಇದನ್ನ ನೀವು note ಮಾಡ್ಕೊಂಡು apply. What is it? You can't go on permit adding it. They are enhancing their extent. ಆಯ್ತು ತಗೊಂಡ್ಬಿಡಿ ಹಂಗೆ ಅಲ್ಲ ಇನ್ನು ಹೋಗಿ ಮತ್ತೆ ಅಪ್ಲೈ ಮಾಡಿ ಕೊಡ್ತಾರ ಅವ್ರು. ನೆಕ್ಸ್ಟ್
Lord, in this matter, my lords had appointed K. Nitish, my lord, to assist the court with respect to
correct,
Lavani sketch. Please, my lord, if I may submit, my lord, there are 3 memorandums, my lord, which would be helpful for the purpose of
tomorrow.
decreeing. Please, they are not in our, we are not able to locate those memorandums. My lord. May I direct the government.
I should. What
Please,
is the
I'll
details?
issue.
Try to see.
Please. Grateful.
Yes, Mr. Await notice. Await notice. There is an undertaking, all right. Undertaking given by the state stands extended after 3. Huh? 16 undertaking is extended. Oh, ಇದು await ಅಲ್ಲ ಇದು ಯಾಕೆ?
So their applications are rejected, my lord. I will file statement of objection, my lord.
Reject ಆಗಿದೆಯಾ?
Protection by the Sanabha court, my lord, not to destroy the crops. I will file statement of objection for 2 weeks time.
List it in B group. Interim order granted rally is extended till next date. Order date. 17, await. I list it in B group ಅಂತ ಹಾಕ್ಬಿಟ್ಟು.
ಇದು ನಾಳೆಗೆ
ನಾಳೆಗೆನಾ? All right, tomorrow. Notice ತಗೋಬೇಕಾ ನೀವು ತಗೊಂಡಿದ್ದೀವಿ.
ತಗೊಂಡಿ
ನಾಳೆ. Next. Yes, Somshikar.
Only issuance of RTC, but news.
40 is also concluded. They have to generate RTC now in terms of 40.
This is totally a fraudulent grant, my lord. I have received some information saying that the very bare going through of annexure A itself says that it is a fraudulent grant.
I have to place it on paper.
I will file my detailed statement out.
List it in B group. Next. ಇನ್ನೀಗ ಕಂಪ್ಯೂಟರೈಸ್ಡ್ RTC ದಲ್ಲಿ ಬರ್ತಾ ಇಲ್ವಾ? Yes, madam.
My lord, this is already, it has been, land has been given to some different person. I think this OS is pending before these parties, my lord. That's why there is no grant records at all. He has not been granted with land. This particular land has been already be given to some other person.
You place on record, then you place on record all.
I will write later.
List it in B group, the learned AGA to file statement of objection within 4 weeks, list it in B group. Next. 21. ಹೌದಾ? Next Monday, yes, at the request of council.
ಭೂದಾನ ಅಂತ ಆಗಿದೆ, ಅವ್ರೇನೋ.
Audit. Next. Yes, sir, Ariga, sir. A land reform, sir. Who are you, tenant or landlord? You are the owner. ಇದೇನಿದು ರಿವ್ಯೂ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? Tahsildar can?
To represent the deceased because he has not left any legal representative.
ಅಲ್ಲ, ಈಗ ರಿವ್ಯೂ whether it should go before the same.
It need not be.
ಯಾಕೆ? Because though you have filed an independent writ petition, because you are not a party, it appears.
Yes, it's a legal representative.
Then it has to go before the same judge. Ariga, sir.
A separate writ petition seeking review of that order is maintainable.
Maintainable. But you should go before the same judge.
The property was sold. The owner's legal
Allah,
representative.
let it be list, because I should ನೋಡಿ ಇದು ರಿವ್ಯೂ ಹಾಕಿದಾರೆ ಎಲ್ಲಾರು ಪಾಪ ಅವ್ರ ಮುಂದೆ ಹೋಗ್ಬೇಕಲ್ಲ, ಬರ್ಕೊಡ್ರಿ. Though petitioner has maintained an independent writ petition on the ground that they are the legal heirs of original petitioner, original respondents, petitioners are in fact seeking review of the order, and therefore this court is of the view that registry has to place this writ petition before the roster judge who has decided the writ petition which is now subjected to review. Registry to since urgent orders are sought in the petition, registry shall ensure that the matter is posted before the roster judge after securing necessary orders. Next. 23. ಏನ್ ರಿಲೀಫ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ಮ್ಯಾಂಡಮಸ್ ಯಾರು ನೋಟಿಸ್ ತಗೋತೀರಿ? ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆನ್ಸ್ ಇದಾರಾ? Audit. Audit 1 and 2 government issue emergency notice to respondents 3 to 8. Yes, next.
As per the grant order, my lord, OM made in the year 1982, 14/6/1982, annexure F, page number 22.
ಯಾರು ತಗೋತೀರಾ ನೋಟಿಸ್? ಹೌದಾ? Learned SCGP
At the time of-
notice to respondents, council, petitioners council shall serve an additional set of writ papers on learned SCGP. Yes, next. Yes, sir.
Seeking mandamus as per annexure L, page number 53 and 54, my.
ಏನ್ mandamus? What is the prayer?
See, the Tahsildar have disputed our boundaries as per sale deed dated as per annexure E and D, sir. Boundaries dispute ಮಾಡ್ತಿದ್ದಾರೆ. This properties comes under the forest land ಅಂತ ಬರ್ತಿದ್ದಾರೆ, sir. In this regard,
Yes, seek section, madam. ಇದು ಯಾರು ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನೀವೇ ಅಲ್ವಾ?
third respondent, no, sir.
ಎಲ್ರಿಗೂ ನೀವೇ. Leonard AG, accept notice to respondents. Yes,
I have it.
next. 26.
Yes, seeking for a mandamus on the basis to mutate the name in the RTC. Is a order we have made representation to DC. DC passes an order to mutate the name.
Does he hold an inquiry or he just
No,
recommends?
he gives an order directing Tahsildar to mutate the name. Subsequently, my lord,
So what provision is given a direction?
we just make a representation to DC saying that Tahsildar has not passed an order, made the mutation.
Now you are seeking change of khata based on what document?
Release date, my lord.
Registered release date?
Registered release date.
Yes, sir.
My lord, there is one more, my lord. There is a, subsequently, my lord, we make a appeal before AC. AC passes a inquiry order, my lord, asking him to mutate the name within 5 days. He does not do that, my lord. Even after the order being passed by AC and direction being given by DC. Page number 40 is the order of the DC.
What is the date of release date?
In 22, my lord, the date of release date.
ಈಗ ಆ ತಹಸೀಲ್ದಾರ್ ಇರಲ್ಲ ಇವಾಗ ಆಕ್ಷನ್ ತಗೋಬೇಕಂದ್ರೆ
ಹೌದು.
will be transferred somewhere. Madam, you check out.
Lord,
Ah?
instead of making application to the proper authority, they are going to higher officials. ಲೋಕಾಯುಕ್ತ ಹೋಗ್ತಾರೆ, DC ಗೆ ಹೋಗ್ತಾರೆ, AC ಗೆ ಹೋಗ್ತಾರೆ.
ಯಾಕ್
And ಬಂದು
ಹೋಗ್ತಾರೆ?
ಒಂದು application ಕೊಡಿ ಅಂದ್ರೆ they are not forthcoming before the
We have made application,
There-
my lord. There is an order
Sir-
passed by AC, my lord, asking them to mutate the name.
ಒಂದು application ಕೊಡಿ.
Page number 40 is the order.
According to that we will do ಅಂತ. It is under process, man. Anyhow, it is under process.
You tell me what
It
is
is not approaching the appropriate authority, my lord.
ಯಾಕೆ ಬರ್ಬೇಕು ಈಗ ಜೆ ಫಾರ್ಮ್ ನಿಮ್ಗೆ ಬರೋದಿಲ್ವಾ ಈಗ ನಿಂತು
ಅವಾಗ ಇಲ್ಲ ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಹಳೇದಿದು.
My lord, there is a,
ಜೆ ಫಾರ್ಮ್ ಇದೆ.
ಜೆ ಫಾರ್ಮ್ ಇರಲ್ವಾ? ಜೆ ಫಾರ್ಮ್ ಇದೆಯೋ ಇಲ್ಲೋ?
Yes, my lord.
ಮತ್ತೆ ಯಾಕೆ why want an application
my
from?
lord, the main contention before the AC is J form has been not received by them. I make an application to registrar, my lord, whether J form has sent to them or not. Registrar confirms that as on the date of executing a registered release
madam,
date,
you
J
tell
form
me.
is sent.
Why
Yes,
I
we
should
will-
not take? No,
It is
no.
under process,
You
my
tell me
lord.
what
Now,
is the date of release date? ಇದೆಲ್ಲ ಈ
September-
ತರ ಆಗಲ್ಲ ಇದು.
September 2022, my lord.
2022, madam.
yes, 23 ನಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈಗ ಅದನ್ನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವರಿಂದ ಒಂದು NOC ಬೇಕಾಗಿತ್ತು, ಅದನ್ನ ಕೊಡಿ ಅಂದ್ರೆ ಕೊಡ್ಲಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ನಾವು
You tell me then J form has become redundant. ಅದಕ್ಕೇನು ಇಂಪಾರ್ಟೆನ್ಸ್ ಇಲ್ವಾ ಈಗ ಜೆ ಫಾರ್ಮ್ ಗೆ? ಯಾಕೆ ಪ್ರೈವೇಟ್ ಪಾರ್ಟೀಸ್ ಯಾಕೆ ಬರ್ಬೇಕ್ರಿ ನಿಮ್ಮ ಹತ್ರ?
ಮಾಡ್ಬೇಕು.
ಮತ್ತೆ
Based on the-
you tell me who is this ತಹಶೀಲ್ದಾರ್ 2022 ದಿಂದ ಯಾರಿದ್ರು ನೋಡಿ?
Now
This
they
is
are
not that,
making,
madam.
I
This is not.
told that another 1 week or
You know why I should pass an order? Why you should approach High Court?
some fault is also on the part of.
No,
the-
you seek, no. You seek explanation from the Tashildar.
Yes, ma'am.
And tell him or her that 10,000 cost.
I'll ask him to file explanation. First, I will ask him to file explanation.
First ask
Why
when he has taken charge,
Yes, ma'am.
ಅವ್ರಕ್ಕಿಂತ ಮುಂಚೆ ಯಾರಿದ್ರು ಡೀಟೇಲ್ ಬೇಕು ನನಗೆ. And they are going to pay cost now. ನಾಳೆಗೆ, tomorrow will pass orders.
Please, ma'am.
Not Monday.
There is a clear inaction on the part of fourth respondent Tashildar in not acting based on a registered release deed obtained by petitioner. The records also reveal that fourth respondent Tashildar is not even ready to comply the directives issued by deputy commissioner and third respondent. Therefore, this is a fit case to impose exemplary cost on fourth respondent Tashildar and also recommend to hold an inquiry against fourth respondent to secure explanation day after tomorrow
My lord, Monday, my lord,
in preliminary.
Monday.
ಬುಧವಾರ
Like
ಬುಧವಾರ
this
phone
Sunday,
ಮಾಡಿ.
ಅಲ್ಲಿಂದ ಬರ್ಬೇಕಾಗುತ್ತೆ.
ಬರ್ಲಿ let him.
Right.
ಬುಧವಾರ.
Much obliged.
Seeking writ of mandamus, my lords. My lords, basically this land was originally cultivated by my grandfather, Dodwaplappa. His name has been shown in the Index of Land Record of Rights. ಇದರಲ್ಲಿ ಸಾಗುವಳಿಯಿಂದ ಅನುಭವ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ. However, he did not mutate his record, all the records in his name.
Take notice. Yes, SCGP accept notice to respondents. Next. Yes, Pasha.
Lord, sought for writ of mandamus, Lord, made an application for conducting Podi and Durasti. But that application is pending.
You know, granted land,
Granted land.
2005, my lord.
Lord,
On 13/3/2024, madam, I will take the step.
ಟೈಮ್ ಕೊಟ್ರೆ ಸಾಕು, ಒಂದು 6 months ಅಲ್ಲಿ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ, in Lord adjacent line owners, Lord, in a same grants, your lordship passed an order, Lord, and within 4 weeks to do it. There are 5 applications have been filed under 136,
ಅಲ್ಲ ಸರ್ವೆ ನಾವು 4 ವಾರ ಟೈಮ್ ಕೊಡಿ.
survey number 1.
ಅದು 4 months ಇರ್ಬೇಕ್ರಿ, ಅದು 4 weeks ಆಗಿದೆ ನೋಡಿ. ಅಲ್ಲ ಸರ್ವೆಗೆ ಟೈಮ್ ಬೇಕಾಗತ್ತೆ ಅವ್ರು. ಪಾಷಾ
Please, Lord. ಇಲ್ಲ 4 weeks ಹೇಳಿದಿರ ಸ್ವಾಮಿ.
ತಪ್ಪದು.
ಆಯ್ತು.
ಸೇಮ್ ಸರ್ವೆ ನಂಬರಾ?
ಹೌದು, ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್. Because process has already started, Lord, it is ತಹಸೀಲ್ದಾರ್ ಆಫೀಸ್ಗೆ ಹೋಗ್ಬಿಟ್ಟು ಮಹಾಜರ್ ಎಲ್ಲ ಆಗಿದೆ.
ಓ ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
8 ವಾರ
1 to 10 ಅಂತ ಆಗಿದೆ.
ಅದ್ರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್ದಲ್ಲಿ ಕೊಡಿ ನೋಡು. ಅಲ್ಲಿ ಕೊಡಿ ಕೊಡ್ತೀನಿ.
35. 136.
Paragraph 4 weeks. 8 weeks time will be granted.
ಕರೆಕ್ಟ್ ಮಾಡಿ, ಇದೆಲ್ಲ ಮಾಡ್ತೀರಾ? ಕಾಸ್ಟ್ ಹಾಕಿದ್ದೇನೆ ಡಿಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ನೀವು. ಕೊಡ್ರಿ. This petition is filed seeking a mandamus against third respondent Tahsildar to process petitioner's reimputation dated 13/3/2024 and conduct Fodian Durasti insofar as petitioner's land bearing survey number 136/4 measuring
ಕಡೆಯಮ್ಮಿಗೆ ವಿಲೇಜ್ ಕೆಕ್ಕೆರೆ ಹೋಗಿ
Inam.
1 acre.
Measuring 1 acre. Next, at the counsel for petitioner and learned CGP, petitioner's counsel has placed reliance on the orders passed by this court, where similar directions are issued to Tahsildar to accomplish the 4D work within a period of 4 weeks in the very same survey number. Next, having taken cognizance of the mandamus issued to the Tahsildar in respect of similarly placed grantees in the same survey number, this court is of the view that this is a fit case where the mandamus lies on parity. The petition is accordingly allowed. Third respondent Tahsildar is hereby directed to accomplish Fodian Durasti insofar as petitioner's land measuring 1 acre in 136/4 situated at so and so within a period of 8 weeks. Next.
But this matter, my lord, for 2 weeks time for this reason, my lord, the petitioners was granted land of 10 guntas, my lord.
Like 2 weeks, huh? You want to file statement?
We are finding the alternative land for the petition, my lord. 2 weeks time will be granted, my lord. Survey report ಎಲ್ಲ ತಗೊಂಡು
ಮಾಡ್ತೀರಾ?
Yes, ma'am. It was for the consideration of interim prayer. I may not be dispossessed till then.
we have intimated.
Learned SCGP on instruction submits that authorities are accomplishing the prayer sought in the petition.
Giving the alternative land.
Huh?
Giving the alternative land.
Ade, prayer under the garb of however, under the garb of providing an alternate land, petitioner should not be dispossessed. Pending consideration of the caption petition, at the request of SCGP, release this matter in preliminary hearing on so and so. 2 ವಾರ ಆದ್ಮೇಲೆ ಕೊಡಿ. Next.
Petitioners are brothers. But in the year 1971, nearly about 25 acres of land was acquired for constructions of the Arangi Dam, and no award was passed. Final notification in the year 1971. After 50 years of legal battle, in 2021, the compensation was awarded in the orders as per the orders of this honorable court, 2021, in MFA number. I have produced it at annexure C, page 21.
ಆಯ್ತು, ಏನಿದು
I have made the application for rehabilitation of the land, alternative land.
taken section?
They are not
And
at
for
all
which
entitled. We have already given an endorsement saying
That-
that ಅವ್ರು ಏನ್ ಕೇಳಿದ್ದಾರೆ, they are, first of all, they are not entitled for alternative grant because they have taken award amount.
Scheme ಇಲ್ಲ.
Whether
Scheme ಅಲ್ಲಿ ಇಲ್ಲ.
land ಕೊಡ್ಬೇಕು ಅಂತ ಎಲ್ಲೂ scheme
Alternate
ಇಲ್ಲ.
land and scheme ಇಲ್ಲ.
Their grievances is that I have received less compensation, so please grant me alternative. There is no scheme under the government.
We have fight for 50 years for taking that lump sum amount of
It's agreed by the less amount, they could have preferred appeal, my lord.
But they have stated only the Ilizar Pradesh ಆಗಿರೋದು ನಮ್ಗೆ we are not eligible ಇಲ್ಲ ಅಂತ
Sir,
ಕೊಡ್ತಾರೆ.
alternate land scheme ಇರ್ಬೇಕು.
Scheme.
ಅಲ್ಲ ಆಲ್ಟರ್ನೇಟಿವ್ ಸ್ಕೀಮ್ ಇದೆ ರಿಹಾಬಿಲಿಟೇಷನ್
Land ಇಲ್ಲಾಂದ್ರೆ ಒಂದು ಸೈಟ್ ಡಿಪೆಂಡಿಂಗ್
ರಿಹಾಬಿಲಿಟೇಷನ್ ಈಗ ಪೂರ್ತಿ
ಬರಲ್ಲ. ಸ್ಕೀಮ್ ಇರಲಿಲ್ಲ, ಅಕ್ವೈರ್ ಮಾಡಿದ್ದಾರೆ, ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ,
Is on the lower side, you challenge it. Seek enhancement.
ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ರು 14,250 ಹಂಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈಗ 2024ರಲ್ಲಿ
ಯಾವಾಗ ಅಕ್ವೈರ್ ಆಗಿದ್ದದು?
71 ನಲ್ಲಿ
ಸ್ಟೇಲ್ ಕೇಸ್ ಇದು. ನಾಗರಾಜ್
71 ನಲ್ಲಿ no award is passed. I have struggled for more than 50 years for getting that compensation.
ಅಡಿಷನಲ್ ಡ್ಯಾಮೇಜಸ್ ಕೇಳ್ರಿ, ಸೂಟ್ ಹಾಕಿ ಡ್ಯಾಮೇಜಸ್ ಕೇಳ್ರಿ. ಆಲ್ಟರ್ನೇಟ್ ಲ್ಯಾಂಡ್ ಬರಲ್ಲ.
ಅಲ್ಲ ಆಲ್ಟರ್ನೇಟಿವ್ ಸ್ಕೀಮ್ ಇದೆ ಅದರಲ್ಲಿ. ನಾನು ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಸ್ಕೀಮ್.
ಬರಲ್ಲ ಅಲ್ಲಲ್ಲ, ಆ ಅಕ್ವಿಸಿಷನ್ ದಲ್ಲೇ ಸ್ಕೀಮ್ ಇರಬೇಕು.
ಅದೇ ಅಕ್ವಿಷನ್ ಅಲ್ಲಿ ಇದೆ ರಿಹಾಬಿಲಿಟೇಷನ್ಗೆ.
ನೋ ಸಚ್ ಸ್ಕೀಮ್ ಇದ್ರೆ ಎಷ್ಟೊತ್ತಿಗೆ ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಿದ್ರಿ?
ಒಂದ್ ವಾರ ಟೈಮ್ ಕೊಡಿ.
ಬರಲ್ರಿ, ಮತ್ತೆ ಪದೇ ಪದೇ ಬೇಡ.
ಅಲ್ಲ ಬೈ ದಟ್ ಟೈಮ್ ಐ ವಿಲ್
ಡಿಕ್ರಿ ನೀವು ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ಹಾಕಿ ನೋಡೋಣ. ಇರ್ಬೇಕು ಆ ತರ ಸ್ಕೀಮ್ ಇರ್ಬೇಕು. ಬರ್ಕೊಡ್ರಿ. ಆ ಪೆಟಿಷನರ್ ಇಸ್ ಅಸೆಲಿಂಗ್ ದ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ issued by fourth respondent. Evidence that annexure A and A1, where it is that claims to be a displaced person. Wherein? Wherein Tahsildar has declined to entertain the representation submitted by petitioner seeking alternate land on the ground that petitioner is a displaced person. Assailing the endorsement, the caption petition is filed. Consequent mandamus is also sought against Deputy Commissioner to consider petitioner's representation dated 9/6/2023. Next. At the council. ಇದೇನ್ LSC ಇದೇನ್ ಹಾಕಿದ್ದೀರಾ?
ಜಲೇಶಿದು MFA ಆರ್ಡರ್ ಸರ್. ಕಂಪೆನ್ಸೇಷನ್
ಎನ್ಹಾನ್ಸ್ ಆಗಿದೆಯಲ್ಲ?
ಎನ್ಹಾನ್ಸ್ ಅಂತಂದ್ರೆ 14,000.
The records reveal that petitioners lands were acquired in terms of preliminary notification dated 15/4/1971. Petitioners lands were acquired by the state for the purpose of construction of Arangi Reservoir. Petitioner feeling aggrieved by inadequate compensation determined by the special land acquisition officer sought reference. An appeal is also filed before this court in MFA 967/2016. Next, having exercised the recourse available to petitioner, this court is of the view that petitioner cannot seek a mandamus at the hands of this court. Equally, the state is not obligated to provide an alternate land in lieu of acquisition of petitioner's land way back in 1971. The representation submitted by petitioner appears to be an afterthought. If petitioner is aggrieved by the compensation determined by this court, he is required to pursue remedy in the manner known to law. Mainly because his lands were acquired at a lesser price will not give rise to a right to seek alternate land. No such scheme is indicated. No such scheme is produced before this court, indicating that while acquiring petitioner's land, the government had floated a scheme of allotting alternate land. In that way of the matter, this court is not inclined to grant any indulgence. The petition will give up not to defend. Next.
But I appear for the petitioner. In this case, my lord, the petitioner was made the application for regularization of unauthorized cultivation. My lord, the same was rejected by its order dated 26/3/2002. And I have prepared the appeal before the Assistant Commissioner, my lord, annexure A1, page 13, my lord.
ಈಗ ರಿಮಾಂಡ್ ಆಗಿದೆ ಅವ್ರು ಮಾಡ್ತಾ ಇಲ್ವಾ ಎಂಕ್ವೈರಿನ ಮಾಡ್ತಾ
ಅವರು ರಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ದಾರೆ, ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಸೆಟಸ್
ಮಾಡ್ತಾರೆ.
ಮಾಡಿದ್ದಾರೆ, ಅವ್ರು ಮಾಡಿಲ್ಲ. ತಿರ್ಗಾ ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅನೆಕ್ಷರ್ಗೆ.
ಎಸ್ ಮೇಡಮ್.
Some litigations ಆಗಿ records ಎಲ್ಲ ಏನೋ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗಿದೆ ಅಂತ they are seeking some more time to consider.
ಮಾಡಿ ಬಟ್ ಅದು ಸೆಕ್ಯೂರ್ ಮಾಡಿ ಎಕ್ಸ್ಪೈರೇಟ್ ಮಾಡ್ಬೇಕು.
ಇಲ್ಲ
ಈಗ
ಹೇಳಿದ್ದಾರೆ.
ಯಾವಾಗ ರಿಮಾಂಡ್ ಆಗಿದೆ ನೋಡಿ.
ಇದು ರಿಮ್ಯಾಂಡೆಡ್ ಆನ್
2001 ರಿಮಾಂಡ್ ಆಗಿರೋದು ಯಾವಾಗ ಸರ್?
2004 ಅಲ್ಲಿ.
2004 ರಿಮಾಂಡ್ ಮೇಡಮ್.
Yes,
18/12/2004.
ಬರ್ಕೊಡ್ರಿ. ಇದು ರಿಮಾಂಡ್ ಟು ದಿ ಕಮಿಟಿನೋ ತಹಶೀಲ್ದಾರ್ಗೆ? ಕಮಿಟಿಗೆ ಹೋಗ್ಬೇಕಲ್ಲ ಇದು?
ಕಮಿಟಿಗೆ ಹೋಗ್ಬೇಕು.
ಕಮಿಟಿ
ನೋಡಿ ಅಲ್ಲ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಓದಿ ಯಾರಿಗೆ ರಿಮಾಂಡ್ ಆಗಿದೆ.
ಈ ಮೇಲ್ಕಂಡ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾಖಲಾಗಿರುವ ಮೇಲ್ಮನವಿದಾರಗಳ ಸಕ್ರಮ ಕೋರಿ ಸಲ್ಲಿಸಲಾಗಿದೆ ಇವರು ಮಂಜೂರಾತಿ ಅರ್ಜಿ ಸಂಬಂಧದಲ್ಲಿ 97
ಕಮಿಟಿ
ತಾಲೂಕು ಅಕ್ರಮ ಸಕ್ರಮ ಸ್ಥಿತಿ ವಜಾಗೊಳಿಸುವ ದಿಶೆಯಲ್ಲಿ ಕೈಗೊಂಡಿರುವ ನಿರ್ಣಯವನ್ನು ರದ್ದುಪಡಿಸಿರುವುದಲ್ಲದೆ
ಕಮಿಟಿಗೆ
ಇದೆ.
ಕಮಿಟಿನೇ ಆಯ್ತು ಬರ್ಕೊಡ್ರಿ. Petitioner in the caption petition is aggrieved by the inaction on the part of fourth respondent land grant committee in not deciding petitioner's claim for regularization afresh in terms of the directives issued by Assistant Commissioner while disposing of the appeal filed by petitioner, which is evidenced at annexure A1. Next, by the counsel for petitioner and learned AG appearing for respondents. You notice ತಗೊಂಡಿಲ್ಲ madam ಇನ್ನು?
ಇಲ್ಲ ಇವತ್ತೇ ಬಂದಿದೆ.
Madam, order sheet ಅಲ್ಲಿ learned AG is directed to accept notice to respondents. Next, perusal of the on review of the writ papers, it's clearly evident that petitioner's application filed in prescribed form is pending consideration before the land grant committee. Though petitioner's application was declined by the committee on earlier occasion, the Assistant Commissioner on an appeal filed by petitioner has set aside the earlier recommendations declining to regularize petitioner's unauthorized occupation. Assistant Commissioner has remitted the matter for fresh consideration. This order is dated 18/12/2004. Next, case on hand clearly reflects complete laxness on the part of LAX, NESS, on the part of fourth respondent committee in not deciding petitioner's claim seeking regularization. This is a fit case where a mandamus lies. Next, if petition is allowed, fourth respondent is hereby directed to reconsider petitioner's claim for regularization, strictly adhering to the directives issued by Assistant Commissioner evidence at annexure A1.
With a rider ಮೇಲೆ overlap ಆಗಿದೆ ಅಂತ observation.
ಅದು ನೋಡಿ.
With a rider.
This exercise shall be accomplished within a period of 3 months from the date of receipt of order.
I appear for petitioner's counsel. He has got personal inconvenience. ಅವ್ರ ಮಗಂದು ಮದುವೆ ಇದೆ.
ಯಾವಾಗ
ನಿನ್ನೆ ಮದುವೆ ಆಗಿದೆ. Next week. 32, 33 and 35.
Audit.
3 matters.
33 and 35. Next Monday.
Next month.
Yes. Yes.
I appeal for the petitioner. I'm just seeking a writ of mandamus to consider my representation. Now, what had happened in survey number 120 of Lakere village was that there was a grant made with respect to 4 acres out of 41 acres. Back in the year 2008, the grantee sold it to the private individual. Layout was formed. A PIL was filed stating that there is some unauthorized occupation by the new owner. The Tahsildar undertook it and the PIL was disposed of back in the year 2011, saying that a survey sketch will be prepared to see if there is any unauthorized occupation and then action will be taken, my lords. Many years have passed. 2023, a report was submitted. At that time, the survey number came within the limits of BBMP. Tahsildar directed the revenue authorities to reconduct the survey with the presence of BBMP
You are
officials.
the purchaser now.
Now we are just a sangha of all the residents that are there in that survey number.
Second section. Learned SCGP accept notice to respondents. He shall secure instructions by next date of hearing. Relive this matter and preliminary on so and so date. Please, great.
335 also same,
ಯಾವುದು?
32.
36. Yes,
But petitioners 1 to 3, they have made an application, form 53 for regularization of the unauthorized cultivation. But 4 to 9, 57 has been filed. Lord, in the earlier occasion, Lord, the Tahsildar rejected the applications filed by the petitioners on the ground that, Lord, their lands come within the 5 kilometers of, Lord, the municipal area. That has called in question before the Honorable Court. The Honorable Court direct, Lord, has passed an order that quashing the endorsement issued by Tahsildar and directed Tahsildar to go and inquire about the, Lord, the hold an inquiry. Lord, those
Fresh matter.
Yes,
fresh matter, but the Lordship and annexure, yes, page 54, my lord. Those endorsements have been passed by the Honorable Court and directed Tahsildar,
ಇಲ್ಲಿ page.
page 54, my lord. ಆಮೇಲೆ ಇದರಲ್ಲಿ 54. There are 3 petitioners and, my lord, annexure, yes, sir, 54. 59, my lord, is another petition. There are 4 petitioners. Actually, my lord, it comes more than 6 kilometers.
there is some hitch on the measuring points ಎಲ್ಲಿಂದ ತಗೋಬೇಕು ಅನ್ನೋದು ಸ್ವಲ್ಪ ಹೆಚ್ಚಿದೆ ಅಂತ ಅದಕ್ಕೋಸ್ಕರ they are seeking some more time.
Was specifically passed an order that quashed the endorsement. Directed Tahsildar to hold an inquiry.
Again, it has been
Till today, he has not hold an inquiry. By that time, not the,
ಯಾಕ್ರಿ ಅದೇನು ಪಾಯಿಂಟ್ ಸೆಂಟರ್ ಅದು ಅದಕ್ಕೆ ಎಷ್ಟು ಟೈಮ್ ಬೇಕಾಗುತ್ತೆ?
ಅದೇನೋ
2
ಹೇಳಿದ
ವರ್ಷ ಬೇಕಾ?
ಅಲ್ಲ ಅದ ಏನೋ ಹೇಳಿದ ನಂಗೆ
ಬೇರೆ ಏನ್ that is the endorsement issued.
ಸರ್ವೆ ಗಡಿ ಎಲ್ಲಿಂದ ತಗೋಬೇಕು ಅನ್ನೋದು ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಅಂತ ಬೆಳಿಗ್ಗೆ ಹೇಳಿದ್ರು. ಐ ವಿಲ್ ಕಮ್ ಬ್ಯಾಕ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ.
ಅಲ್ಲ, ಈ Lordship kindly say, Lord, I produced the annexure. Lord, already survey has been conducted by, Lord, the survey department. They said, my lord, it's more than for 6 kilometers.
It's more than
6 kilometers.
ಎಲ್ಲಿದೆ ಅದು?
ಕೊಟ್ಟ ಎಲ್ಲಿದೆ? No, my lord, the land has been acquired with KDB. ಈಗ ಏನಾಗುತ್ತೆ, ಅವರು ರೋಡ್ ಮಾಡಕ್ ಶುರು ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Lord, annexure.
ಅಲ್ಲ, ಅಕ್ವೈರ್ ಆಗಿಬಿಟ್ರೆ ನಿಮ್ಗೆ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಎಲ್ಲಿ ಬರುತ್ತೆ? ಅದು ನಿಮ್ಗೆ ಏನ್ ರೈಟ್ ಈಗ?
ಅಲ್ಲ, ಅಕ್ವೈರ್ ಹಾಕಿ ಮೊದಲು ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀವಿ. 1998 ಅಪ್ಲಿಕೇಶನ್ have been filed.
ಈಗ ಅಕ್ವೈರ್ ಆಗಿಬಿಟ್ಟಿದೆಯಲ್ಲ.
ಅಲ್ಲ, ಅಕ್ವೈರ್ ಆಗಿದೆ, ಬಟ್ ದೇರ್ ಫಾರ್ ನಾಟ್ ಬಿಫೋರ್.
ಏನು ಪ್ರೀ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ರೈಟ್ ಇರಲ್ಲ ರೀ. ಅನಥರೈಸ್ಡ್ ಅಕ್ವಿಷನ್ ಇಸ್ ನಾಟ್ ಎ ಪ್ರೀ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ರೈಟ್.
ಬಟ್ ನಾಟ್ ಇನ್ ಸಮ್ ಅದರ್ ಜಜ್ಮೆಂಟ್ ಸೇಮ್ ನಾಟ್ they are also entitled for
you are entitled for compensation.
compensation. I produce.
If it is.
Let my applications consider. 1998, my lord, the applications have been filed. So many years, my lord, we are
Once
waiting.
it is rejected.
And
on the
those,
ground
my
that
lord,
it falls within 5 kilometer radius. Rightly, it has been
ಇಲ್ಲ.
rejected. Again, they have approached this honorable court.
ಇಲ್ಲ,
Again, they have
ಸೆಪರೇಟ್
sent
ರಿಪೋರ್ಟ್
it
ಇದೆ
back.
ಅಂತ ಹೇಳ್ತಾರೆ. ಇಟ್ ಇಸ್ 6 ಕಿಲೋಮೀಟರ್ಸ್ ಅಂತ.
6 foot ಅದು
ಯಾರದು ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದು?
ಇದೆ ರಿಪೋರ್ಟ್, ರೆವಿನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಹಾಕಿ, ಸರ್ವೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ.
ಎಲ್ರಿ ನೀವು ಅನಥರೈಸ್ಡ್ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಕೇಳಬೇಕಾದ್ರೆ ಇನ್ನು ಪೆಂಡಿಂಗ್ ಎಂಕ್ವೈರಿ ಯು ಆರ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್
They
ಕಾಂಪನ್ಸೇಷನ್
are
ಅಂತ.
not entitled.
Not
ಆಗ್ರಿ.
page 65, my lord.
ಎಲ್ಲಿದೆ ಜಜ್ಮೆಂಟ್ ತೋರಿಸಿ ಒಂದು
ಅದು ಕೊಡ್ತೀವಿ.
ಓಡಿ ತೋರಿಸಿ ನೋಡು.
ಜಸ್ಟಿಸ್ ಇಂಚಿಗಿರಿ ಸಾಹೇಬರು ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ನೋಡಿ, ನನ್ನ ಪ್ರಕಾರ ಬರಲ್ಲ.
ಬಟ್ ಏನೋ ಮೈ
ಹಾಗೆ ಬರಲ್ಲ. ಇಟ್ ಇಸ್ ಅಕ್ವೈರ್ಡ್. ಅದಕ್ಕೆ ಲೆಟರ್ ಏಜ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆನ್ಸ್.
ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದೆ ಅಷ್ಟೇ, ಇನ್ನು ಅಕ್ವೈರ್ಡ್ ಆಗಿಲ್ಲ. ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್.
Both the
We have filed objections, my lord.
parties admit that the petition land is now acquired by KIDB. If that is so, petitioner is required to demonstrate that how his application seeking regularization is maintainable. Counsel for petitioner submits that this issue is clearly covered by a judgment rendered by this court, indicating that even an unauthorized occupant has a locus to seek compensation in respect of an acquired property by the state.
Another ground is.
No,
We made an application in 1998. If they were granted earlier, I am entitled for compensation. Those who are filed applications.
See, Inam land, occupancy rights, so our pre-existing.
Those who have filed applications along with me, their lands are regularized in the year 2002 itself.
Correct.
Nandu 4 ಜನ ಮಾಡಿಲ್ಲ.
It is rejected at the way back in the inception itself, it is rejected.
Yes.
Rejected recently. That has been satisfied with this honorable court.
List it on so and so date.
But
Yes.
in that case, 98 application, this is not come in the way. If the application is considered earlier,
I am not convinced you, but place on record judgment, let us see.
ಅದು later stage.
No, no, no.
If my application was considered in the year 1998, that I could have get the.
No. You produce the judgment. Next. ಯಾಕೆ ಡಿಗ್ರಿ ಬೇಸ್ಡ್ ಇದ್ರೆ ಯಾಕೆ ಮತ್ತೆ ಮಾಡ್ಲೇಬೇಕಲ್ಲ, ಇದು ಡಿಗ್ರಿದು ನಾಳೆಗೆ ಹಾಕೊಂಡಿದೀವಲ್ಲ, ನಾಳೆಗೆ ಹಾಕೊಳ್ಳೋಣ. Tomorrow. Please sit tomorrow in primary.
Similar notes, decree notes, as against the decree notes, I got the lots, the property registered. But even after registration lots, they are not mutating my name in the revenue customer.
Sketch
The
tomorrow.
revenue sketch illa, madam is confusing. Last time also hage ಹೇಳಿದ್ರು.
ಯಾವುದು?
Kindly plus as against the decree lots, plus my vendor has got an independent record in the revenue record. Plus kindly sees RTC lots.
Entire extent is
ಹೌದು.
agreed to be sold. ಯಾಕ್ರಿ ಅದಕ್ಕೆ ಯಾಕೆ 11 sketch ಬೇಕು?
Yes.
Let's kindly see his RTC lots. It is independently standing in his name lots.
If it is so, we will consider.
ಇದೇನೋ suit for what ಇದು?
Suit for specific performance lots.
Daily obtained ಮಾಡಿದ್ದೀರಾ?
ಆಗಿದೆ execution.
ಬರ್ಕೊಡಿ. This petition is filed seeking a mandamus against respondent Tashildar to effect change of khata in terms of compromise decree, in terms of decree obtained by petitioner in OS 739 of 2015, which is one for specific performance of contract, followed by sale deed obtained through court commissioner
ಹೌದು ಸ್ವಾಮಿ.
in execution proceedings bearing EP number 39/2019. Next, learned AGA has registered this petition on the ground that petitioner's name cannot be entered in the RTC unless L1 sketch is produced. This statement, this contention of the Tashildar is misconceived. Records reveal that petitioner has purchased entire extent in survey number
68 bar
P10, totally measuring 4 acres. When an entire extent is purchased and there are no multiple owners, the revenue authorities cannot insist for L1 sketch. This is nothing but deliberate intent on the part of authorities in not acting on the decrees passed by a competent civil court. This is a clear case of dereliction of duty, though decrees obtained by petitioner in 2019 and sale deed is obtained. Yavaga,
plus sale deed notes plus 30/12/2019.
30/12/2019 and a detailed representation is submitted on 30th December 2024. The respondent Tashildar is yet to act upon the representation. Petitioner, having acquired valid title pursuant to decree passed in a specific performance suit, followed by a sale deed executed in a properly instituted execution proceedings, has a legal right to seek change of khata. Respondent Tashildar is equally obligated to forthwith act under 128/129 and execute change of khata, strictly aligning with the decree passed in OS
number
9 of 2015, followed by sale deed obtained by petitioner in execution proceedings. Since there is inaction, this court proceeds to pass following order. If petition is allowed. Tahsildar is hereby directed to mutate petitioner's name to the petition land by taking note of the decree passed in OS so and so, followed by SLD dated so and so. This exercise shall be accomplished within a period of 4 weeks
Public notice.
from the date of receipt of order copy.
Matter 40.1, my lord. So it had come up last week in my lord, so please to.
Please.
On 11th of February.
Please.
ಆಗ್ಬೋದಾ?
ಆಗ್ಬೋದು ಸ್ವಾಮಿ. ಅವತ್ತಿನ ಎರಡನ್ನೂ ಕರೆದ್ರೆ we'll argue the matter.
Preliminary
hearing itself is my request.
Preliminary hearing,
Please.
Let it in preliminary on so and so date.
11/2.
Interim order be continued, my lord, please.
Interim order granted early is extended till it.
Grateful, my lord.
May be extended in my petition also. Same order is under challenge.
ಹೌದಾ?
ಹೌದು.
ನಿಮ್ಗೆ interim order
Interim
ಕೊಟ್ಟಿಲ್ಲ?
order it.
ಬರ್ಕೊಡ್ರಿ. ಯಾವ್ದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ ರಾಜಶೇಖರ್?
1006 of 2006.
1006
Council appearing in
1678.
ಯಾವ್ದು ಹೊಸದು ಯಾವ್ದು?
Nandu.
ಹೊಸದು 40 is the ಹೊಸದು.
40 host. 1678 is mine.
ಅದು ಹೊಸದಾ?
ಹೌದು.
The council for petitioner appearing WP 1678 of 2025 has brought to the notice of this court that that petitioner's case is identical to the connected writ petition, and on parity petitioner is also entitled for protection at the hands of this court. ಏನದು interim order ಏನ್ ಕೊಟ್ಟಿದ್ದೀವಿ?
ಅದರಲ್ಲಿ ಸ್ವಾಮಿ, actually they may not be in parity. Their appeal and their original,
Stay of
they
the
have been
interim.
rejected. The interim order granted is that the Tahsildar will not precipitate the matter and transfer.
ಅಷ್ಟೇ. Tahsildar is hereby directed not to precipitate the matter to next date of it.
Not to effect changes in the record of rights.
Aదే
which is already
Aదే,
there.
aದೇ, not to
ಅದೇ
precipitate.
precipitate slash
precipitate.
not to effect changes.
Yes.
Please.
Let
My lord, would it be,
ಸ್ವಾಮಿ,
Let Rajshekar also collect.
ಇಲ್ಲ ಅವ್ರ ಹೆಸರಲ್ಲಿ there was no order at all in their case. At least in that previous order, the appeal was allowed in their favor. Their appeal was rejected by the assistant commissioner.
would it be kindly, my lords, posted in third week any day, my lords? 17 to 21st,
Just a
any day.
minute,
my
yes,
lord.
sir.
Number 40, my lord, I will take notice for responding for it.
1 and 2, all right.
1 to 4, man.
1 to
1 to 4.
First petition.
Private respondents, my learned.
I'm appearing for 13 to 16.
These are
Gave it
notice to 1 to 4. Yes.
Would it be in third week any day, my lords, with kind permission?
ಸ್ವಲ್ಪ ಡಿಲೇ ಆಗ್ಬೋದು.
ಯಾಕ್ರಿ
11th
ಯಾಕೆ
ಅಂತ
ಬರಲ್ಲ?
1820, ಬಹಳ matters ಇದೆ.
ಹಾ?
There are many other matters on 13 to 15, my lords, therefore.
ಆಯ್ತು, ತಗೊಳ್ಳಿ date ತಗೊಳ್ಳಿ.
13 to.
Yes.
ಅಲ್ಲ, 18 or 19, my lords, the third week any day it is submission, my lords.
18 to is fine.
18 to.
18 to.
Yes.
Please, grateful.
Great.
Great.
Next.
Interim order in my case may be continued, my lords.
Yes, sir. Extended.
Grateful. Great.
Parvi. None appears listed on so and so date. Next. ಇದ್ರಲ್ಲ ಬೆಳಿಗ್ಗೆ ಪಾಸ್ವರ್ಡ್ ಇದು 43 ಪಾಸ್ಟ್ ಓವರ್. ಏನಿದು ರಿಮಾಂಡ್ ಆರ್ಡರ್?
Remanded to AC.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ಅವರು. ವೈ ಇಸ್ ಚಾಲೆಂಜಿಂಗ್ ರಿಮಾಂಡ್ ಆರ್ಡರ್? ಅಪೀಲ್ ಯಾರು ಇವ್ರದೇನಾ? ಈ ಮೇ ಬಿ ರೈಟ್ ಆಲ್ಸೋ ಮಂಜುನಾಥ್. ಏನಿದ್ ಮ್ಯಾಟ್ರು ಬರ್ಲಿ ಬಿಡಿ ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್.
Okay, in filed compromise petition.
Parties have settled the matter.
So.
Matter, we have filed compromise, matter may be disposed or dismissed as settled.
ಎಲ್ಲಿದೆ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್?
Got it.
ಏನು ಯು ವಿಡ್ರಾಯಿಂಗ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್?
In terms of compromise petition, we are withdrawing our claim. Parties are present.
ವಾಟ್ ಇಸ್ ದ ಪ್ರೆಸೆಂಟ್?
Parties are present.
what is the terms of settlement? ಏನ್ matter ಇದು? Mutation ಇದು?
This is with regard to tenant.
Land reform.
Land reforms.
Land
Land
reforms.
tribunal granted occupancy rights in respect to R4. It was challenged by the petitioners.
ನೀವು
Now,
rival tenant or landlord?
Landlord,
You are withdrawing,
I'm withdrawing.
will permit.
yes,
So the land tribunal order stands affirmed.
Yes,
yes.
and there are 2 IAs pending for proposed respondents.
ಏನದು?
Proposed respondents.
ಅವ್ರು ಯಾರು?
BDA. I have made respondent 8 and 9 as BDA and respondent number 10 as agreement holder under R4. But, those IAs may be disposed of
BDA ಯಾಕೆ ಇದರಲ್ಲಿ?
because there was an award passed by the BDA. The land was acquired. So to notify them with regard to these proceedings, I had made them part.
What is our yes?
What is that?
Party, sir.
ವಯಸ್ಸಾಗಿದೆ.
He is-
ಯಾರು ಮಾಲಕರು ಯಾರು?
he is R4.
ಈ landlord acknowledges tenancy.
Yes, I acknowledge that. My other clients are not able to stand there sitting
ಹಾ
there.
ಪಾಪ.
ಒಬ್ರು ಅವ್ರ ತಮ್ಮ ಬಂದ್ರು.
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ petitioners?
ನಾಲ್ಕು ಜನ.
ನಾಲ್ಕು ಜನ.
Four members.
4 petitioners.
ಅಲ್ಲ, five petitioners. Five petitioners.
5.
All are brothers.
One family.
ಬರ್ಕೊಡ್ರಿ. A joint compromise petition is filed by petitioners and respondents.
Number 4.
And respondent number 4.
He is here.
Yes. Petitioners who are the landlords have questioned the occupancy rights granted by the land tribunal. Today, by way of joint compromise petition, the landlords, petitioners slash landlords who are before the court acknowledge the tenancy rights of respondent number 4. In the light of settlement, petitioners have made a request to withdraw the writ petition as settled in terms of compromise petition. Have sought for disposal of the writ petition in terms of settlement arrived in the compromise petition. The compromise petition is lawful since the occupancy is granted in favor of both respondent is acknowledged by landlords. This court deems it fit to permit petitioners and respondent number 4 to enter into compromise. This petition is admitted and record. The petition stand disposed of in terms of joint compromise petition. ಏನದು ಆಯಗಳು ಏನದು?
Impleading applications.
ಅದೇನ್ ಮಾಡ್ಬೇಕೀಗ?
Dispose. Does not survive for
All interlocutory
not pressed. Does not survive for consideration.
does not survive for consideration. Yes, sir. Order sheet ಅಲ್ಲಿ sign ಮಾಡಿಸ್ಬಿಡಿ.
Mars.
Yes, sir. Nagarajappa, sir.
That, regarding Durasti and my lord Podi, Lord, the petitioner.
ಇವತ್ತ why it is listed today?
Lord, here, that's the lordship has, and last week has said, my lord, here and deposit.
ಅದು ತಗೊಂಡಿದ್ದೀನಿ ಕಾಪಿ.
ಅದು ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿ lordship ಮೇಲೆ can recall that.
ಏನದು ಏನ್ ಮ್ಯಾಟರ್ ಸರ್?
Lord, the annexure A is my lord, the petitioner herein. Lord has purchased the lands on 5/8/1968, annexure A. Lord, that's annexure A, your lordship. Then, my lord, the mutation entries have, my lord, page 20, in respect of my lord survey number 5/2, 2 acres, my lord, that has. And the RTC is also standing in the name of the petitioner to an extent of 2 acres. That is annexure C, my lord. The lordship may kindly go to my lord annexure D. There lies, my lord, a dispute between me and the respondents.
Yes.
That is in the sketch, my lord, showing. My lord, my client is in.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಈಗ? What
But the order passed by my lord, the technical assistant as well as the deputy commissioner order. But what, my lord, the my learned friend has also agreed that I am owner of it to an extent of 2 acres and 5 guntas.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ದಲ್ಲಿ?
ಸರ್ವೆ ನಂಬರ್ 5/2, my lord.
ಅವರು
5/8 ಅಲ್ಲಿ 2 acres. They have been in page number 39 of the order, my lords. Total extent 2 acres 8 guntas. Adali A Karab 1 gunta, B Karab 7 gunta. So in extent 2 acres he is the owner of.
They are also not disputing, my lord, the extent of land is concerned. The dispute is in respect of overlapping, my lord, to an extent
ಸ್ಕೆಚ್
of
ಅಲ್ಲಿ ಇದೆ, ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಇದೆ.
a sketch ಅಲ್ಲಿ annexure D, my lord, annexure D, page 22.
Page 22.
Page 22, annexure D. But item number 8, my lord, in the, may I show lordships, my lord. The marked portion,
ಎಲ್ಲಿದೆ ಅದು?
my lord, may I show it to lordships, my lord. This is the petitioner, my lord, in occupation.
ಅದು
Instead of,
ಸಬ್ ಡಿವಿಷನ್ 8 ಅಂತಿದೆ ಅದು.
ಹೌದು.
ಅದೇನದು?
Our subdivision 8 is, my lord, my property, and they are claiming under, my lord, the next, the portion. May I show it to lordship? Lordship, permit me, my lord, I will
Huh?
come forward. and
Tors-
show it. This portion, my lord, 5 guntas belongs to my lord, petitioner. That was given up for the purpose of widening of the road to this place. Now they are showing, my lord, the lands here.
As against this.
There is against this. This is to my lord, the correct of the
ಇಲ್ಲ, ಬಟ್ ಇದು ಸ್ಕೆಚ್ ಆರ್ಡರ್. ಈಗ ಇಲ್ಲಿ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ.
ಇಲ್ಲಿ ತೋರಿಸ್ತಾ ಇದೆ portion. Actually ಈಗ ಬರ್ಬೇಕಾದ್ರೆ.
ಆಯ್ತು. ಅಲ್ಲ, ಇದು ಪೋಡಿ ಆಗಿತ್ತಲ್ಲ, ಇದು ಪ್ರಪೋರ್ಷನೇಟ್ ಇದಕ್ಕೆ ಇದಾಯ್ತಾ? ಪೋಡಿ ಆದ್ಮೇಲೆ RTC ಜನರೇಟ್ ಆಯ್ತಾ?
RTC ಎಲ್ಲ ಬಂದಿದೆ ಸರ್.
My
ಅಲ್ಲ,
lords,
ನಿಮ್ದು
RTC
ಸರ್ವೆ ನಂಬರ್
I have produced the RTC. They have not produced.
ದೇ ಆರ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್.
ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್
Statement of objections ಅಲ್ಲಿ ನಾನು ಇಬ್ಬರದು RTC produce ಮಾಡಿದ್ದೀನಿ. My statement of objection is filed on.
ಈಗ ಮೇಡಮ್, ದಿಸ್ ಪೋಡಿ ಇಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್, annexure D is
He was
accepted.
the one applied for the podi and I have accepted my extent. He has accepted his extent. ಒಂದೇ ಒಂದು ಓದ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ. ನನ್ನ annexure 9 ಅಲ್ಲಿ statement of objections, page number 42. That is the podi, what he is the applicant, my lords. And the master is in page number 44, my lords.
ಹಾ,
44 ಅಲ್ಲಿ ಸರ್ಕಾರಕ್ಕೆ ಅದೊಂದು ರಿಪೋರ್ಟ್ ಬರ್ದಿದೆ ನೋಡಿ ಸ್ವಾಮಿ. ದಿನಾಂಕ 5/7/2017 ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದ್ತೀನಿ ಸ್ವಾಮಿ.
40 page.
ಎಸ್ ಮೇಡಮ್.
ಮೈ ಲಾರ್ಡ್ಸ್, ವರದಿ ಏನೆಂದರೆ ಪಾಂಡವಪುರ ತಾಲೂಕು ಮೇಲ್ಕೋಟೆ ಹೋಬಳಿ ಮಹದೇಶ್ವರಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 5/2 ಅನು 220 ಇವ್ರ ಅಪ್ಲಿಕೇಶನ್ ನಂಬರ್ ಸ್ವಾಮಿ. ಕಚೇರಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಸರಿ ಅಷ್ಟೇ. ಅದರಂತೆ ಮುಂಚಿತವಾಗಿ ನಮಗೆ ಪ್ರೋಬೋನಂತೆ ನೋಟಿಸ್ ನೀಡಿ ಸದರಿ ನೋಟಿಸ್ ಅನ್ನು ಗ್ರಾಮ ಅವಧಿಯ ಚಾವಡಿಯಲ್ಲಿ ಪ್ರಚಾರಪಡಿಸಿ ಅಂಟಿಸಲಾಗಿದೆ. ಅದರಂತೆ ದಿನಾಂಕ 8/5/2000 ಇವರು ಸರ್ವೇಯರು ಗ್ರಾಮ ಬೀದಿ ನೀಡಿ ಜಮೀನನ್ನು ನಮ್ಮನ್ನು ಹಾಜರಿಸಿಕೊಂಡು ನಾವು ತೋರಿಸಿಕೊಳ್ಳುವ ಅನುಭವದ ಆಧಾರದ ಮೇಲೆ
ಅಳತೆ
ಆಧಾರದ ಮೇಲೆ
Already ಈಗ
ಅಳತೆ ಮಾಡಿ ಸರಿದೂಗಿ ನಮ್ಮುಗಳ RTCಗೆ ಅನುಭವಕ್ಕೆ ವಿಭಾಗದಂತೆ
ಮೇಡಮ್
ವ್ಯತ್ಯಾಸವಿದ್ದು
ಮೇಡಮ್
ನಾವುಗಳು ಅದು
Already.
ಪೇಜ್ ನಂಬರ್ 44 ಅಲ್ಲಿ ವರದಿ ಕೊಟ್ಟಿದಾರಲ್ಲ ಅಲ್ಲಿ ದೇ ದೆಮ್ಸೆಲ್ಫ್ ಅಗ್ರಿ ದಟ್ ನಮ್ಮ ಅನುಭವಕ್ಕೆ ಮತ್ತು ನಾವಿರುವ ಇದಕ್ಕೆ ವ್ಯತ್ಯಾಸವಿದ್ದು ನಾವುಗಳು ಒಮ್ಮತದಿಂದ ಈಗಿನ RTC ವಿಸ್ತೀರ್ಣಕ್ಕೆ ಪೋಡಿ ನೀಡಲು ತಿಳಿಸಿರುತ್ತೇವೆ. ಅದರಿಂದ ಸರ್ವೇಯರ್ ನಮ್ಮನ್ನು ಅನುಭವ ಹೊಂದಿರುವ ತಾಳೆ ಮಾಡಿ ಅನುದಾನ ತಾಳೆ ಮಾಡಿ ಈ ಅಳತೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಮ್ಮದು ಮುಂದೆ ತರಕಾರಿಗಳು ಬಂದರೆ ನಾವೇ ಒಂದಕ್ಕೆ ಮಾಡಿಕೊಳ್ಳುತ್ತೇವೆ ಎಂದು ಪರಿಗಣಿಸಿ ಈ ಮೇಲಿನ ಹೇಳಿಕೆಯನ್ನು ಹೇಳಿ ಸಹಿ ಮಾಡಿರುತ್ತೇವೆ. RTC ನಮ್ದು ದಿ ಸೆಕೆಂಡ್ ಇಸ್ ಮೈ ಪಾರ್ಟಿ ಮೈ ಲಾರ್ಡ್ಸ್. ಅರ್ಜಿದಾರರು ಬಂದು ದೇವೇಗೌಡರು ಅವರೇ ಬರೆದು ಕೊಟ್ಟಿರುವಂತದ್ದು ಸರ್ವೆ.
ಯಾವ್ದು ಅಲಾಟ್ ಯಾವ್ದಾಗಿದೆ ಅವರಿಗೆ? ಸಬ್ ಡಿವಿಷನ್ 8 ಅಲ್ವಾ?
ಸಬ್ ಡಿವಿಷನ್ ಹೌದು. Kindly go to the sketch, my lords. I have given it annexure R17, page number 51, my lords. There is a road which crosses in between my property and his property, my lords.
It is the sketch about
and 5/8. My lords, that Karab land which has been there, that has been made use of the road. So namgu aurgu sambandhane illa. Mine is 5/8, our 5/2, and theirs is 5/8. There's no dispute, my lords. But simply is going on harassing me by putting 1/1 applications, my lord. The same is given the DC or order notice on. Annexure yellow.
Annexure M ಅಲ್ಲಿ.
Page number 43 ಅಲ್ಲಿ. Para number 3. Revision ಆಧಾರದಾರರು ಸ್ವಾಧೀನ ಹೊಂದಿರುವ ಜಮೀನು 1 ಎಕರೆ 20 ಗುಂಟೆ ಮಾತ್ರ ಮತ್ತು ರಸ್ತೆಯಿಂದ ಉತ್ತರಕ್ಕೆ ಇವತ್ತಿಗೂ ಸ್ವಾಧೀನ ಇರುವುದಿಲ್ಲ. ನಮ್ಮ ಕುಟುಂಬದವರು 26/6/1998 ವಿಭಾಗದಂತೆ 78ರಂತೆ 4ನೇ ಎದುರಾದ ತಂದೆ ಮತ್ತು ಚಿಕ್ಕಪ್ಪನೊಂದಿಗೆ ಆದಂತಹ ವಿಭಾಗ ಪಟ್ಟಿಯಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ 4ನೇ ಎದುರುದಾರರು ತಂದೆಯವರಿಗೆ ಸರ್ವೆ ನಂಬರ್ 5/2ರಲ್ಲಿ 1 ಎಕರೆ 5 ಗುಂಟೆ ಪ್ರದೇಶ ಬಂದಿದ್ದು ಅದರಂತೆ ಸದರಿಯವರು 30/9/2001 ಸ್ವಾಧೀನ ಮತ್ತು ಅನುಭವಿಸಿಕೊಂಡು ಬಂದಿದ್ದು ತದನಂತರ 1/10/2001ರಿಂದ 4ನೇ ಎದುರುದಾರರು ನಮ್ಮ ಸ್ವಾಧೀನ ಹೊಂದಿರುತ್ತೇನೆ ಎಂದು ಪರಿಶೀಲಿಸಿ ಊರ ಗ್ರಾಮಸ್ಥರ ಸಮ್ಮುಖದಲ್ಲಿ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಮತ್ತು ನನಗೆ ದುರಸ್ತಿಯಾಗಿದೆ. 2 ಮತ್ತು 3ನೇ ಎದುರುದಾರರು ಪ್ರಸ್ತುತ ಅಳತೆ ಮತ್ತು ದುರಸ್ತಿ ಕ್ರಮ ಹಾಗೂ ನಕ್ಷೆ ತಯಾರಿಸುವ ಪೂರ್ವದಲ್ಲಿ ದಿನಾಂಕ 5/8/1968 ನೋಂದಾಯಿತ ಕ್ರಯಪತ್ರವನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿ ಮತ್ತು ರಿವಿಷನ್ ಅರ್ಜಿದಾರರಿಗೆ 1 ಎಕರೆ 22 ಗುಂಟೆ ಇದ್ದು ಅದರ ಒಪ್ಪಿಗೆ ಮೇರೆಗೆ ತಾತ್ಕಾಲ್ ಪೋಡಿ ನಂಬರ್ ಮೇರೆಗೆ ಭೂ ಮಾಲೀಕರಾದ ಕೇಶವಮೂರ್ತಿ HC ಅವರು ಸ್ಥಳಕ್ಕೆ ಬಂದು ಸ್ವಾಧೀನ ಅನುಭವದ ಜಮೀನಿಗೂ RTCಗೂ ವ್ಯತ್ಯಾಸವಿದೆ ಎಂದು ರಿವಿಷನ್ ಅರ್ಜಿದಾರರಿಗೆ ಮನವರಿಕೆ ಮಾಡಿದ್ದಾರೆ. ಸ್ವಾಧೀನ ಅನುಭವ ಇರುವ ಭೂಮಿ 1 ಎಕರೆ 28 ಗುಂಟೆ ದುರಸ್ತಿ ಮಾಡಲು ಸಾಧ್ಯ ಎಂದು ಹೇಳಿದಾಗ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ನನಗೆ RTCಯಲ್ಲಿರುವ ಭೂಮಿಯ ಪೂರ್ತಿ ದುರಸ್ತಿ ಆಗಬೇಕು ಎಂದು ಹೇಳುತ್ತಾರೆ. ಅದಕ್ಕೆ RTCಯಲ್ಲಿನ ಹಕ್ಕುದಾರರ ಒಪ್ಪಿಗೆ ಇದ್ದರೆ ನಿಮಗೆ ದುರಸ್ತಿ ಮಾಡಬಹುದು ಎಂದು ಪರವಾನಿಗೆ ಭೂಮಾಲೀಕರು ತಿಳಿಸಿದ ಮೇರೆಗೆ ನನಗೆ ದೂರವಾಣಿ ಮೂಲಕ ಕರೆ ಮಾಡಿ ದೇವೇಗೌಡರು ತತ್ಕಾಲ್ ಪೋಡಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು RTC ವಿಸ್ತೀರ್ಣಕ್ಕೂ ಅನುಭವ ವಿಸ್ತೀರ್ಣಕ್ಕೂ ವ್ಯತ್ಯಾಸವಿದ್ದು ನಿಮ್ಮ ಒಪ್ಪಿಗೆ ಇದ್ದರೆ ಇವರಿಗೆ RTCಯಲ್ಲಿರುವಂತೆ ಭೂಮಿಯನ್ನು ದುರಸ್ತಿ ಮಾಡುತ್ತೇನೆ ಎಂದು ಹೇಳಿದರು. ಇದಕ್ಕೆ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಗ್ರಾಮದ 40 ಜನರ ಸಮ್ಮುಖದಲ್ಲಿ ನ್ಯಾಯ ಮಾಡಿ ಸದರಿಯವರು ಕೋರಿಕೊಂಡ ಮೇರೆಗೆ ಪಶ್ಚಿಮ ದಿಕ್ಕಿನಲ್ಲಿ 66 ಅಡಿ ಅಗಲದ ದಕ್ಷಿಣದಿಂದ ಉತ್ತರಕ್ಕೆ ವ್ಯತ್ಯಾಸವಿರುವ ಭೂಮಿಯನ್ನು ಬಿಟ್ಟು ಕೊಡುವುದಾಗಿ ನಾನು ಒಪ್ಪಿಕೊಂಡ ಮೇರೆಗೆ ಅಳತೆ ಮತ್ತು ದುರಸ್ತಿ ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಆದರೆ ಈಗ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು 4ನೇ ಅರ್ಜಿದಾರರಿಗೆ ತೊಂದರೆ ಕೊಡುವ ಏಕೈಕ ಉದ್ದೇಶದಿಂದ 1ನೇ ಅರ್ಜಿದಾರರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮೇಲ್ಮನವಿ ಸಂಖ್ಯೆ 109/78 ಅನ್ನು ವಿರುದ್ಧ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿಯವರು ವಿಚಾರಣೆ ಮಾಡಿ ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿ ಸರ್ವೆ ನಂಬರ್ 5/2/8 ದುರಸ್ತಿ ಕ್ರಮಗಳನ್ನು ಕ್ರಮಬದ್ಧವಾಗಿರುವುದೆಂದು 16/12/2017 ಮೇಲ್ಮನವಿಯನ್ನು ವಜಾ ಮಾಡಿ ಆದೇಶ ಮಾಡಿರುತ್ತಾರೆ. ಅದರಿಂದ ಪ್ರಸ್ತುತ ರಿವಿಷನ್ ಅರ್ಜಿಯನ್ನು ವಜಾ ಮಾಡಬೇಕೆಂದು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಾರ್ಥಿಸಿಕೊಳ್ಳುತ್ತಾರೆ. ಉಭಯ ಲಿಖಿತರ ಅಂಶಗಳ ಮೇರೆಗೆ ಹಾಗೂ ಸ್ಥಳ ಕಚೇರಿಯಿಂದ ಪಡೆದ ಕಡಿತದೊಂದಿಗೆ ಪ್ರವೇಶಿಸಲಾಗಿದೆ. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರಮುಖವಾಗಿ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ತನ್ನ ಹೆಂಡತಿ ಶ್ರೀಮತಿ ಕೆಂಪಜಮ್ಮ ಪರವಾಗಿ ಪಾಂಡವಪುರ ತಾಲೂಕು ಮೇಲ್ಕೋಟೆ ಹೋಬಳಿ ಮಾದೇಶ್ವರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 5/2 ಮ್ಯೂಟೇಶನ್ ಅಳತೆಯಂತೆ ಸೊ ಅಂಡ್ ಸೊ ನಂಬರ್ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದರ ಮೇರೆಗೆ ಗ್ರಾಮಸ್ಥರ ಕ್ಷಮ ನಡೆದ ಮಾಜರಿನಲ್ಲೂ RTC ವಿಸ್ತರಣಕ್ಕೂ ಮತ್ತು ಅನುಭವ ವಿಸ್ತರಣಕ್ಕೂ ವ್ಯತ್ಯಾಸ ಇರುವುದು ತಿಳಿದು ಬಂದಿದ್ದು, ಸದರಿ ವ್ಯತ್ಯಾಸವನ್ನು ನಾವುಗಳು ಮುಂದೆ ಬಗೆಹರಿಸಿಕೊಳ್ಳುವುದಾಗಿ ಹೇಳಿ ಅರ್ಜಿಯನ್ನು ವಿಲೆ ಇಡಲು ಕೋರಿದ್ದರ ಮೇರೆಗೆ ಮಾಜಾರ್ ಮಾಡಿ ಅರ್ಜಿಯನ್ನು ಅಂತಿಮ ವಿಲೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ತದನಂತರ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಇದೇ ವಿಚಾರದಲ್ಲಿ ಅಳತೆ ಮತ್ತು ಪೋಡಿ ಮಾಡಿಸಿಕೊಳ್ಳಲು ತಾತ್ಕಾಲ್ ಪೋಡಿ ಅರ್ಜಿ ಸೋ ಅಂಡ್ ಸೋ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಅದರಂತೆ ಅಳತೆ ಮಾಡಿ ಮುನ್ನ ಭೂಮಾಕರ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಮತ್ತು ಎದುರುದಾರರಿಗೆ ನೋಟಿಸ್ ನೀಡಿ ಅಳತೆ ಸಂದರ್ಭದಲ್ಲಿ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು RTC ವಿಸ್ತೀರ್ಣಕ್ಕೂ ಮತ್ತು ಅನುಭವ ವಿಸ್ತೀರ್ಣಕ್ಕೂ ವ್ಯತ್ಯಾಸವಿದ್ದು ತಾವುಗಳೇ ಒಮ್ಮತದಿಂದ ತೀರ್ಮಾನಿಸಿಕೊಂಡು RTC ವಿಸ್ತರಣೆಗೆ ತಾಳೆ ಇಟ್ಟು ಅಳತೆ ಮಾಡಲು ಯಾವುದೇ ತಕರಾರು ಇರುವುದಿಲ್ಲವೆಂದು ಒಪ್ಪಿಗೆ ಸೂಚಿಸಿದ್ದರ ಮೇರೆಗೆ ಅದರಂತೆ ಭೂ ಮಾಲೀಕರು ಅಳತೆ ಮಾಡಿ ದುರಸ್ತಿ ಮಾಡಿರುವುದು ದಾಖಲೆಗಳಿಂದ ಕಂಡುಬರುತ್ತದೆ. ಸದರಿ ವಿಚಾರವನ್ನು ಪ್ರಶ್ನಿಸಿದ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು 1ನೇ ಎದುರು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮೇಲ್ಮನವಿ 109/1718 ನಂತೆ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿದ್ದು, 1ನೇ ಎದುರು ಸಹ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರ ಅಳತೆ ಕಾಲದಲ್ಲಿ ನೀಡಿದ ಒಪ್ಪಿಗೆ ಮೇರೆಗೆ ಅಳತೆ ಮತ್ತು ದುರಸ್ತಿ ಆಗಿರುವುದರಿಂದ ಹಾಗೂ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿ ಭೂ ಮಾಲೀಕರು ಮಾಡಿರುವ ಅಳತೆ ಮತ್ತು ದುರಸ್ತಿ ಕ್ರಮವು ಕ್ರಮಬದ್ಧವಾಗಿದೆವೆಂದು ಪರಿಗಣಿಸಿ ಮೇಲ್ಮನವಿ ವಜಾ ಮಾಡಿರುತ್ತದೆ. ಈಗಾಗಲೇ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಈ ಹಿಂದೆ ಮಾಡಿಸಿದಂತಹ ಅಳತೆ ಮತ್ತು ದುರಸ್ತಿ ಕ್ರಮವನ್ನು ಒಪ್ಪಿಕೊಂಡಿದ್ದು, ಈಗ ಇದು ಸರಿಯಿಲ್ಲವೆಂದು ಪುನಃ ಮೇಲ್ಮನವಿ ಹಾಗೂ ರಿವಿಷನ್ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುವುದರಲ್ಲಿ ಯಾವುದೇ ಗುಣಾಂಶ ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಮೇಲ್ಮನವಿ ಹಾಗೂ ರಿವಿಷನ್ ಅರ್ಜಿ ಸಲ್ಲಿಸುತ್ತಾರೆ ಎಂದು ಈ ನ್ಯಾಯಾಲಯವು ಅಭಿಪ್ರಾಯಪಟ್ಟು ಕೆಳಗಿನಂತೆ ಮಾಡಿದ ರಿವಿಷನ್ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಲಾಗಿದೆ. ಇದರಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಅನ್ನೋದೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
All right, just a minute. Yes, Nagaraj sir. Come to sketch.
Sketch
Thoroughly sketch. ಯಾವಾಗ ಆಗಿದ್ದು?
this
ಇದು
is
ಪೋಡಿ ಯಾವಾಗ ಆಯ್ತಿದ್ದು?
ಅಲ್ಲಿ ಪೋಡಿ ಆಗಿರೋದು ಪ್ರೊಡ್ಯೂಸ್ annexure B your lordships my lord. Let's see.
ಅಲ್ಲ ನಿಮ್ದು who is the original owner?
Original owner and one my lord. His name is
ಆಯ್ತು, ನೀವು ಅವ್ರ ಹತ್ರ interaction purchase ಮಾಡಿ.
in my lord on 5868 my lord my purchase the
You have
sale deed
purchased it?
purchase
And
and
you have sold.
his document is of the year 2001.
No, you have sold a portion to.
No, I have not sold, but they have purchased from the original owner to an extent of 1 acre, 3 guntas.
ನೀವೇ
And I have purchased, my lord, from the same owner to an extent of 5 acres and 6 states, because there are 3 acres, my lord, put together all. ಅವರು ಒಂದು ಪೋರ್ಷನ್ ತಗೊಂಡ್ರು, ನಾನು ಒಂದು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದೀನಿ.
Correct.
Their document is of the year 2001. My document is, my lord, on 5868, 68ರಲ್ಲಿ. I am the first purchaser.
ಅಲ್ಲ ಈಗ ನೀವು ಬಂದು ತೋರಿಸಿದ್ರಲ್ಲ ಬಿಯಾಂಡ್ ರೋಡ್ ನಿಮ್ಗೆ ಹೆಂಗ್ ಬರುತ್ತೆ? ಅದು ದಟ್ ಇಸ್ ಸಬ್ ಡಿವೈಡೆಡ್. ಅವ್ರದ್ದು ಎಕ್ಸ್ಟೆಂಟ್ ಒಂದ್ ನಿಮಿಷ, ನಿಮ್ ಸೆಲ್ಡಿನ ಪ್ರಕಾರ ಎಷ್ಟು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದೀರಾ ನೀವು?
My lord.
ವಾಟ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಟ್ ಪರ್ಚೇಸ್ ಬೈ ಯು?
They have produced, my lord, along with the statement of objection, page 23, some, page 23 of their statement of objection.
ಒಂದ್ ನಿಮಿಷ, ಅವರು ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೆಸರೇನು?
ಅವರ ಹೆಸರು ವಿಶ್ವನಾಥ್.
ವಿಶ್ವನಾಥ್.
ವಿಶ್ವನಾಥ್ ಮುದ್ದೇಗೌಡ.
ಇದು ನಮ್ಮ ತಂದೆಯವರಿಗೆ ಬಂದಿದ್ದು 1 acre 3 guntas ಸ್ವಾಮಿ. There is a family partition between us. ಅದ್ರಲ್ಲಿ ವಿಶ್ವನಾಥ್ ಅವ್ರ ತಂದೆಗೆ ಬಂದಿದ್ದು 1 acre 3 guntas.
1 acre 3 guntas.
Yes, my lords.
ಸರ್ ನಿಮ್ ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟು?
Well, 2 acres and 5 guntas, 5 guntas. 2 acres, 5 guntas, man. That is 5 guntas is Karab, 2 acres.
ಒಂದ್ ನಿಮಿಷ, ಅದು 5/8 ಅಲ್ಲ?
ಹೌದು.
5/8.
They are also not, my lord, disputing the extent of land in survey number.
ಎಲ್ಲಿದೆ ಸರ್ವೆ ನಂಬರ್ ಕೊಟ್ರಲ್ಲ ನೀವು? RTC ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಲ್ಲ?
ಮಾಡಿದ್ದೀನಿ ಸರ್.
ಇಲ್ಲ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ.
ನಾನು ಮಾಡಿದ್ದೀನಿ. Annexure
45 ಇಂದ 5/8 ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
45 ಇಂದ ಅವ್ರದಾ?
45.
ನಿಮ್ದು ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟು ಸರ್ 5/8 ಅಲ್ಲಿ?
5/8 2 acres ಮೇಲೆ.
ಇದೆ, ಅಷ್ಟು ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ?
ಅದೇ ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿದೆ. But my lord, the deputy commissioner lordship may kindly go to my lord. I will not take your lordship. And the orders of the deputy commissioner. Page 43. Page 43. Page 43, my lord, third paragraph from top. My writ petition, your lordship.
Yes, sir.
ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಮೂರನೇ ಪ್ಯಾರಸ್ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಸ್ವಾಧೀನ ಹೊಂದಿರುವ ಜಮೀನು 1 ಎಕರೆ 28 ಗುಂಟೆ ಮಾತ್ರ. How we can, my lord, the document says, and even the sale deed, and my lord, the RTC and mutation is 2 acres 5 guntas, but 5 guntas is Karab. He has arrived at a conclusion saying that, my lord, I am in possession of only 1 acre 28 guntas. 18 ಗುಂಟೆ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. Just contrary to the, my lord, documents. This has to be set aside, my lord, they have to conduct resurvey, my humble lord, prayer to your lordship.
Oh, that will have ramifications, sir. ಅವರೆಲ್ಲ ಈಗ ಅದು ಡೆವಲಪ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ನಗರಸಭೆ. ಅಲ್ಲ, is it a case?
ಡೆವಲಪ್ ಅಂತ ಹೇಳಿದ್ರೆ
ಅಲ್ಲ, is it a case of encroachment according to you?
no encroachment. They are, my lord, there. ಅಂದ್ರೆ ಈ portion ಗೆ that is a overlapping, my lord, to an extent of 18 guntas.
ರೋಡ್ ಇದೆ ಅಲ್ಲಿ. ರೋಡ್ ಬಿಯಾಂಡ್ ನಿಮ್ಗೆ
ಅಲ್ಲ 5 guntas ರೋಡ್ ಹೋಗಿದೆ.
ರೋಡ್ ಬಿಯಾಂಡ್ ನಿಮ್ದು ಬರಲ್ಲ. Then you have to file a suit.
ಅಲ್ಲ ರೋಡ್ ನಿಂದ ಆಚೆ ಇರುವಂತ just I showed to lordships, my lord, a portion after the road ಅದು 2 acres 5 guntas ಆಗುತ್ತೆ. ಅವರು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ extent of land. I am not also disputing their
Correct.
but the thing is, my lord, the deputy commissioner arrived at a conclusion saying you are in possession of 1 acre 28 guntas.
ಒಂದ್ ನಿಮಿಷ, ಇಲ್ಲಿ ಈ ಸ್ಕೆಚ್ ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. We don't know. ಈಗ ಇಲ್ಲಿ ನೋಡಿ, ಇದು come to page 35 annexure J.
Please, my lord. 35.
ಕರೆಕ್ಟ್ ಆಗಿ ತೋರಿಸಿದ್ದಾರೆ, 2 ಎಕರೆ ತೋರಿಸಿದ್ದಾರೆ. ಅವಾಗ ಪೊಸೆಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೆ. ಈಗ ಗೊತ್ತಿಲ್ಲ ಅಕ್ಕಪಕ್ಕ ಎಲ್ಲಿ ಎನ್ಕ್ರೋಚ್ ಆಗಿದೆ ಗೊತ್ತಿಲ್ಲ. You have to file a suit.
But this
This is not defective because you are
but the
putting
extent
possession
of
of.
land, my lord, how can, my lord, the deputy
ಬನ್ನಿ ಆ
commissioner
ಟೇಬಲ್ ದಲ್ಲಿ ಬನ್ನಿ, ಆ ಟೇಬಲ್ ನೋಡಿ. ಟೇಬಲ್ ದಲ್ಲಿ ಕಮ್ಮಿ ಇಲ್ಲ.
ಅವ್ರ ಸಬ್ಮಿಷನ್
ಓದ್ತಾ ಇದ್ರು ನಮ್ದೀಗ ಕಮ್ಮಿ ಇದೆ ಅಂತ. ನಮ್ದೀಗ ಬರೀ 1 ಎಕರೆ 20. RTC ಇದೆ. ಟೇಬಲ್ ಅಲ್ಲೂ ನಿಮ್ಗೆ 2 ಎಕರೆನ ಕಬ್ಜಾ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ 5/2 5/8 ಅಂತ ಬರೆದು ರೋಮನ್ 2 ಅಂತ ಮಾಡ್ತಾರೆ. What is handed over to you is Roman 2.
I agree with the lordships, my lord,
ಇದು
but the deputy commissioner
ನಿಮ್ದು ದಕ್ಷಿಣಿಗಿದೆ ನಗರಜಪ್ಪ ಸರ್.
ಅಲ್ಲ the
ರೋಡ್
extent
ದಕ್ಷಿಣಿಗೆ
ಅವ್ರ
ನಿಮ್ದು.
extent ಹೇಳ್ತಾರೆ
ತರಕ ನಾವು
1 acre 28 guntas ಅಂತ ಹೇಳ್ತಾರೆ ಈಗ, not to 2
ರೋಡ್
acres.
ಇದೆಯಲ್ಲ, ರೋಡ್
ಅಲ್ಲ
ಬಂದ್ಬಿಟ್ಟಿದೆ.
ರೋಡ್ ಬೇರೆ 2 acres 5 guntas ಇರುವಂತದ್ದು totally. Out of that 5 acres, my lord, but that has been given up for the purpose of widening of the road.
ಕರೆಕ್ಟ್.
2 acres remained is there. They are not also disputing.
ಅಲ್ಲ, ಈ ಸ್ಕೆಚ್ ಕರೆಕ್ಟ್ ಇದೆ.
18 ಗುಂಟೆ ಡಿಫರೆನ್ಸ್ ಬರ್ತಾ ಇದೆ.
ಅದು ಫ್ಯಾಕ್ಚುಲಿ ಬರ್ತಾ ಇದ್ರಿ, you have to file a suit by demonstrating
The
that
order of the authorities, my lord, coming in the way of, my
ಇದು
lord.
40 ಹೋಗಲ್ಲ, ಇದು 40 ಹೋಗಲ್ಲ. ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಇದ್ರೆ ನೀವು ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿಸಿ. If adjoining owner is in excess
ಅಲ್ಲ, if it
extent,
is the resurvey is conducted, not
ಇದು-
put an end to this.
ಅಲ್ಲಲ್ಲ, ನೀವು ನಿಮ್ಮ ಲ್ಯಾಂಡ್ ಅನ್ನ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿಸಿ ಬೇಕಾದ್ರೆ ಮಾಡಿ. ರಿಡಕ್ಷನ್ ಇದ್ರೆ you file a suit for possession. This sketch is correct.
But the deputy commissioner, my lord, the extent of land, your lordship may kindly say 1 acre 28, how we can say, my lord, your lordship may kindly, my lord, with.
ಅಲ್ಲ, ಈಗ ನೀವು ತೋರಿಸಿದ್ರಲ್ಲ, ನೀವು ರೋಡ್ ಬಿಯಾಂಡ್ ನೀವು ಪೋರ್ಷನ್ ನಮ್ದು ಇದೆಯಾ ಅಂದ್ರಲ್ಲ, ದೇರ್ ಇಸ್ ದಿ ಬಟ್ ಅದು ಬರಲ್ಲ.
ಅಲ್ಲ 5 guntas road ಹೋಗಿದೆ ಸರ್.
ಹಾಗಲ್ಲ,
ಅದನ್ನ I am not
ಅಲ್ಲಲ್ಲ
disputing that.
ನಾಗರಾಜಪ್ಪ ಅವರೇ, ನೀವು
ಅದ್-
ಆ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದಾರೆ ಗೊತ್ತಾ? ಈ ರೋಡ್ ಬಿಟ್ಟು ಸ್ವಲ್ಪ ನೀವು ಪೋರ್ಷನ್ ಕೇಳ್ತಾ ಇದೀರಾ, ಅದು ಬರಲ್ಲ.
ಅಲ್ಲ ನಾನು ಇದ್ದೀನಿ, ಅವರು ಒಪ್ತಾರೆ. Next.
ರೋಡ್ ಇಂದ ನಾರ್ದನ್
ಅವರು they are not disputing. ರೋಡ್ ನಿಂದ ಆಚೆ 18 ಗುಂಟೆ ಇದೆ.
ರೋಡ್ ದಕ್ಷಿಣಕ್ಕೆ ನಿಮ್ದು ಮೆಜರಿಂಗ್ 2 acres. ಕೋರ್ಟ್ ಖರಾಬ್ ಎಷ್ಟಿದೆ ಗೊತ್ತಲ್ಲಿ?
5 guntas ಅಂತ ಹೇಳ್ತಾರೆ. 5 guntas ರೋಡ್ಗೆ ಹೋಗಿರೋದು.
ಅಲ್ಲ, ಎ ಖರಾಬ್ ಏನೋ 1 ಗುಂಟೆ ಅಂತ ತೋರಿಸ್ತಾರೆ.
ಎ ಖರಾಬು ಮತ್ತೆ ಬಿ ಖರಾಬು 7 ಗುಂಟೆ.
2 ಎಕರೆ ಇದೆ ನಿಮ್ದು.
ಎರಡು ಸೇರಿ 8 ಗುಂಟೆ.
ಹಿಂಗಂದ್ರೆ ಎಷ್ಟು ಅದು? ನ್ಯೂಮರಿಕಲ್ ಎಷ್ಟು ಅದು? 1 2 ಅದು? 1 ಅದು ಅಲ್ವಾ? ಇಲ್ಲ ರೀ ನಾಗರಾಜ್ ಸರ್, ಏನೋ ಬೇರೆ ಇದೆ ಅಲ್ಲಿ.
ಅಲ್ಲ ಬೇರೆ ಏನಿಲ್ಲ.
ಏನೋ ಬೇರೆ ಇದೆ.
ಅಲ್ಲ ಡೆಪ್ಟಿ ಕಮಿಷನರ್, my lord, ಬೇರೆ ಇದ್ರೆ ಸಹ.
ಇಲ್ಲ, ಇದು 40 is correct ಸರ್. ನಿಮ್ ಟೈಟಲ್ ಡೀಡ್ ಪ್ರಕಾರ ನಿಮ್ಮದನ್ನ ಸೌತ್ ಡಿಮಾರ್ಕೆಟ್ ಮಾಡಿ 2 ಎಕರೆ ನಿಮ್ ಕಬ್ಜೆನೂ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕೋಡಿ ಮಾಡಿ. RTC ಕೂಡ ಜನರೇಟ್ ಆಗಿದೆ ಸಬ್ ಡಿವಿಷನ್ಗೆ. ಅವ್ರದ್ದು 5/2, ನಿಮ್ದು 5/8, and both the properties are divided by a road, so there is no confusion.
ರೋಡ್ ನಿಂದ ಆಚೆ 18 guntas, that is our, my lord. They are also agreed the extent of land is 2 acres 5 guntas. ಅದ್ರಲ್ಲಿ 5 ಗುಂಟೆ ಹೋಗಿದೆ ಅಂತ ಅವರು They are agreed.
ರೋಡ್ ಮುಂದೆ ಉತ್ತರಗೆ ಮತ್ತೆ ನೀವು ಕ್ಲೇಮ್ ಮಾಡ್ತಾ
After the road, my lord, to an extent of.
ಅದು ಬರಲ್ಲ. ಈ ಸ್ಕೆಚ್ ನೀವು ಅವಾಗ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು. ಯಾವಾಗ ಆಗಿದ್ರೆ ಮಂಜುನಾಥ್ ಸ್ಕೆಚ್?
8 9 starts first.
Right, there is subsequent.
ಆಮೇಲೆ ದೇರ್ ಇಸ್ ನೋ ಮಟೀರಿಯಲ್. ನಾಗರಾಜಪ್ಪರೇ, ಇದು ರೋಮನ್ 2 ಅಂತ ಕೆಳಗಡೆ ದಕ್ಷಿಣಗೆ ಏನ್ ತೋರಿಸಿದಾರಲ್ಲ, ಎಲ್ ಶೇಪ್ ಇದೆಯಲ್ವಾ, ಅದು 2 ಎಕರೆ ಇಲ್ಲಂತೆ ತೋರ್ಸಕ್ ನಿಮ್ಮ ಹತ್ರ ಏನೂ ಇಲ್ಲ ಈಗ.
But my lord, the deputy commissioner says.
ಏನ್ ಮಟೀರಿಯಲ್ ಇದೆ ನಿಮಗೆ? ಅದು 2 acres ಮೆಜರ್ಮೆಂಟ್ ಆಗಲ್ಲ.
The sale deed is there. Your lordship may kindly go to my lord.
ಅಲ್ಲ ರೀ, ಈಗ ಅದು ನಿಮ್ಗೆ ಅಲಾಟ್ ಮಾಡಿದ್ದು 5/8, ಅದು ಲೆಸ್ ದೆನ್ 2 acres ಇದೆ ಅಂತ.
5/8 to 2 acres ಅಂತ ಇದೆ sir.
You can't lay over 5/2.
Page 20 your lordship, my lord, that is RTC.
ಯಾವ್ದು page 20 ಏನು?
Page 20 of my writ petition.
Yes sir.
ಕೆಂಪಾಜಮ್ಮ ಅಂದ್ರೆ ದೇವೇಗೌಡರ ಹೆಂಡತಿ ಕೆಂಪಾಜಮ್ಮ. ಹೋಮ್ ದೇವೇಗೌಡ 2 acres lordship, right hand column.
ಹೌದು, ನಿಮ್ಗೆ 2 ಎಕರೆ ಇದೆಯಲ್ಲ.
Physically, my lord, physically it is not in existence according to the orders of the revenue.
ನೋಡಿ, ಇದು ಒರಿಜಿನಲ್.
Then your lordship may kindly go to my next document, RTC also. Next, that is the page 21, my lord, page 21. RTC ಅಲ್ಲಿ 2017 and my lord, Vishwanath, our client, Devagowda bin Vannagiri Gowda, my lord, column number 7.
ಈ ವಿಶ್ವನಾಥ್ ಯಾರು?
My client minors. Husband, my client.
2 acres is my lord.
ಅದು ಇದ್ರ ಬೇಸ್ ಮೇಲೆ ಅವರು 4D ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲಿ ತೋರಿಸೋದನ್ನು 2 ಎಕರೆ ಅಂತ ತೋರಿಸ್ತಾರೆ.
ಇಲ್ಲೂ 2 ಎಕರೆ ತೋರಿಸಿದ್ದಾರೆ. ಸ್ಕೆಚ್ 4D ಅಲ್ಲೂ 2 ಎಕರೆ ತೋರಿಸಿದ್ದಾರೆ.
ಇಲ್ಲ ಅಲ್ಲಿ 2 ಎಕರೆ ಅಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ. ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್ ತಾವು ದಯವಿಟ್ಟು ಒಂದ್ಸಲಿ ಇನ್ನೊಂದ್ಸಲಿ ಬಿಟ್ಟು. ಕಾಸ್ಟ್ ಆಫ್ ರೆಪ್ಯುಟೇಷನ್, ಪೇಜ್ 43.
ನಿಮ್ ಸಬ್ಮಿಷನ್ ಅದು.
ರಿವಿಷನ್ ಅರ್ಜಿ ಸ್ವಾಧೀನ ಅಲ್ಲ, ಅದನ್ನ ರಿವಿಷನ್ ಅರ್ಜಿ ಅಂದ್ರೆ ನಾವೇ ಸ್ವಾಧೀನ ಹೊಂದಿರೋ ಜಮೀನು 1 ಎಕರೆ 20 ಗುಂಟೆ ಮಾತ್ರ ಮತ್ತು ರಸ್ತೆಯಿಂದ ಉತ್ತರಕ್ಕೆ ಇವತ್ತಿಗೂ ಸ್ವಾಧೀನ ಇರುವುದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. ರಿವಿಷನ್ ನಮ್ಮ ಕುಟುಂಬದವರು 26-78 ವಿಭಾಗದಂತೆ 4ನೇ ತಂದೆ ಮತ್ತು ಚಿಕ್ಕಪ್ಪನೊಂದಿಗೆ ಅಂತ ವಿಭಾಗ ಪಟ್ಟಿಯಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ 4ನೇ ಎದುರುದಾರರು ತಂದೆಯವರಿಗೆ ಸರ್ವೆ ನಂಬರ್ 5/2ರಲ್ಲಿ 1 ಎಕರೆ 5 ಗುಂಟೆ ಪ್ರದೇಶ ಹೊಂದಿದ್ದು, ಅದರಂತೆ ಸದರಿಯವರು 39ವರೆಗೆ ಸ್ವಾಧೀನ ಮತ್ತು ಅನುಭವಿಸಿಕೊಂಡು ಬಂದಿದ್ದು, ತದನಂತರ 1/1/2001 4ನೇ ಎದುರುದಾರರಾದ ಸ್ವಾಧೀನ ಹೊಂದಿರುತ್ತೇನೆಂದು ಇದನ್ನು ಪರಿಶೀಲಿಸಿ ಊರ ಗ್ರಾಮದ ಸಮ್ಮುಖದಲ್ಲಿ ರಿವಿಷನ್ ಸೌಂಡ್ಸ್. ಹೌದು my lord, deputy commissioner has arrived at a conclusion that I am in a position of 1 acre 28 guntas. That is 2 acres, my lord, not 1 acre 28 guntas. The difference is 18 guntas. Plus, my lord, that includes 5 acres kharab. ಅವ್ರು ಹೇಳಲಿಕ್ಕೆ ಬರಲ್ಲ ಸರ್, 1 acre 28 guntas. This has come in our May, my lord. Even if I file my lord suit for position declared.
This is I will clarify it.
This will come in my way. That's my.
ಬರಲ್ಲ.
If it is my lord, lordship.
ಉಭಯತರು ಲಿಖಿತವಾದ ಅಂಶಗಳ ಮೇರೆಗೆ ಹಾಗೂ ಕೆಳ ಕಚೇರಿಯಿಂದ ಪಡೆದ ಕಡತದೊಂದಿಗೆ ಪರಿಶೀಲಿಸಲಾಯಿತು. 5/2ರಲ್ಲಿ ಮ್ಯುಟೇಷನ್ ಅಳತೆಗಾಗಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ರ ಮೇರೆಗೆ ಗ್ರಾಮಸ್ಥರ ಸಮಸ್ಯೆಗಳು ನಡೆಸಿದ ಹಾಜರಿನಲ್ಲೂ RTC ವಿಸ್ತೀರ್ಣಕ್ಕೂ ಮತ್ತು ಅನುಭವ ವಿಸ್ತೀರ್ಣಕ್ಕೂ ವ್ಯತ್ಯಾಸವಿರುವುದು ತಿಳಿದು ಬಂದಿದೆ. ಸದರಿ ವ್ಯತ್ಯಾಸವನ್ನು ನಾವುಗಳ ಮುಂದೆ ಹೇಳಿ ಅರ್ಜಿಯನ್ನು ವಿಲೆ ಇಡಲು ಕೋರಿದ್ದರು ಮೇರೆಗೆ ಹಾಜರು ಮಾಡಿ ಅರ್ಜಿಯನ್ನು ಅಂತಿಮ ವಿಲೆ ಮಾಡಿದರು. ತದನಂತರ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಇದೇ ವಿಚಾರದಲ್ಲಿ ಅಳತೆ ಮತ್ತು ಕೋಡಿ ಮಾಡಿಕೊಡಲು ತತ್ಕಾಲ ಕೋಡಿ ಅರ್ಜಿ ನೀವೇ ಕೊಟ್ಟಿರೋದು ಅದು. ಅದರಂತೆ ಅಳತೆಗೆ ಮುನ್ನ ಭೂಮಾಕರ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಮತ್ತು ಎದುರುದಾರರಿಗೆ ನೋಟಿಸ್ ನೀಡಿ ಅಳತೆ ಸಂದರ್ಭದಲ್ಲಿ ರಿವಿಷನ್ ಅರ್ಜಿ ಮತ್ತು ಅನುಭವಿಸಿದಕ್ಕೂ ವ್ಯತ್ಯಾಸವಿದ್ದು ತಾವುಗಳೇ 9ರಿಂದ ತೀರ್ಮಾನಿಸಿಕೊಂಡು ತಾಳಿ ಇಟ್ಟು ಅಳತೆ ಮಾಡಲು ಯಾವುದೇ ತಕರಾರು ಇರುವುದು ಒಪ್ಪಿಗೆ ಮತ್ತೆ ಭೂಮಾಕರು ಅಳತೆ ಮಾಡಿ ದುರಸ್ತಿ ಮಾಡಿರುವುದು ದಾಖಲೆಗಳಿಂದ ಕಂಡುಬರುತ್ತದೆ. ಸದರಿ ವಿಚಾರ ಆ ಕನ್ಕ್ಲೂಷನ್ ಎಲ್ಲ ಅವ್ರು 1 acre 28 ಗುಂಟಸ್ ಅಂತ ಹೇಳಲ್ಲ ಅವ್ರು.
ಹೇಳ್ತಾರೆ sir.
Submission.
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳ್ತಾರೆ 2 ಮತ್ತು 3ನೇ ಎದುರುದಾರರು ಪರಿಷ್ಕೃತ ಅಳತೆ ಮತ್ತು ದುರಸ್ತಿ ಕ್ರಮ ಹಾಗೂ ನಕ್ಷೆ ತೋರಿಸುವ ಪೂರ್ವದಲ್ಲಿ ಸೋಣಿಸೋ ಕ್ರಯಪತ್ರವನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿ ರಿವಿಷನ್ ಅರ್ಜಿದಾರ 1 ಎಕರೆ 20 ಗುಂಟೆ ಇದ್ದು
ನಾಗರಾಜಪ್ಪ ಅವ್ರೆ RTC ದಲ್ಲಿ ನಿಮ್ದು 2 ಎಕರೆ ಇದೆಯಲ್ಲ,
2 ಎಕರೆ ಇದೆ, ಬಟ್ ಆರ್ಡರ್ ಆಫ್ ದಿ
2 ಎಕರೆ 1 acre 28 ಗುಂಟಸ್ ಕೊಟ್ಟಿಲ್ಲ ನಿಮಗೆ ಕಬ್ಜಾ ಅವರು. ಫೋಡಿ ಮಾಡಿದಾಗ ತತ್ಕಾಲ್ ಫೋಡಿ ನೀವೇ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಇನ್ನ ಹರಿ. At your instance, notice is ordered and in your presence it is subdivided.
ದಿ ಥಿಂಗ್ ಇಸ್ ನೌ ಮೈ ಲಾರ್ಡ್
And RTC is generated. ಯಾವಾಗಿದ್ದು ಫೋಡಿ ಯಾವಾಗಿದ್ರೆ ನೋಡಿ ಅವ್ರದ್ದು ನೋಡಿ ಅಲ್ಲಿ ಏನ್ ಬರೀತಾರ.
ಫೋಡಿ
ಆ
ಚೆಕ್ಕುಬಂದಿ ಎಲ್ಲ ಹೇಳ್ತಾರೆ ಅವರು. ಪೇಜ್ 34, 39
ಹಾ
ಪೇಜ್ 39 ದಿನಾಂಕ 1/10/2001 ಮೂರನೇ ಎದುರುದಾರರು ಮತ್ತು ಅವರ ಸಹೋದರರ ನಡುವೆ ಆದ ವಿಭಾಗ ಪತ್ರದಲ್ಲಿ 3ನೇ ಎದುರು ಭಾಗಕ್ಕೆ ಬಂದಂತಹ
3ನೇ ಎದುರುದಾರ ಮತ್ತು ಅವ್ರ ಸೋದರ ನಡುವೆ
ಚೆಕ್ಕುಬಂದಿ ಪೂರ್ವಕ್ಕೆ ರಸ್ತೆ, ಪಶ್ಚಿಮಕ್ಕೆ ನಿಂತಾಳಿ ಗ್ರಾಮ ಅವರ ಜಮೀನು, ಉತ್ತರಕ್ಕೆ ದೇವೇಗೌಡರ ಜಮೀನು, ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ.
ಟೇಬಲ್ ನಲ್ಲಿ ವಾಟ್ಸಪ್ಸ್ ಕೈಂಡ್ಲಿ ಸರ್, ಆ ಟೇಬಲ್ ನಲ್ಲಿ ಕೂಡ ಐಟಮ್ ನಂಬರ್ ಮೆಲಾಡ್ 5/8 ನಲ್ಲಿ 2 ಎಕರೆ ಅಂತ ತೋರಿಸ್ತಾರೆ. ಮೇಲ್ಮೇಲೆ ವಿಚಾರಣೆ ದಾಖಲೆ ಮತ್ತು ಸ್ಥಳೀಯ ಪರಿಶೀಲನೆಯಿಂದ ನ್ಯಾಯಾಲಯ ಗಮನಿಸಬೇಕಾದ ಅಂಶಗಳೇನೆಂದರೆ
ಅಲ್ಲೇ ಫೋಡಿ ಆಗಿದ್ದು ಯಾವಾಗ? 2000
ಅದು ಬಸ್
R17 page 51. It is indicated 25/1/2008.
ಎಲ್ಲಿ ಯಶವಂತ್
Islamic statement of officials R17 page 50.
15
50. 51.
ನಿಮ್ಮದ್ರಲ್ಲ
Statement of objection. ಅಲ್ಲಿ ಡೇಟ್
25/1/2008.
2000 ಆಗಿದ್ದು
18.
2018
ಅದಕ್ಕಿಂತ ಮೊದಲಿದೆ
18
ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಸರ್.
Bottom of the bottom.
25/1
ಅದಕ್ಕಿಂತ ಮೊದಲು ಅನೆಕ್ಷರ್ ಡಿ ನಲ್ಲಿ ಅನೆಕ್ಷರ್ ಡಿ ಮೆಲಾಡ್ ಇನ್ ಮೈ ರಿಟ್ ಪಿಟಿಷನ್ ಅದಕ್ಕಿಂತ ಮೊದಲಾಗಿದೆ ಇದು.
ನಿಮ್ ಗ್ರೌಂಡ್ಸ್ ಓದಿದ್ರೆ ಏನು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ನಾಗರಾಜಪ್ಪ ಅವ್ರೆ. ನಿಮ್ದೇನ್ ಗ್ರೀವೆನ್ಸ್ ಇದೆ ಹೇಳಿ.
ದಿ
ಆಯ್ತು ನಿಮ್ ಗ್ರೌಂಡ್ಸ್ ಓದ್ರಿ.
ಪ್ಲೇಸ್ಮೆಂಟ್ I read your lordship. Para 8 your lordship. Para 8.
ಓದಿ ನಿಮ್ಗೆ ಏನ್ ಅನ್ಯಾಯ ಆಗಿದೆ ಅಂತ ಎಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ.
This is the my lord, the grounds urged by me in para 8 and that is the only my lord. The difference is my lord, the deputy commissioner arrived at a conclusion saying that I am in a position of only 1 acre 28 guntas.
I don't think so. ಅದು ಬಂದಿಲ್ಲ ಆ ತರ.
ಅದನ್ನ ಒಂದು ಕ್ಲಾರಿಫೈ ಮಾಡಿ lordships may direct may will approach my lord. I am not
your owner in respect of 5/8
to an extent of my lord 2 acres.
5/8 You can't lay a claim over 5
But the document says 2 acres. Even my
And
deputy commissioner,
ಈಗ orally ನೀವು argument ಮಾಡಬೇಕಾದ್ರೆ you try to assert a portion beyond northern road, which
ಅಲ್ಲ,
divides both the survey numbers. You can't lay a claim over northern portion. Beyond road you have no, on the northern side. To the
ನನ್ನ
south
2
of-
ಎಕರೆ 2 ಎಕರೆ ಬರೋದಿಲ್ಲ ಸಮ.
ಅದು ಬರ್ಲಿಲ್ಲ ಆದ್ರೆ you have a different remedy. Who has encroached we don't know. ಇಲ್ಲ ನೀವು ಅವ್ರದ್ದು ತೋರಿಸ್ಬೇಕು, ನೀವು ಅವ್ರದ್ದು ಜಾಸ್ತಿ ಇರ್ಬೇಕಲ್ಲ. They have purchased only 1 acre 3 guntas. You have purchased 2 acre 5 guntas. ನಿಮ್ದು ಅದು ಗ್ರೌಂಡೇ ಇಲ್ಲ. ಬಿಯಾಂಡ್ ರೋಡ್ ನಮ್ದು ಬರುತ್ತೆ, ನಮ್ದು ಸ್ಕೆಚ್ ಅಂಡ್ ಸ್ಕೆಚ್ ಡಸಂಟ್ ಶೋ. ಸ್ಕೆಚ್ ಪ್ರಕಾರ ಟೇಬಲ್ ನೋಡಿದ್ರೆ 5/8 measures 2 acres.
ಅಲ್ಲಿ 1 ಎಕರೆ 28 ಗುಂಟಾಸ್ ಬರ್ತದೆ. ಅದನ್ನ ಹೇಳೋದು ರೋಡ್ ನಿಂದ ಆಚೆ ಇಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
ಕರೆಕ್ಟ್ ಇದೆ ಅದು. ನೀವು ಯು ಆರ್ ಲೇಯಿಂಗ್ ಎ
That
ಕ್ಲೇಮ್
is
ಓವರ್
the,
ಬಿಯಾಂಡ್
that's
ರೋಡ್.
it. That is the my lord, the crux of the issue.
ಅದು ಬರಲ್ಲ ಸ್ಕೆಚ್ ಪ್ರಕಾರ. ಬಿಕಾಸ್ ಟೇಬಲ್ ಪ್ರಕಾರನೇ ನಿಮ್ದು ಅದು 5/8 2 acre ಇದೆ.
ಸೇಲ್ ಡೀಡು
ವಿ ಡೋಂಟ್ ನೋ ಈಗ ಅದು ಯಾರು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿ. ನಿಮ್ ಪಕ್ಕದಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಈಗ? ಎಲ್ಲ ಕನ್ವರ್ಟೆಡ್ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್, ಅದು ಎಲ್ಲ ಡೆವಲಪ್ ಆಗಿಬಿಟ್ಟಿದ್ಯಾ?
ಡೆವಲಪ್ ಅಂತ.
ಆ?
I don't know exactly the topography of the area.
ಆಯ್ತು, ಬರ್ಕೊಡ್ರಿ.
But this, the order deputy commissioner should not come in my way, my lord.
ಅಲ್ಲ ಅವ್ರು ಎಲ್ಲೂ ನೀವು ನಾನು ನೋಡಿದೆ ಅದು ಇವ್ರ ತಪ್ಪು ಮಾಡಿದ್ದು, ಇವ್ರದ್ ಕಂಟೆನ್ಷನ್. ನಿಮ್ಗೆ
ಆದ್ರೆ ನನಗೆ ಇದು
ಅವ್ರದ್ದು 1 acre 28 ಗುಂಟಾಸ್ ಇದೆ ಅಂತ ಹೇಳಕ್ಕೆ ನೀವು ಯಾರು? ನೀವು ಹೂ ಆರ್ ಯು? ವಾಟ್ ಈಸ್ ಯರ್ ಲೋಕಸ್? ಯು ಶುಡ್ ಹ್ಯಾವ್ ಸೆಡ್ ದಟ್.
ಅವ್ರು ಹೇಳೋದು
ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಅವ್ರು ಬರ್ದು ಹಾಕಿದ್ರು.
ಅದೇ ಅದಕ್ಕೆ ಆಗಿದೆ ಅದು.
ಹೇಳೋದು 2 acres ಒಂದೇ ಅಲ್ಲ, 2 acres 8 ಗುಂಟಾದಲ್ಲಿ ಇದ್ದೀನಿ, ಇನ್ನ 3 ಗುಂಟೆ ಜಾಸ್ತಿ ಇದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ದಟ್ ಇಸ್ ದೇರ್ ಕಂಟೆನ್ಷನ್. ನಾಟ್ ಓನ್ಲಿ 2.5, 2.8 ನಲ್ಲಿ ಇದ್ದೀರಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರೇ. ದಟ್ ಇಸ್ ದೇರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್. ಐ ಆಮ್ ಇನ್ ಎ ಲಾರ್ಜರ್ ಎಕ್ಸ್ಟೆಂಟ್.
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಅವರು ನೋಡಿ. ಆಮೇಲೆ ಇದು ನೀವು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದೆ ಹೇಗೆ ಹೋಗ್ತೀರಾ? ಇದು ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಲ್ಯಾಂಡ್ ರೆಕಾರ್ಡ್ಸ್ ಮುಂದೆ ಹೋಗಿ. ದೇ ಆರ್ ದಿ ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿ.
Please.
ಐ ಥಿಂಕ್ ಡಿಸಿ ಬೈ ಟೆಕ್ನಿಕಲ್
49 ನಲ್ಲಿ ಅಲ್ಲಿ ಮಾಡಿದ್ರು ಎಸಿ ಹತ್ರ. ಇಲ್ಲಿ 56
ಡಿಸಿ ಬೈ ಯಾರು? ಟೆಕ್ನಿಕಲ್
ಟೆಕ್ನಿಕಲ್.
ಡಿಸಿ ಟೆಕ್ನಿಕಲ್ ಅಂದ್ರೆ ಎಸ್ ಕರೆಕ್ಟ್.
ಡಿಸಿ ಅಲ್ಲ ಇದು.
ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಲ್ಯಾಂಡ್ ರೆಕಾರ್ಡ್ಸ್.
38 ಪೇಜ್ 38 minute.
ಅವರು
ಟೆಕ್ನಿಕಲ್
ಏನ್
ಅಸಿಸ್ಟೆಂಟ್.
ಬರ್ತಿದ್ದಾರೆ, ಏನ್ ಬರ್ತಿದ್ದಾರೆ ಮಂಜುನಾಥ್?
ಟೆಕ್ನಿಕಲ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮ್ ಮೈ ಲಾರ್ಡ್ ಪದನಿಮಿತ್ತ ಬುಧ
ಹಾ, ಏನ್ ಬರೀತಾರ ಅವರು?
38.
ನೋಡಿದೆ, ಓದಿದ್ರು ಬಿಡಿ. ಕೂತ್ಕೊಳ್ಳಿ ಸರ್. This petition is filed. Appealing the order passed by second respondent. Order passed by third respondent. ಯಾರು ಮಾಡಿದ್ದು?
It's a technical assistant come my lord, the deputy director my lord, ಭೂ ದಾಖಲೆಗಳ ಉಪನಿರ್ದೇಶಕರು. Page 38 annexure K.
ಅಲ್ಲ, 2 orders you have challenged.
Please my lord, that is the first under section
Annexure
49
ಎಲ್ಲಿ ಯಾರ್ದು? Annexure ಎಲ್ಲಿ ಯಾರ್ದು?
annexure L is the deputy commissioner.
ಹಾ,
That is under section section 56 ಅದು. ಇದು 49.
ಅಲ್ಲಿ ಯಾರು ಆರ್ಡರ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ?
Both the orders my lord, both the orders.
ಅಲ್ಲ, ಬಟ್ ಅದು annexure K is ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ರೀ. ಮತ್ತೆ ಏನದು ಯಾವ ಪ್ರೊವಿಷನ್ ಕಡೆ ಎರಡು ಹೇಗೆ ಬರುತ್ತದೆ? By
ಜಿಲ್ಲಾಧಿಕಾರಿ
deputy commissioner and the other is by technical assistant to deputy commissioner. ಎರಡು ಆರ್ಡರ್ ಹೆಂಗ್ ಬರುತ್ತೆ?
Sure.
ಆಮೇಲೆ ಟೆಕ್ನಿಕಲ್ ಅಸಿಸ್ಟೆಂಟ್ ಟು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್ ನೀವು ಮತ್ತೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಮುಂದೆ ಬರಲ್ಲ.
is also my lord,
ಆ ಟೆಕ್ನಿಕಲ್ ಅಸಿಸ್ಟೆಂಟ್ ಅಂದ್ರೆ ಅದು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್. ಅದು ನಾಗರಾಜಪ್ಪ ಅವ್ರೆ,
placement.
ಎರಡು ಆರ್ಡರ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್.
ಪದನಿಮಿತ್ತ ಭೂ ದಾಖಲೆಗಳ ಉಪನಿರ್ದೇಶಕರು.
ಟೆಕ್ನಿಕಲ್ ಅಸಿಸ್ಟೆಂಟ್ ಅದು ಯಾವ್ದು ಆರ್ಡರ್ ಅದರಲ್ಲಿ? ಅನ್ನೆಕ್ಸರ್ ಎಲ್ಲ ಕೆ is by the technical assistant. Oh, Tantriko. Okay.
ತಾಂತ್ರಿಕ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ತಾಂತ್ರಿಕ ಸಹಾಯಕರು ಹಾಗೂ ಪದನಿಮಿತ್ತ
Petitioner in the caption petition as assailed, the order passed by second respondent, wide annexure K. And the order passed by first respondent deputy commissioner, wide annexure L. By the counsel for petitioner, learned counsel appearing for respondent number 5, learned SCGP appearing for respondents 1 to 4. Next, facts leading to the case are as under. Petitioner is asserting his title to an extent of 2 acres, 5 untas. Petitioner asserts that the erstwhile owner sold 2 acre 5 untas in survey number 5/2, totally measuring 3 acre 11 untas. Wide registered sale date dated 5/8/1968. Petitioner is aggrieved by the orders passed by respondent number 2 and 1, respondent number 1, on the premises that that the Tatkal 4D conducted in 2018, Allah,
Yes, sir.
is contrary to title documents.
2018 ಅಲ್ಲಿ ಆರ್ಡರ್ ಬಂದೆ 2017 ಬಟ್ ಆರ್ಡರ್ ಆಫ್ ದಿ ಅನೆಕ್ಸರ್ ಕೆ ಇಸ್ 2017
ಇದು sketch ಯಾವಾಗ ಆಯ್ತು ಪ್ರಿಪೇರ್?
ಅದು ಬಸ್ ಸ್ಕೆಚ್ ಆಗಿರೋದು 18.
25?
2008. As per annexure R
2008
2018.
18 ಅವ್ರು ಹೇಳೋದು ಇದು ಓಕೆ ಆರ್ಡರ್ ಬಂದಿರೋದು ಅನೆಕ್ಸರ್ ಕೆ ಇಸ್ 2017.
ಗೊತ್ತಾಗಲ್ಲ. ಏನ್ ಬದ್ರಿ ಮೇಡಮ್? Tatkal conducted, which is evidence at annexure J. Petitioner in the caption petition is laying a claim beyond the east-west road towards northern side. Next paragraph. On closer examination of records, it is clearly evident that petitioner owns 2 acre 5 untas, while respondent number 5 owns 1 acre 5 untas, Allah?
1 acre 3 guntas.
1 acre 3 untas. At the instance of petitioner, a Tatkal 4D was conducted by the authorities. The 4D proceedings are evidenced at annexure J. The land held by petitioner to an extent of 2 acre 5 untas is subdivided and reassigned a new survey number as 5/8, while private respondent number 5, respondent number 5's property is assigned new survey number, is retained old survey number as 5/2. Between the properties held by petitioner and the 5th respondent, a road runs east-west. Therefore, the 4D conducted by the authority clearly reveals that petitioner's property is situated to the south of the road, while 5th respondent's property bearing survey number 5/2 is situated beyond on the northern side of the road. Both the properties is separated by a east-west road. The 4D, Tatkal 4D also reveals that petitioner's extent held is clearly reflected in the table as 2 acres 5 untas, while 5th respondent's extent is reflected as 1 acre 3 untas. Respondent number 5, along with the statement of objection, has placed on record the RTCs pertaining to survey number 5/8, evidenced at annexure R11. Original of the same, the petitioner's extent reflected in survey number 5/8 is 2 acres, and the total extent is shown as 2 acre 8 guntas, while 7 guntas is shown as a Port Kharab. The RTC generated subsequent to 4D proceedings and reassignment of the property held by petitioner as 5/8 and the entries reflected and the extent reflected in RTC pertaining to 5/8 clearly aligns with the 4D proceedings evidenced at Annexure J. Next, the fact that petitioner, contrary to 4D proceedings, is laying a claim over the northern portion of the road indicated in Annexure A clearly gives an indication that petitioner is laying a claim in 5/2. Subsequent to 4D, new RTCs are issued to respective parties, their extents are clear, and both the properties are clearly separated by a east-west road. Next, though counsel for petitioner has placed to emphasize on the reasoning assigned by the authorities, this court is not inclined to accede to the said arguments. Petitioner's apprehension that fifth respondent is disputing is titled to an extent of 2 acres, 5 guntas, 2 acres in survey number 5/8 is also misconceived. Though in the arguments tendered by private respondents, a contention is raised that petitioner is in possession of only 1 acre 28 guntas. However, this contention is of no consequences. The fact that 4D proceedings have stood concluded and petitioner's extent is rightly reassigned afresh survey number as 5/8, thereby reflecting extent as 2 acres, will lead to an inference that petitioner, as pursuant to 4D proceedings, has retained 2 acres in survey number 5/8, unless there are tangible evidence to substantiate that the respondent has tried to encroach over southern portion of the land which is reassigned 5/8. This court is not inclined to grant any indulgence. Next, if at all petitioner is aggrieved by any encroachments, petitioner has to approach civil court and substantiate the encroachment and seek appropriate relief in the manner known to law. However, at this juncture, this court is not inclined to interfere with the 4D, which has stood concluded and is acted upon by issuing separate RTC pertaining to petitioner's property bearing survey number 5/8 and fifth respondent's property bearing survey number 5/2. Writ petition is divided up and it's for instant dismissed.
The observation will not come in the way.
ನಾನು ಏನು ಬರ್ದಿಲ್ಲ ನಿಮ್ಮ against ಏನು ಬರ್ದಿಲ್ಲ.
ಅಲ್ಲ ನೀವು ಅಬ್ಸರ್ವ್ ಮಾಡಿದಿರಲ್ಲ ಅಬ್ಸರ್ವೇಷನ್. I filed a suit, my lord, this.
ಅದೇ ನಾನು ನಿಮ್ಮ
Observation
against ಏನು ಮಾಡಿಲ್ಲ.
That should not, my lord.
ಏನು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದೀನಿ ಹೇಳಿ ಅದು
ಅಲ್ಲ, that's wrong. 1 acre 28 gunta ಅಂತ ತಾವು again your lordship has said. I am in possession of only 1 acre 28.
ನಾನು ಅಂದಿಲ್ಲ ಅದು that is of no consequence ಅಂತ.
ಅದನ್ನ ತಾವು.
That is in your favor. That observation is in your favor. If there is a reduction in your extent, there has to be a measurement, spot inspection agi bandre you seek possession from them. 46.
I appear for respondents. Sir, office objections in respect of wakalat. I'll clarify and
You are not rectified. Even today you are not rectified.
no, kindly grant some time here.
What is this? What rectification on wakalat?
Because
All right, finally week's time is granted to respond number.
I am too many respondents are there.
He is for respondent 27, 28, 40 and 54.
Appearing for respondents to rectify the office objection raised in the wakalat. Yes.
Now, so far as this is respondents are concerned, there are altogether 61 respondents, my lord.
Ah.
13, 14, 52, 46, 58, 15, 37, 48,
ಇದಕ್ಕೆಲ್ಲ
33.
ನೋಟಿಸ್ ಹೋಗಿದ್ಯಾ?
ಎಲ್ರಿಗೂ ನೋಟಿಸ್ ಹೋಗ್ಲಿಲ್ಲ, ಹೋಗ್ಬೇಕು.
Issue notice on LR
ಇಲ್ಲ
application.
application. And
They have to be paid within 3 days.
my lord, one application is filed for paper publication in respect of
18A, 35A, 51A,
ಎಷ್ಟ್ ಸರಿ ನೋಟಿಸ್ ನೋಡಿದ್ದೀರಲ್ವಾ ಅವ್ರು?
ಒಂದು 3 ಸಾರಿ ನೋಟಿಸ್
3 ಸರಿ ತಗೊಂಡಿದ್ದೀರಾ? ಕರೆಕ್ಟ್
ಹೌದು,
ಅಡ್ರೆಸ್
notice.
ತಗೊಂಡಿದ್ದೀರಾ? ಅದು ನೀವು ಯಾವ ಟು ಫರ್ನಿಶ್ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಅಂತ ಬಂದಿದ್ರೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಇಲ್ಲ.
ಎಲ್ಲ ಸೇಮ್ ವಿಲೇಜ್ ನಲ್ಲಿ ಇರೋರೆಲ್ಲ.
ಏನಂತ? ಹಾ, ಫಸ್ಟ್ ಸ್ಟೆಪ್ಸ್. ಅದು ಯಾವ್ದು ಅದು?
IA number 1 of 24 ಅದು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ಗೆ. It was filed on
Deferred. Application filed in I number 1 of
24.
is deferred for time being. Petitioner is directed to take first steps by furnishing correct addresses. In the event he is able to substantiate that the respondents are deliberately evading the notices, the application filed in I-1 of 24 will be considered
Please.
at later stage. Yes. 47. Non-amendment test. Propose. Yaru. Finally, week's time to amend the cost title. Or ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಆಫೀಸ್ ದವರು ಮಾಡಬೇಕಲ್ಲ. ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಯು ಡಿ ನಾಟ್ ವೇಟ್. 14 days ವೇಟ್ ಮಾಡಬೇಕು, ನೀವೇ ಮಾಡಬೇಕು. 14 days ಏನಿದೆ ಸಿಲ್ಫ್ ಪ್ರಾಕ್ಟೀಸ್. ರೀಡಿಂಗ್ಸ್ ಮಾಡಕ್ ಬರಲ್ಲ, ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇದ್ರೆ ಮಾಡ್ಬಿಡು. Alright, finally 1 week. Yes, Mr. Ganpati.
In this case, application lot for vacating the interim order lot. But the copy is served now, my lords, kindly, my lords.
And for respondent 4 copies. What is served now?
Copy of the vacating application lots.
ನೀವು ಯಾರಿಗೆ?
And for the respondent 5 lots.
Vacating ಯಾರು? ನೀವು ಹಾಕ್ಬೇಕು vacating.
ನಾವು ಹಾಕಿದೀವಿ,
ಅವ್ರು
ನಾವು
ಹಾಕಿ
ಹಾಕಿದೀವಿ, copy serve ಮಾಡಿಲ್ಲ, but I have served the copy.
You
just know there.
And the office objection may be word. Office objection may be.
Copy of the vacating application is served on the council appearing for petitioner. Office objection does not survive for consideration. Next.
Interim order may be extended.
Interim order granted early.
Some date will be fixed lots.
Order 3 ವಾರ ಆದ್ಮೇಲೆ ಕೊಡ್ರಿ. Next. Next.
4th
March. 4/3. Non-filing for having served copies. ಬಂದಿದ್ಯಾ ಮಂಜುನಾಥ್? ಮಂಜುನಾಥ್ ಕಾಪಿ ಸರ್ವ್ ಆಗಿದ್ಯಾ? ಮಾಡಿದಾರಾ?
Yes, madam.
All right. Learned AG acknowledges the receipt of copies. Office objection does not survive for consideration. Next. Yes, Manjunath Prasad. Listed in preliminary along with office objections. On.
So office objection is required to be overruled, madam.
Adhe this smart bidola. Manjunath. Will list it in preliminary.
Because endorsement has issued, no proceedings papers are available in the Tahsildar office. As such, he has issued endorsement, but office has issued to secure the proceedings copies. So that office is good to.
Adhe this nona.
Date may be.
Yes. Next.
Please.
51 same. List it along with the.
Served the copy on KV. That is.
ಮಾಡಿದೀರಾ? ಅದು ಒಂದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
ಗೌರ್ಮೆಂಟ್ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ನಾವು ಫೈಲೇ ಮಾಡೋದು.
ಅದು ಆಗಿದೆ.
ಅದು ಆಗಿದೆ.
Served,
KVT I have served. I have served through WhatsApp and also email.
Copy of petition is served on the cavator. Acknowledgement is placed on record. Acknowledgement is placed on record. Office objection therefore does not survive for consideration. Listed in preliminary. Urgency?
Urgency this one.
Order. ಇವತ್ತು Tuesday ಅಲ್ಲ? Today is Tuesday or Monday?
Monday.
Monday. ಬುಧವಾರ.
Sir.
Listed in preliminary.
ಗುರುವಾರ.
Thursday.
Thursday.
Next.
I filed an application for amendment in the judgment. There is a typographical error. Survey number 353 is mentioned in 352.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ ಸುಮ್ಮನೆ ಏನಿಲ್ಲ. Para 5, para 3. Sorry, para 5, page 5.
ಯಾವುದು para 5?
It is.
Para 5 ಅಲ್ಲಿ ಮಾತ್ರನಾ? Para 5 ಅಲ್ಲಿ ಮಾತ್ರ.
ಅಷ್ಟು ಮಾತ್ರ ಇದೆ.
At para 5, the judgment, there is error in mentioning correct survey number.
352.
It is wrongly mentioned as
353 instead of 352.
It is wrongly mentioned as 353 instead of 352.
352. In fact,
Therefore, an application is filed under section 152
of the
of Civil Procedure Code, accepting the reason. This court is of the, I1 of 25 is allowed. Since there is a typographical error at para 5 of the judgment,
That's all.
registry to issue corrected copy.
In fact, the sale has been executed in respect to 352.
ಆಗಿದೆ. Yes.
You have entered appearance, my lords. The person who is sought to be impleaded, my
Ah.
lords, was the appellant, my lords, who had questioned, my lords, the change of revenue entries in my name. He was not impleaded to the petition.
You
It
have to
is-
take notice now, Ajit.
ಅಲ್ಲ ಅವರಿಗೆ notice ಜಾರಿ ಆಗಿದೆ sir.
ಆಗಿದೆಯಾ?
He has been served also.
Impleading applicant is served,
He is served.
and unrepented. There is no contest to this impleading application.
Yes.
Caution is accepted. I1 of 24 is allowed. Petitioner to implead the proposed impleading applicant as respond number
5.
5.
We are
Petitioner's
in-
counsel to forthwith amend the cost title physically. Amended cost title is filed today. Same is taken on record. Yes.
Lords, may I seek one indulgence?
Yes, sir.
Lordship may kindly assign a date, because my lords, I have to concede that this order has already attained finality. I'll make my submissions. I won't trouble my lords.
Partner.
On any date, my lords.
ಬುಧವಾರ.
ಆಯ್ತು.
Partnered.
May I seek a date next week,
ತಗೊಳ್ಳಿ. Partnered next, when you want, date,
next Wednesday?
next one.
I appear for the petitioner. I
Yes.
have made this application to amend the petition by incorporating the subsequent developments. The fourth respondent has filed a suit for declaration.
ಯಾರು contesting ಯಾರು ಇದಕ್ಕೆ?
4B has been represented by an advocate. So far as 4A is dead, 4B to D are the legal representatives. I am filing a memo to that effect.
ಯಾರು? Who are the LRs?
4B to D are the LRs of 4A.
Or C to 4D?
4A is dead.
ಹಾ.
So far as fifth respondent
ಈಗ
is,
notice to 4C and 4D ಅಂತ ಬಂದಿದೆ, land R5.
ಅಲ್ಲ 4A is dead, ಅದು steps ತಗೋಬೇಕು ಅಂತ ಬಂದಿದೆ.
That may not be because
Not
the LRs
necessary.
are already.
B to D are the legal representatives.
But 4C, 4D ಇನ್ನೂ notice ಹೋಗ್ಬೇಕು.
CD ಗೆ ಮಾತ್ರ steps ಹೋಗ್ಬೇಕು. B is represented by an advocate.
Or B is reported.
Advocate.
Respond number 4 is reported to be dead. Memo is filed indicating that,
So far as C and D is concerned, I am take steps.
memo is filed indicating that respondents 4B to 4D are the
Legal
surviving-
representatives.
surviving legal representatives, and they are
Oh.
already on record accepting the memo. Petitioner is
Let me
hereby
kindly-
directed to amend the cost title
Yes.
for fresh steps to 4C and 4D and R5, a week's time.
R5 ಗೆ I am filing a memo to the effect that she is neither necessary nor a proper party. She doesn't claim any interest or reward.
ಆಯ್ತು, ಬರೇ fresh steps to 4C.
I
and
filed a
4D.
memo to delete R5.
ಆಯ್ತು, fresh steps to 4C and 4D by a week. Insofar as R5 is concerned, a memo is filed seeking deletion
For R5 delete.
on the ground that
He is
he's not at all a necessary
he is
party. and
neither a
not-
proper nor a necessary.
At the risk of petitioner, memo is taken on record. Respondent number 5 is ordered to be deleted. Petitioner counsel to forthwith amend the cost title.
An amendment application, it can be,
Other to be heard as on.
a date may be given.
All right. I1 of 24 to be heard along with the main matter. District on so and so date. Indeed.
Date please.
Date what? What the?
I2.
Yes, next. Ian earlier Ingrid.
For R4 minutes.
I'm for petitioner, my lord.
I am for the pleading applicant.
My lord, seeking time to file objection for impleading application, my lord.
All right, 2 weeks time to file.
And
objection
one
to-
more submission, my lord. There is another petition is there, that is petition number 101021.
Registry to tag this writ petition along with WP number, birth coding.
21. And this interim order to be extended.
Extended, entry board granted, early is extended.
My lords,
Next.
I'm for the petitioner and 56, my lords. We have filed a recalling application for recalling the order dated 25/11/2022, my lords.
ಏನದು recalling, madam?
My lords, this matter.
ಎರಡಕ್ಕೆ ಹಾಕಿದ್ದೀರಾ?
One has,
Why 2 recalling applications are filed?
my lords, one is for condonation of delay, my lords. One is for recalling, this is a
Yesterday,
transfer.
344 days, why?
My lords, this is a transfer brief, my lords, for us, and the matter was dismissed for non-prosecution as we had not complied uh, this one, my lords, office objections,
Non-compliance, huh?
non-compliance.
Cost ಎಷ್ಟು?
As a lordship.
1,000. Clerk fund. Worked, though there is inordinate delay of 344 days, bearing in mind the valuable rights of the parties, this court is inclined to condone the delay. Accordingly, I-1 of 24 is allowed. Delay of 344 days is condoned. Consequently, I-2 of 24 is allowed, and the writ petition is writ petition is restored on file, subject to petitioner paying a cost of 1,000 to clerk's fund. Yes. ಅಲ್ಲಿ ಕಂಪ್ಲೈಂಟ್ಸ್ ಮಾಡ್ಬೇಕಲ್ಲ ಮೇಡಮ್, ಫೈನಲಿ 2 weeks time to remove office.
And for the fifth respondent.
By the impugned order, my lord, B Karab, A Karab is converted into B Karab by the state just to accommodate him. Under what power, till that nobody is able to explain, my lord, under what power state gets the authority to convert the land from A Karab to B Karab?
ಬರಲ್ಲ, ಮಾಡಕ್ ಬರಲ್ಲ.
Yena B Mautar, kindly see the impugned order.
Is
Belongs to me. Just because they have granted land to him and they are not able to identify where the land is, land na convert Mautar, government land.
ಏನ್ರಿ ಬೇಡ?
Last occasion, my learned friend informed that it is, they are nowhere concerned with the property of the fifth respondent.
ಈಗ they are agreed by conversion of their A class. A class is the ownership of land and you have no right unless they are able to show that it is a B Karab. Yes.
I'll file my statement of objection.
Everybody else has.
ಏನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ತೀರಾ? ಏನ್ ಹಾಕ್ತೀರಾ?
Because as per.
ಏನ್ ಎಂಕ್ವೈರಿ
State
ಮಾಡಿದ್ದೀರಾ?
has already filed its statement of objections.
Sir,
my lord.
Huh?
State has already filed its statement of objections. They have not explained under what authority.
Fifth respondent only filed.
My vendor is granted 26/1. It is coded, my lords would find that body work, my lord, it's simple, my lord, I will not trouble, my lord. At page 38. It is abutted by Karab land, which is classified as B Karab. Notice is issued. I file a writ petition before this court seeking my entry because I purchased the property. They then realize, my lord, that they have granted 1 acre to him in survey number 26, not 26/1. To accommodate him, the impugned order is passed, whereby saying, my lord, that A Karab, my land is classified into B Karab, will justify this action.
ಅದು ಈಗ ಎಲ್ಲಿದೆ ಅದು? ಏ ಖರಾಬ್ ಅಂತ ತೋರ್ಸಕ್ ನಿಮ್ಮ ಹತ್ರ ಆಕಾರ
My
ಬಂದಿರ್ಬೇಕು.
lords may see the impugned order itself, my lord. There in page 97.
Oh, they are asserting that they have converted.
Oh, converted it to B Karab. ಒಂದೇ ಲೈನ್ ಓದ್ತೀನಿ ನೋಡಿ.
Admitted that it is.
In survey number 26/1, A Karab to an extent of 3 acre 20 guntas to record and enter as B Karab and issued orders.
ಎಲ್ಲಿದೆ ಅದು?
Page 97, my lord. Last but one page, my lord, just before the vote.
ಯಾರು ಆರ್ಡರ್ ಮಾಡಿದ್ದು?
ADLR, my lord. Just because I file a contempt petition, my lord, this is being done.
97
Last 3 lines, my lord.
ದುರಸ್ತಿ.
First line end in the survey number 26/1,
ಪೇಜ್ ಅಲ್ಲಿ
page 97, my lord.
97.
First line and last line, survey number 26/1. A Karab, extent of 3 acre 20 guntas to record / enter as B Karab and issue orders. Hence 26/1 is put into part separate. And now what they do is, my lord, when they do a body work in 83, it's a single block. You got illon block, illon block, illon block. Just to more blocks separate. Earlier body work is taken away without application, just to accommodate him.
You kind of file.
Huh?
A day may kindly be fixed.
ಅಲ್ಲ, ಬಟ್ we have to take action against this gentleman.
I will convince.
ಅಲ್ಲ, ನೀವು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಅದು ಏ ಖರಾಬ್ ಇದೆ, ನಾ ಕನ್ವರ್ಟ್ ಮಾಡ್ತಾ ಇದೀನಿ ಅಂತ.
Maybe under threat of
ಏನ್ರಿ?
contempt.
ಆ?
Maybe under the threat of contempt, some wrong things have happened. I'll
ನೋ,
convince.
ನೀವು ಅದು ಪಟ್ಟ ಲ್ಯಾಂಡ್ ಅದು.
Yes, I'll convince her with records. I'll secure records.
Ordered, parted at the request of learned AGA. Really this matter in preliminary. Yeah, short point ಇದೆ. On so and so day. Yes. ಪಾಪ ಅವ್ರಿಗೆ ಗ್ರಾಂಟ್ ಮಾಡಿದಾರೆ, ಹುಡುಕಿ ಯಾವ್ದಾರ ಒಂದು ಜಮೀನ್ ಕೊಡ್ರಿ.
All along it has been granted along with Karab only.
ಇಲ್ಲಿ ಕಣ್ಮುಚ್ಚಿ
But it is
ಕೊಡ್ತೀರಾ ಆಮೇಲೆ.
A or B Karab. has
Can
to
you
be-
say that forest land, ಗುಂಡು ತೋಪು?
Yes, my lord.
Now you have started
Second,
even,
even B Karab land has been
so ಈಗ
given.
private land to rob, you have started robbing private land ಈಗ.
My lord, along with their Hiduvali land, it is run with the Karab land only. Karab anta all along their record speaks.
ಅಲ್ಲ, ಈಗ ಅವ್ರು ಏ ಖರಾಬ್ ಅಂತ ಹೇಳೋದು ADL.
ಅದೇ A Karab, B Karab ಅನ್ನೋದು I have to convince.
RTCL A Karab ಅಂತ ತೋರಿಸಿದ್ದಾರೆ, ಅವ್ರು ಆರ್ಡರ್ A Karab ಅಂತ ಹೇಳ್ತಾರೆ.
RTCL reflect.
Then you have to follow that rule 122 ಅಲ್ಲ? 122.
122.
122.
Yes.
Yes.
Records ಸಾಕಾರ ಬಂದಂಡ್
ಕೊಡ್ರಿ. ಆಯ್ತು, ಆಯ್ತು.
records will.
Obliged.
What is the date, sir? For petitioner, madam.
58,
Council on record, Dodama passed away last night. Request to.
Appearing for respondent number 4, my lord.
Order.
Kindly pass over, my lord. Senior counsel is engaged in this matter, my lord.
no, he says council on record has passed away.
ಅಲ್ಲ ಅವ್ರು ದೊಡಮ್ಮ ತೀರೋಗಿದ್ದಾರೆ ಲಾಸ್ಟ್ ನೈಟ್ ಅವ್ರು ದೊಡಮ್ಮ
ಯಾರು ತಿರುಗಿದ್ದಾರೆ?
ಮುನ್ರೆಡ್ಡಿಸ್ ದೊಡಮ್ಮ ಮೇಡಮ್ ಪಿಟಿಷನರ್ಸ್ ದೊಡಮ್ಮ
ಹಾ.
ಅಡ್ವೊಕೇಟ್ಸ್ ದೊಡಮ್ಮ
ಯಾರು?
ಪಿಟಿಷನರ್ ಅಡ್ವೊಕೇಟ್ ದೊಡಮ್ಮ ತೀರೋದು ಲಾಸ್ಟ್ ನೈಟ್.
ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
ಹೌದು ಸ್ವಾಮಿ. There is a stay from long time.
Already then we wait for another 1 week, no?
Humble request, my lord.
ಅಲ್ಲ ಈಗ ಅವ್ರ ಮನೆಯಲ್ಲಿ bereavement ಇದ್ರು ನಿಮಗೆ
ಅಲ್ಲಿ ಇದಾರೆ
you are objecting?
No.
ರಿಮೆಟ್ರಿ ಫಂಕ್ಷನ್ ಅಲ್ಲಿ
Kindly have it on Wednesday or tomorrow.
12 to.
ಇಂಟ್ರಿ ಆರ್ಡರ್ ಮೇ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಮೈ ಲಾರ್ಡ್.
My lord, short date, man. Wednesday or tomorrow.
Interim order granted early is extended till next date of hearing.
Please, my lord.
ಯಾರಿದು?
The impleading
Impleading application ಯಾರು ಹಾಕಿದ್ದಾರೆ ಸರ್?
My lord,
ಯಾರು
Who
ಅಪ್ಲಿಕೇಶನ್?
has filed impleading application?
myself, plead.
Notice ಹೋಗ್ಬೇಕಾ ಹೋಗಿ ಬಂದಿದೆಯಾ?
ಅಲ್ಲ ಇವರು he is representing in dual capacity. He is already on record as a power of attorney. Now he is made as a party as an individual. It is whether my learned.
Allow ಮಾಡಿ. Allow ಮಾಡ್ಬೋದಾ? ಬರ್ಕೊಡ್ರಿ. Keyword respondent is reprinted by the impleading applicant is already appearing as the GP order of keyword respondent.
ಹೌದು.
Counsel appearing for keyword respondent concedes the application file.
I filed KVT in respect of proposed respondent Venkatesh 23. The caused it, they have shown wrongly, my lord. Therefore,
ಏನಾಗಿದೆ ಅದು?
21 ಅಂತ ಹೇಳಿ ಹೇಳಿದೆ. 21 ಅಂತ ಹೇಳಿ ಹೇಳಿದೆ. Cause list. Appear for 21. 23 ಅಂತ ಹೇಳಿ ಮಾಡಿದೆ.
ಅದು 21 GP order of 21 ಅಂತ 23 ಆಗ್ಬೇಕು.
ಆಗ್ಬೇಕು.
keyword respondent number 23 ಅದು. Madam, ಗೊತ್ತಾಯ್ತಾ? 23. Application, since there is no contest to I1 of 25, same is allowed. Petitioner to implead the proposed impleading applicant has respond number
23,
23.
23, my lord.
23 already ಇದಾರೆ ಈಗ.
23 already
One
ಇದೆ
minute.
ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲ 23.
ಇಲ್ಲ
23
23 ಇದ್ದಾರೆ, 22 ಇದ್ದಾರೆ.
ಸೊ ಅವರು 22 ಅಪೇರ್ ಆಗೋದಾ ಈಗ GP holder ಗೆ?
23. ಈ proposed respondent ಗೆ KVT ಹಾಕಿ.
ಈಗ 23 ರೀ.
ಹೌದು.
ಅಲ್ಲ ನೀವು ಅಪೇರ್ ಆಗೋದು GP holder
ಅವರು 21 ವರೆಗೆ.
ಕರೆಕ್ಟ್
ಇಲ್ಲ ಇಲ್ಲ 21 ಗೆ ಒಂದು.
To implead him as respond number 23.
ಇವಾಗ 23
ಈಗ
lordships.
23.
23.
23.
Council on record shall forthwith carry out amendment physically to file amended cost settle 1 week's time.
In the meantime, may I request my lord, last time, of course, my learned friend appeared, all these things happened. After 24 years, the mutation, everything stands in my name. After 24 years, they pass an order, Assistant Commissioner,
All right, list it in preliminary.
my lord,
Preliminary, list it in preliminary on so and so date.
please. Great.
ಇಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ನನಗೆ ಇದು ಅವರು ಇಂಪ್ಲಿಡಿಂಗ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕೊಳ್ಳಿ. ಡೇ ಆಫ್ಟರ್.
They make a submission in list number 2, my lord. Serial number 9, my lord. I appear for the petitioner. CMP, I have some personal inconvenience in the afternoon, my lord. If I kindly be called on Friday, my lord.
9 ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆಯಾ?
Second list, my lord. CMP list, my lord. I have some inconvenience today, my lord. Any other days?
Madam, 2017 matter.
Yes, my lord. My lord, I have only got it restored back to file, my lord. A writ petition was disposed of, giving me liberty to revive the CMP. CMP is now revived. It's a very old matter. I only have an urgency. Today I have some inconvenience. 7, obliged.
My lord, serial number 10, list 2. Short accommodation may be granted, my lord. For respondent number 3.
You have to wait
Okay, my lord.
and you have to read the file.
Yes, my lord.
You have gone through the file.
No, my lord, senior is not.
Better read. Skip your lunch and read the file. No adjournment, 2009 matter.
Seven.
ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ?
Serial number 3. Pass over ಆಗಿ ಹಂಗೆ ನೋಡಿ ಸರ್ 3.
22/1/2025,
ಮೆಮೊ ಅದಲ್ಲ. I have extra copy.
where you filed it in the office?
I filed it in the office
That's all.
with 31st is. Extra. Extra.
Yes, sir.
Para 2, my lord. My lord, they are claiming under Muni Madhurappa is the original grantee. They are claiming daughters and their legal heirs. My lord, son of Muni Madhurappa by name, Muniappa sold the property to one Madhurama under the sale deed dated 3/7/1974. Same portion of land, they sold it in 3/7/2004 to Madhurama. In turn, that Madhurama and Venkatramana sold the land to one A.C. Munikrishnappa on 29/3/1995. Thereafter, my lord, A.C. Munikrishnappa sold the aforesaid land to one Suresh Kedia on 26/10/2004. Thereafter, Suresh Kedia sold the land in favor of Arish. Subsequently, the petitioner herein, Mr. Respondent number 6A, who claims to be legal heir of Pillakaima, that is K. Narsimaya, has executed a confirmation deed dated 5/4/2008 in favor of the said Arish. The same extent of land. Then the said Arish applied for the POD of 2 acre 20 guntas. He got the POD done by official memorandum 7/8/2019 and it was assigned survey number 140. He in turn, that Arish sold the property to DX Max. My lord, important is, I'll come, page number 57.
Who are the private respondents now?
Private respondents 6A, they are claiming under Muni Madhurappa, the legal heirs of Muni Madhurappa. The 6A is a Narsimappa. The same Narsimappa executes a confirmation deed there, saying that, my lord, the family tree, whatever they are producing it everywhere, is a totally a misconceived family tree. Muni Madhurappa had a son.
You're not aware of this 5/4/2008.
My lord, I was not aware when the last date of hearing, we had a survey sketch. I produced the survey sketch. I could not get the document. Meanwhile, after granting this time, I went to searched it. I got all these documents within 2-3 days. My lord, kindly see the page number 57. My lord. This is POD sketch 2/1/2020. The grantee name, Muni Madhurappa bin Siddha. ಯಾವಾಗಾದ್ರೂ ಕರ್ದ ಆದಾಗ ಗ್ರಾಂಟಿ ನೇಮ್ ಒರಿಜಿನಲ್ ತೋರಿಸ್ತಾರೆ. ದಟ್ ಈಸ್ ಮುನಿ ಮಧುರಪ್ಪ ಬಿನ್ ಸಿದ್ದ. ಒರಿಜಿನಲಿ ದಿ ಸರ್ವೆ ನಂಬರ್, ಹೊಸ ಸರ್ವೆ ನಂಬರ್ ಮೇಲ್ಗಡೆ 140 ಕೊಟ್ಟಿದೆ.
ಗ್ರಾಂಟ್ ಆದಾಗ ಏನಿತ್ತದ ನಂಬರು?
ಗ್ರಾಂಟ್ ಆದಾಗ ಇದರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 60. ರೈಟ್ ಸೈಡ್ ಕಾಲಮ್ ಅಲ್ಲಿ ಅಲ್ಲೇ ಬರ್ದಿದ್ದಾರೆ ಹೊಸ ಹಳೆ ನಂಬರ್ 60 ಪೈಕಿ. ಕೈಂಡ್ಲಿ ಇನ್ ದಿ ಕಾಲಮ್ ನಂಬರ್ 2 ಮೇಲೆ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಕುಂದಾನ ಹೋಬಳಿ ಸಿಂಗ್ರಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 60 ಪೈಕಿ
ಮುನಿಮದ್ದೂರಪ್ಪ ಬಿನ್ ಸಿದ್ದಾರ್ ಅವರಿಗೆ ತಹಸೀಲ್ದಾರ್ ದೇವನಹಳ್ಳಿ ಅವರ ಮಂಜೂರಿ ಅಧಿಕೃತ ಜ್ಞಾಪನ ಸಂಖ್ಯೆ LND SR 785/1962-63 dated 4/7/1963. Same grant order they are claiming, my lord.
Yes.
My lord, I have produced a confirmation deed at page number 98, my lord. Annexure N.
Annexure
N. Page number 40.
page number
40, my lord.
40.
40.
Yeah, the additional document.
ಅದರಲ್ಲ 40. ನರಸಿಂಹಯ್ಯ, ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6A, my lord. ಅವ್ರಿಗೆ ಇನ್ನೊಬ್ಬ ಮಗ ಇದ್ದಾನೆ, ಆ ಮಗನ್ ಹೇಳಿಲ್ಲ ಇಲ್ಲಿ. ಶ್ರೀನಿವಾಸ ಇಬ್ರುನು ಲ್ಯಾಂಡ್ ನ ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಮಾಡ್ತಾರೆ.
ಯಾರು ಪರವಾಗಿ ಮಾಡಿದ್ದಾರೆ ಇದು?
ಹರೀಶ್, ಇವಾಗ ಹೊಸದಾಗಿ ಪೋಡಿ ಆಗಿದೆ ಅಲ್ಲ, ಪರ್ಚೇಸರ್, ಲೇಟೆಸ್ಟ್ ಪರ್ಚೇಸರ್, ಅವ್ರಿಗೆ ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಮಾಡಿದ್ದಾರೆ. ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಅಲ್ಲಿ 2 acre 20 guntas is the schedule. I have given it, legible ಇರಲಿಲ್ಲ certified copy, I have given it. Lordship, there is an order of Podi prior to giving the new number. There is an order of Podi, Anadhikrita Gnapakana, page number 53, my lord. Relevant portion is at page number 54.
ಎಲ್ಲಿದೆ ಪೇಜ್?
Page number 54, second, ಉಲ್ಲೇಖ 3ರಂತೆ ಉಲ್ಲೇಖ 3ರಂತೆ ಪ್ರಕರಣ ಸಂಖ್ಯೆ 2ರಂತೆ ಪ್ರಸ್ತಾಪಿತ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಕುಂದಾನ ಹೋಬಳಿ ಸಿಂಗರಳ್ಳಿ ಗ್ರಾಮದ 60P1 ರಲ್ಲಿ ಮುನಿಮದ್ದೂರಪ್ಪ ಬಿನ್ ಸಿದ್ದ ಅವರಿಗೆ 2 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನು LND SR 785/62-63 ದಿನಾಂಕ 4/7/63 ಮಂಜೂರ ಬಗ್ಗೆ ನಡುವಳಿ ನಡೆದಿದ್ದು, ಮಂಜೂರಿ ಬಗ್ಗೆ ಅಧಿಕೃತ ಜ್ಞಾಪಕ ಪತ್ರ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ, ಸಾಗುವಳಿ ಚೀಟಿ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವುದಾಗಿ ತಿಳಿಸಿ ಅದರಲ್ಲಿ ಜಿಲ್ಲಾ ಮಟ್ಟದ ಗೈರು ವಿಲೆ ಕಡತ ಸಭೆಯಲ್ಲಿ ಮಂಡಳಿಸಲಾಯಿತು. ಪರಿಶೀಲಿಸಾಗಿ ಶ್ರೀ ಮುನಿಮದ್ದೂರಪ್ಪ ಬಿನ್ ಸಿದ್ದಾರ್ ಅವರಿಗೆ 2 ಎಕರೆ 20 ಗುಂಟೆ ಮಂಜೂರಾಗಿದ್ದು, ನಂತರ ಮದ್ದೂರಮ್ಮ ಕೋ ಮುನಿಯಪ್ಪನವರಿಗೆ MR 3482 ಎಂಬರಂತೆ ಖಾತೆಯಾಗಿದ್ದು, ನಂತರ AC ಮುನಿಕೃಷ್ಣಪ್ಪ ಬಿನ್ ಅಗ್ರಹಾರದ ಚೆನ್ನಪ್ಪನವರಿಗೆ MR 5196-94 ಖಾತೆಯಾಗಿದ್ದು, ನಂತರ ಸುರೇಶ್ ಕೇಡಿಯಾ ಬಿನ್ ಶಿವದತ್ತ ರೈ ಕೇಡಿಯಾ ಅವರವರಿಗೆ ಕ್ರಯವಾಗಿದ್ದು, ನಂತರ ಶ್ರೀ ಹರೀಶ್ ಬಿನ್ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರಿಗೆ ಕ್ರಯವಾದಂತೆ ಆಲಿಪಾಣಿಯಲ್ಲಿ ಶ್ರೀ ಹರೀಶ್ ಬಿನ್ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರು ನಮೂದಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಮಂಜೂದಾರನ ಗೈರು ವಿಲೆ ಕಡತ ತಯಾರಿಸಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಇದನ್ನ ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಇದನ್ನ ಮಾಡ್ಬಿಟ್ಟು ಇದನ್ನ ಕೋಡಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮಾಡಿ ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 140 ಕೊಡ್ತೀವಿ.
60/P1 ಅಲ್ಲ?
60/P1 ಅದು ಹೊಸ RTCಗಳು ಬಂದಾಗ 50/P1, ಹಳೆ RTCಗಳು 60/6 ಅಂತ ಇದೆ. ಸೇಲ್ ಡೀಡ್ಸ್, ಪ್ರೀವಿಯಸ್ ಸೇಲ್ ಡೀಡ್ಸ್ ಎಲ್ಲ 60/6 ಅಂತಾನೆ ಬರ್ದಿರೋದು. ನಾವು the same grant is under they are claiming 785.
RS 60/6 is renumbered.
ಅಂದ್ರೆ ಅದು ಕಂಪ್ಯೂಟರ್ ಆದಾಗ P1 ಅಂತ ಆಗಿದೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ದೇ ಹ್ಯಾವ್ ಆಲ್ಸೋ ಸೆಡ್ ದ ಸೇಮ್ ಥಿಂಗ್.
RS ನಂಬರ್ ಎಷ್ಟಾಗ? 140
140 ನ್ಯೂ ನಂಬರ್. ಇವಾಗ ನಾನು ಅದರದ್ದು RTCನೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ. ಆಮೇಲೆ ಈ ಹರೀಶ್ ಅವರು ಪೋಡಿ ಎಲ್ಲ ಆದ್ಮೇಲೆ DX ಪ್ರಾಪರ್ಟೀಸ್ಗೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ತಾರೆ. ಪೇಜ್ ನಂಬರ್ ಅಟ್ ಪೇಜ್ ನಂಬರ್ 60 ಮೇಲೆ relevant page at 62 my lord.
Sale deed is by whom? By Harisha.
ಹರೀಶ್ ಇಂದ DX Max ಗೆ ಪೋಡಿ ಆದ್ಮೇಲೆ ಮಾಡ್ತಾರೆ. ಅದರಲ್ಲಿ 3rd ಪ್ಯಾರಾಗ್ರಾಫ್ ಪೇಜ್ ನಂಬರ್ 62 ಮೇಲೆ the grant order of 785/62-63 could be found. It is the same order under which is
ಅವರು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ ಯಾರು ಇಲ್ಲಿ? ಮ್ಯಾಕ್ಸ್ ಅವರು ಇಲ್ಲಿ
ಇಲ್ಲ. ಇದು ಡ್ಯೂರಿಂಗ್ ದ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್, ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಆಗೋದೆಲ್ಲ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. This proceeding, these things are not before. They have been given repeatedly. ಎಲ್ಲೆಲ್ಲಿ ಕೇಸ್ ಆಗ್ತಾರೋ ಅಲ್ಲಲ್ಲಿ ಒಂದೊಂದು ಫ್ಯಾಮಿಲಿ ಟ್ರೀಟ್ ಕೊಟ್ಬಿಟ್ಟು they are creating a problems like this. They are sold, they have executed a confirmation deed. The same Nasimappa is representing
Sorry,
before this court.
Now what they're challenging then?
Let-
Grant ಇದೆ ಅಂತ ಹೇಳಿ they challenge this 40.
No, my lord. Now, they sold the land to different persons. Now my number is 95. I am claiming under different person. My POD is done in 1980, 1980,
Which is not challenged.
which is challenged, dismissed.
Are dismissed, JDL are dismissed
Again, they approached the deputy commissioner without jurisdiction.
based on
Artist.
endorsement.
Based on endorsement, that order. Now, they were arguing, my land is not identified, my land is not identified on the last occasion, my lord. The land identified, they sold it, they executed a confirmation deed.
ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಮಾರಿದಾರಂತ.
Our property ne marirodu. All these sale deeds is of their property. It is not my property. I have a different flow of title.
ನಿಮ್ದು ಯಾವ್ದು ಸರ್ವೆ ನಂಬರು?
Namdu 95.
ಅವ್ರದ್ದು 60/6 which is renumbered as 140.
140. Now, further for clearance, my lord. My lord, page number 59.
ಹಾ
95 extreme right ಗೆ ಟಾಪ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಸರ್ ಸರ್ವೆ ನಂಬರ್. ಲೆಫ್ಟ್ ಗೆ ಟಾಪ್ ಅಲ್ಲಿ 95 ಬರುತ್ತೆ.
ಲೆಫ್ಟ್ಗೆ
ಟಾಪ್ ಅಲ್ಲಿ ಟಾಪ್ ಇಂದ ಎರಡನೇ ಪ್ರಾಪರ್ಟಿ 95 ನನ್ನ ಸರ್ವೆ ನಂಬರ್.
95 ಅಂತಿದೆ, 96 ಕೆಳಗಡೆ ಇದೆ.
96 ಕೆಳಗಡೆ ಇದೆ. ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಕೈಯಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ 140 ಹೊಸ ಸರ್ವೆ ನಂಬರ್.
140.
This is the land which is granted to Muniyamadurappa, which has all these sale deeds. I have read out only the sale deeds sold by the son of Muniyamadurappa, where respondent number 6 has executed a confirmation deed. How can he can claim 2 acre 20 guntas here sold, executed confirmation deed?
On what basis they are asserting on survey number 95 now?
Now they say 60/6 ಪೋಡಿ ನನ್ ಜಾಗನ ಅವ್ರಿಗೆ ಪೋಡಿ ಮಾಡ್ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ.
ಬಟ್ ಅವ್ರ 40 ಆಗಿ ರಿಯಸನ್ ಆಗಿದ್ದನ್ನ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದೆ ಈಗ.
ಇವಾಗ that is
produced now. That you have produced.
Which we are not aware of all these sale deeds transaction, my lord. I was aware of new survey number was being granted. I produced a sketch, but I did not get the document. After the hearing the last occasion, I got searched all these documents and got a documents.
No, they again challenged it before Tahsildar. They moved one more application on the premises that they are the owners of survey number 95.
They are not
ಅಲ್ಲ,
owners of land.
ಅಲ್ಲಿ
60/6 ಅಲ್ಲೇ
Don't
grant.
argue that. ಅಲ್ಲ, ನಾನು ಕೇಳ್ತಾ ಇರೋದು.
Yes.
ಅದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್
Yes,
ಮಾಡಿ.
yes.
The case is that they are owner of 95. 95 is granted to them.
No, no. My lord.
ಅದೇ ಅವ್ರ ಪ್ರಕಾರ ರೀ.
ಇಲ್ಲ, that is not the case.
ಹಾ,
Their case is that they granted 2 acres 20 guntas by some manipulating with the revenue authorities. I got it, body done of survey number 95, 5 acres. And they are in possession of that land.
ಇಲ್ಲ, ಪ್ರಾಪರ್ಟಿ ಹೆಲ್ಡ್ ಬೈ ಈಸ್ ಅಸೈನ್ಡ್ 95 ಅಂತ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಅವ್ರ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದ್ರು ಅವ್ರಿಗೆ ನೋಟಿಸ್ ತರ್ದಿರ, ಗಮನಕ್ಕೆ ತರ್ದಿರ, ನಾವು 95 ಅಂತ ಪೋಡಿ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಿ ಅಂತ.
Their property is reassigned 95 and it is their property ಅಂತ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅವ್ರದೀಗ. ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಇಲ್ಲ, my lord, they contend podi done in my favor, though they are in possession. Podi is done in favor of my vendor.
Oh, they are in possession of 95.
They are claiming independent title.
ಅವರು 95 they are in possession ಅನ್ನೋದು ಅವ್ರು.
ಹೌದು, ನನ್ನ ಲ್ಯಾಂಡ್ ಅವ್ರು.
But the documents show that they are owner of 60/6
And they sold it.
sold, it has undergone 4D and it is reassigned, and they have further acknowledged by executing a confirmation
Yes.
deed. And 95 and 140 are totally different properties, can be gathered from P4.
P4.
Annex P4. Page 59, correct?
Correct.
Of 95. Yes. Subject, you can reply. Yes, sir, Shatri sir. ಎಲ್ಲ ಹೊಸದು. ಅಲ್ಲ, ನೀವೆಲ್ಲ ನಿಮ್ದು ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲ ಇದೆ ನೋಡ್ರಿ, ಬಿ ಕೇರ್ಫುಲ್. ನೀವೆಲ್ಲ ಪರ್ಚೇಸ್ ಮಾಡಿ ಎಲ್ಲ ಮನೆಗೇನೆ ಕಟ್ಕೊಂಡಿದೆ. ಯಾರು ಹಿಂಗ್ ಸ್ಕೆಚ್ ತೊಗೊಂಡ್ ಬಂದ್ಬಿಟ್ರೆ ಕಷ್ಟನೇ ಎಲ್ರಿಗೆ ಬೆಂಗಳೂರಲ್ಲಿ. ಇದೆಲ್ಲ ನೋಡಿದ್ರೆ ನೋಡಿ ಸರ್, the more you dig, skeletons, abundant skeletons come out. What is this, sir? ಏನೆಲ್ಲ ನೋಡಿ. ಒಂದು perception kind of a narrative which you are set up in your while contesting this writ petition goes away. These are all title documents. ನಿಮ್ದು ಪ್ರಾಪರ್ಟಿನೇ ಬೇರೆ ಇದೆ. Now how we can assert claim over 95? ಇದು ನೋಡ್ಬೇಕಾ ನೀವೆಲ್ಲ ನೋಡ್ಬೇಕ್ರಿ ಇದು? ನೋಡಿದ್ದೀರಾ? ನೋಡಿದ್ರಾ? You got an answer to this?
But you must kindly take my statement for objections. First of all, now, Lord, by these arguments, he has made out a case for remand. There are so many documents, so many facts which he is not aware. Nor the lower authority, nor these documents are produced there. They are sought to be relied on in a writ court. Writ court can't examine this. Nor it could lay down who has got title, who has lost title, who has no title. Those are all beyond our scope under Article 226. What he had alleged in the writ petition is he had no.
Allah, we won't decide. We'll say that these are all registered documents, public documents.
Those registered documents.
Evidentiary probative value. We are not deciding whether they are correct or not.
Please.
Shastri sir.
Now, along with the objection statement, you have asked me to look at an action.
Sir, you tell me, see, the problem with the difficulty we are facing as a court is, you both argued and then again now you have to start afresh. I had a better grip on facts in the last date. ಇದು incremental the arguments ಅಲ್ಲ, it really.
Last day, your lordships were tightly sitting as a writ court within that encompass.
Correct.
Now, my lord, my learned colleague has drawn the court to so many aspects which are beyond rather the scope of writ court, resulting in little diversion. And when these facts are put to the mind of the honorable court, when court finds that there is something
which is very real or very near to the truth, then my lord, I need to rebut it by
You start
showing
from,
not these facts which we have stated.
Allah,
is-
begin from the starting point. What is the issue involved?
There's
All that I can recollect is a 40 was done in 1980.
Correct.
You give a fresh application before the Tahsildar. He issues the endorsement that it can't be done because 40 is already done in 1980. You challenge that. An endorsement is challenged by the deputy commissioner. He sets aside 1980 40. Whether he has a jurisdiction is a point to be answered.
That is the
Now you
point,
can
not
take
which
it.
your lordships were fixed on the last
Correct,
day.
on that point, for limited.
Now, my lord, I will just answer it, my lord, later.
Yes.
Because, my lord, so many facts are, we should not allow a wrong fact to come on record, my lord, in anywhere, in courts record, it gets repeated, relied upon by certain other courts, upper, lower, and all that. Therefore, my lord, I am making it clear. My lord, annexure A, along with the statement of objections, my lord, your lordship. 3/4/2017, respondent number 6 has filed a statement of objection.
Allah, before you start taking this code to the relevant documents, what's your opening statement that you are owner of which survey number?
60/6, 2 acre, 20.
60/6 is your claim. Now, under the 40, you mean to say that this 60/6, why you're questioning the 40?
I have not as such asked my lord for quashing the body. It is these revenue authorities or survey authorities which have made out this, what they say is, unless it is quashed, we can't survey your survey your land. That is what they say.
You're concerned with 60/6.
I am concerned with my land 60/6, 2 acres 20 guntas, which was granted to my husband Muni Madhurappa in the year 1963, on 7/6/1963.
Yes.
Blood on Sagalichi, it was issued on 4/7. Blood 30/6/1963, it was granted.
Yes.
2 acres 20 guntas in survey number 60/6 was
Just a
granted.
minute, just a minute. You appear for 6A?
I appear for 6, respondent number 6.
6 or 6?
Wife of late Munisoma.
ಅಲ್ಲ 6A ನಾ ಇವರು 6A ಅಂತಂದ್ರಲ್ಲ.
ಎಲ್ಲಾರು ಅಪ್ಪಿರ್ ಆಗ್ತಾರೆ.
Sir, we proceed.
6A. According to you, original owner was,
Original owner, my lord, Muni Madhurappa.
and you are concerned with 60/6.
Yes, 60/6.
Owned by Muni.
Muni Madhurappa.
Yes, sir.
Lord, 2 grants were made, Lord, the whole.
He acquired by way of a grant,
He acquired by way of grant,
1963 grant.
30th June 1963.
Thirteen six 1963, correct?
Same time, Lord, same survey number 60/6, 2 acre 20 guntas was granted in favor of one Muniappa.
ಮುನಿಯಪ್ಪ.
Muniappa,
ನಿಮಗೆ ಎಷ್ಟು ಗ್ರಾಂಟ್ ಆಗಿದ್ದು?
2 acre 20 guntas.
And what was the total extent in 60/6?
More than 129,
Oh, all right.
100 and all that.
So same day Muni Shamappa was also granted.
Muniappa was
Muniappa.
granted. Muniappa, son of Narsimha, was granted 2 acre 20 guntas.
So now,
Narsimha.
he petitioner traced title through this Muni Shamapana.
No. Petitioner claims title through Muni Madhura.
Your petitioners.
Petitioner ಅಲ್ಲ. Respondent number 6.
R6.
R6. And what about petitioners? Petitioners?
Petitioner claims not through one Muniga. petitioner claims through one Muniga. Muniga purchased in a court auction in the year 1948 a portion of server number 60. That way, that Muniga that was poured in his favor about after 40-50 years in the year 1980 in favor of Muniga. So in 2000, petitioner purchases from the heirs of Muniga. That is not the title so far as petition is concerned. It is same server number 60.
You will just, I will note down, petitioners are tracing through.
Petitioners are claiming title through Lord one Muniga. Muniga.
Muniga, yes.
Muniga Milord purchased under a public auction on 29/4/1948. He purchased 5 acre 10 guntas in server number 60.
Not 60/6.
Not 60/6.
Yes.
It was coded Milord on 19/9/1980. What was purchased by him was coded as server number 95 on 19/9/1980.
Either 1980-40 though.
1980 body. That is the coding Milord which
Also, portion purchased by Muniga was subjected to 40 in 1980.
correct.
After 40, what is the survey number reassigned?
90.
Yes.
Petitioner purchased on 19/9/2000 from the wife and children of
Muniga.
that not so far as petitioner is concerned.
In 2001,
19/9/2000, 19th September 2000.
2000. From widow and children of Muniga.
Muniga.
Yes, sir.
We'll continue with my case. Blood Sabolicit was issued to me on 4/7/1963 for server number 60/6 area 2 acre 20 guntas.
ಯಾರಿಗೆ ಮುನಿಮದ್ದೂರಪ್ಪಗೆ.
Muni Madura. 4/7/1963.
What is the date, sir?
4th July 1963.
Yes, sir.
Annexure B1 Milord along with the statement of objection.
Annexure?
B1, B-1.
Yes.
The Darkhast grant Milord is annexure A-1, Darkhast memorandum, first 30th/6/1963, along with my objection statement. Then Milord, Munimuddurappa sold this survey number 60/6 2 acre 20 guntas on 18th December 1965.
He sold.
He sold.
Entire extent,
Entire extent 2 acre 20 guntas, 18th.
one ನಿಮಿಷ. What is the date, sir?
18th December 1965.
In favor of?
C1 is the sale deed.
In favor of?
In favor of one Ramakrishnappa.
Ramakrishna.
Ramakrishnappa.
Ah,
Annexure C1 Milord is the sale deed.
C1,
C1
all right.
with server number 60/6 boundaries. Then that Ramakrishnappa was sold to one Venkojappa on 9 September 1968. 9th September 1968.
In favor of?
Ramakrishna was sold to Venkojappa.
Venkojappa.
Annexure D1, my lord, is the sale deed. Then respondent number 6, who is the daughter of Muni Madhurappa, she filed a petition under section 5 to the Assistant Commissioner Dadbalapur.
Daughter of Madhura.
Muni Madhurappa. She filed an application for restoration under section 5 of the PTCL Act, and the Assistant Commissioner passed an order on 8/6/1998. 8/6/1998.
One ನಿಮಿಷ.
Annexure F, my lord, is the order of the Assistant Commissioner.
Order for restore.
Order for restoration. Petition was delivered by Rahina Majar by the Revenue Inspector.
Yes.
6/10/2000, Annexure H1.
Annexure H is
H-1, 6/10/2000. Mazar handing over possession to the respondent number 6. 60/6, 2 acre 20 gunta stands restored to me, possession is there.
yes.
From 97/98, from the order of the Assistant Commissioner, the names of these vendors were bracketed, removed, and name of respondent number 6 came to be restored in the record of rights for 60/6, 2 acre 20 guntas. That continued up in order 2001-2002. In 2001-2002, instead of 60/6, he simply made 60/P5. This P5 always refers to not on the record of right side. Paiki. That is out of this survey 60. Paiki, somewhere I am there. That not created confusion and deletion of 60/6 and making it a vague 60/P5. Gave a cause of action law to the petitioner requesting the revenue authorities to conduct survey, fix Haddabast or whatever regarding the 60/6 which was originally granted to Muni Madhurappa. This is the starting of problem. Then my name was continued for 60/P5, 60/P5. The petitioner has purchased a certain area in same serial number from certain else. And there is a 4D in his favor and all that. I asked for my measurement of property which was granted to me, which was restored to me and all. That's all my concern is concerned. At some stage, that is, my client has filed an appeal, no doubt, to the Joint Director of Land Records, challenging this 4D of 95.
ಯಾರು ಮುನಿ ಮುದ್ರಪ್ಪನೋ ಡಾಕ್ಟರು?
Same Pilla Akayama challenges it by filing
ಯಾರು R6?
R6.
Now, Shastri sir, why you challenged 1980 4D, which was in respect of survey number 95?
There is identification problem, Lord.
Then come to what's Shastri sir?
Solve what can I make out?
No. What's your explanation to this sketch? Come to sketch.
My lord, I will come bit later, Lord.
ಹೌದಾ ಆಮೇಲೆನಾ?
No, my lord, your lordship may go to the
Page
sale
15.
deed produced by him.
Sale deed.
Sale deed, annexure. 31 ಅಲ್ಲ? Annexure K. Page 15. Or 31/1/2024.
Yes, sir.
29/3/1995 ಚೆನ್ನಪ್ಪನವರ ಮಗನಾದ ವಯಸ್ಸುಳ್ಳ ಎ.ಸಿ. ಮುನಿಕೃಷ್ಣಪ್ಪನವರಿಗೆ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಸಿಂಗರಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಾಗಿರುವ ಮುನಿಯಪ್ಪನವರ ಧರ್ಮಪತ್ನಿ ಮದ್ದೂರಮ್ಮ, ಅದು ನಾನು, ನನ್ನ ಮಗ ವೆಂಕಟರಮಣ. Therefore, I pointed out your lordships. 2 grants were there. In the year 1963, on the same date, 30th/6/1963, 2 acre 20 guntas in favor of Munimaddurappa and 2 acre 20 guntas in favor of Muniappa.
Munyap.
That Muniappa's wife and children have sold that 2 acre 20 guntas here.
ಯಾರಿಗೆ?
Muni Krishnappa. Muni Krishnappa sold it to one Kedia. Kedia sold it to one Harish. And it was surveyed, identified as survey number 140. These names are confusing. Muniappa, Munisappa, Munimaddurappa. These two grants, so my lord, my 2 acre 20 guntas, one has to acknowledge it because it is there successfully on the same day grant was made to another, it was identified. Grant to me also should be identified similarly. That's all it's my problem. I may jump here, I may jump there, I may jump here. Only to see, work out my remedy of, because it would not have been there, but for these magics happen, my lord, on the survey side, as civil lawyers we find, even we can displace the judgment of the Supreme Court or High Court by just a sketch, my lord, drawing this way, this way, this way. That land gets displaced, the title gets displaced, the position gets displaced, everything happens, and nobody can question these surveyors because we are not experts. We don't know where to place this chain and fix it, draw it, and all that. It's beyond our knowledge. Only we, my lord, by our common sense, we displace them in when they are in box. Otherwise, what they make a sketch, my lord, is something which is greater than, my lord, judgment of any court of law is my experience in life. They create a lot of problems. Now, whole problem here is my client filed appeal to the JDLR. Then JDR said, no, it is done already. 90 is there. Yours is separate. His is separate. There is only one paragraph, the last paragraph. The JDL. Before the JDLR, he says, why this lady comes to here questioning mine? Her land is there 1 kilometer away. Why she is asking mine? You dismiss it. It was done in the year 1980. JDLR says, right. It was done in 1980. We are in the year 2001 or 2020 years have lapsed. Your land is there. That there can be circus on item number 1, item number 2. So you that is separate aspect, separate. I need not interfere. This is the order of the JDLR. Problem does not stop there. My client then filed a petition to the Deputy Director of Land Records saying that my land should be surveyed. Then Deputy Director of Land Records, as per annexure M1 said, you file revision. Lord M1, my lord, along with the objection statement. Page 91, annexure M-1. ಭೂಮಾಪನ ತಾಂತ್ರಿಕ ಸಹಾಯಕರು ಪದನಿಮಿತ್ತ ಭೂಗು ದಾಖಲೆಗಳ ಉಪನಿರ್ದೇಶಕ ಜಿಲ್ಲಾಧಿಕಾರಿ ಪ್ರಕರಣವನ್ನು ವಿಚಾರಣೆ 3/4/2000 ಪ್ರಕರಣ ವಿಚಾರಣೆ ಕಳಿಸಲಾಯಿತು. ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿ ವಾದಿಗಳ ಪರ ವಕೀಲರು ಇದನ್ನು ಹಾಜರಿದ್ದು ಪ್ರಕರಣ ಕುರಿತು ಈಗಲೇ ವಾದವನ್ನು ಮಂಡಿಸಿದ್ದಾರೆ. ಏನಂದ್ರೆ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಕುಂದಾಣ ಹೋಬಳಿಗೆ ಸೇರಿದ ಸಿಂಗರಹಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಹಳೆ ಸರ ನಂಬರ್ 60/6 ಹೊಸ ನಂಬರ್ 95 ಇದ್ದು, ಇದು ಹಳೆ ಸರ ನಂಬರ್ 60ರಲ್ಲಿ 2 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನು ಮಣಿಮುದ್ದರಪ್ಪ ತಂದೆ ಸಿದ್ದಪ್ಪನವರಿಗೆ ಮಂಜೂರಾಗಿತ್ತು ಮತ್ತು 2 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನು ಸರ ನಂಬರ್ 60ರಲ್ಲಿ ಮನಿಗಾ ತಂದೆ ನರಸಿಂಹ ಎಂಬವರಿಗೆ ಭೂ ಮಂಜೂರಿ ಆದೇಶದಲ್ಲಿ ಮಂಜೂರಾಗಿತ್ತು. ನಂತರ ಈ ಸರ ನಂಬರ್ 60ರಲ್ಲಿ ಮನಿಗಾ ತಂದೆ ನರಸಿಂಹಪ್ಪ ಎಂಬವರಿಗೆ statement of objections. My statement of objections dated 3/4/2017. Respond number 6.
Now, there is a intricate dispute between Munishamappa's 2 acre 20 guntas grant and yours or adu illa.
This is separate, mine is separate.
ಅಲ್ಲ ನಿಮ್ಮಿಬ್ರದ್ದು ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್ ಅವ್ರು ಸಪರೇಟ್ ಅಂತೀರಾ?
Same sir.
ಮತ್ತೆ 95 ವರೆಗೆ ನೀವು ಚೇಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Sir,
ಅವ್ರದ್ದು ಮಾರ್ಸು
ಯಾರನ್ನು
ನಿಮ್ದು
ಚೇಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ತಮ್ಮ ಪಕ್ಷಗಾರಿಗೆ ಒಬ್ವಿಯಸ್ಲಿ ಗೊತ್ತಿರಲ್ಲ, ಅದು ಗೊತ್ತಾಗಿ ಸಾಧ್ಯ ಆಗಲಿಲ್ಲ.
ಮಾರ್ಸು ನೀವು
ಜಮೀನ್ ಇದೆ, ನಮ್ ಸ್ವಾಧೀನ ಇದೆ, ನಾವಿದ್ದೀವಿ ಅಷ್ಟೇ ನಮ್ಗೆ ಗೊತ್ತು. ನೀವು ಅದಕ್ಕೊಂದು ಕೋಡಿ ಮಾಡಿ ಅದಕ್ಕೆ ನಂಬರ್ ಕೊಡ್ರಿ. ಯಾವ ನಂಬರ್ ಕೊಡ್ತೀರಾ ನಮ್ಗೆ ಸರ್ವೇಯರ್ಸ್ ಐಡೆಂಟಿಫಿಕೇಶನ್ ನಮ್ಗೆ ತೊಂದ್ರೆ ಇಲ್ಲ. ಎಲ್ಲ ನೀವು 60/6 ಅಂತ ಇದ್ದಿದ್ದು ನಮ್ಗೆ ಒರಿಜಿನಲ್ ಗ್ರಾಂಟ್ ನಮ್ಮ ಅಪ್ಪನಿಗೆ ಆಗಿದ್ದು 60/6. ಅದು ಚೇಂಜ್ ಮಾಡಿ ನೀವು ಸಡನ್ ಆಗಿ 60/P5 ಅಂತ ಇಟ್ಬಿಟ್ರಿ. 60/P5 ಅದು ಅನಾಮಧೇಯ ಡೆಸಿಗ್ನೇಷನ್ ಅಂಡರ್ ದಿ ರೆಕಾರ್ಡ್ ಆಫ್ ರೈಟ್ಸ್. ಅಷ್ಟು ನಮ್ಮ ಪಕ್ಷಗಾರಿಗೆ ಗೊತ್ತಾಗ.
ಈಗ ನೀವು ನೀವು ಅದು ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಲ್ಲ, ನೀವು ಮಾಡಿ.
ನಾವು ಮಾಡಿಲ್ಲ. ಆ ಇನ್ನೊಂದು 2 ಎಕರೆ 20 ಗುಂಟೆ ಅವನು ಆ ಜಾಗಕ್ಕೆ ಮಾಡಿದ್ರು.
ಅಲ್ಲ, ಅದು ಮುನಿಶಾಮಪ್ಪಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು.
ಮುನಿಶಾಮಪ್ಪ ನನ್ಗೆ ಸಂಬಂಧವಿಲ್ಲ.
ನೀವು ಮಾಡಿಕೊಟ್ಟಿದ್ದೀರಾ. ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಇಸ್ ಬೈ ಯೋರ್ ಕ್ಲೈಂಟ್. You own only ಅದು ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. That is what they are telling.
Lord, Narsimaya is different.
No.
They are all different.
Same Narasimha.
Come to confirm. See, you own only 2 acre 20 guntas, correct?
Correct.
Nimdu 2 acre 20 guntas. You have already executed confirmation deed. Come to that document. ಎಲ್ಲಿದೆ ಇರೋದು ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್?
Page number 50, my lord.
50.
Typed copy at page number 50. Actual copy at 40.
50 annexure N.
Same address.
ನರಸಿಂಹಯ್ಯ ಯಾರು ಇವರು?
Narasimha, respondent number 6A.
ಯಾವ ಪ್ರಾಪರ್ಟಿ ಮಾಡಿದಾರೆ ಅವರು? 60/P1. ನಿಮ್ದು 60ದಲ್ಲಿ ಇರೋದು ನಿಮ್ದು ಒಂದೇ ಪ್ರಾಪರ್ಟಿ. You have already meddled. You are not holding any property now. If you look into this confirmation deed, ಮುನಿಶಾಮಪ್ಪದ ನೀವೇ ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ತೀರಾ?
One more clarification, my lord. They read Munduramma sold the property which is granted to Narasimham. That is what they said. That is a different portion they sold it. My lord, page number 15, typed copy. First to sale deed on. First to sale deed. First, clarification. Clarification.
I have doubt, so I'll come back to you. Yes.
Clarification. My lord, first property was sold by Muniyappa, son of Muni Madhurappa, on 1974.
Muniyappa,
Son of Muni Madhurappa.
he sold it.
He sold it land in 3/7/1974 in favor of Madhuramma.
ಅದ್ಯಾವ್ದು ಪ್ರಾಪರ್ಟಿ?
ಇವರೇ ಮಾರಿದ್ದು. ಮುನಿ ಮದ್ದೂರಪ್ಪನ ಮಗನೇ ಮನಿಯಪ್ಪ ಮಾರಿರೋದು. That is why I said different family trees is given at different levels in a different proceedings.
No, just a minute. ಈಗ ಶಾಸ್ತ್ರಿ ಸರ್ ಕೊಟ್ಟಿರೋದು ಫ್ಲೋ ಆಫ್ ಟೈಟಲ್ ಅಲ್ಲಿ ಮುನಿ ಮಧುರಪ್ಪ ಸೋಲ್ಡ್ ಇಟ್ ಟು ರಾಮಕೃಷ್ಣಪ್ಪ.
ಅಲ್ಲೊಂದ್ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ 65 ಅಲ್ಲಿ. ಅದು ಬಿಟ್ಟು ಇನ್ನೊಂದ್ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿದ್ದಾರೆ.
ಇನ್ನೊಂದ್ ಸೇಲ್ ಡೀಡ್
1970
ಇದೇ ಪ್ರಾಪರ್ಟಿ.
ಇದೇ ಪ್ರಾಪರ್ಟಿ.
ಅದು ಫ್ಲೋ ಆಫ್ ಟೈಟಲ್ ಮೇಡಮ್. ನೀವು ಅದು ಬರಿತಾ ಹೋಗಿದ್ದೀರಾ 20 ಹೆಸರುಗಳು.
ಕನ್ಫ್ಯೂಷನ್.
ಮೂರನೇ ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೋದ್ರೆ ಏನು ಗೊತ್ತಾಗಲ್ಲ. ಫ್ಲೋ ಆಫ್ ಟೈಟಲ್ ಬಂದ್ರೆ ಗೊತ್ತಾಗತ್ತೆ. Now you mean to say that same property is sold by Narasimha and Srinivas also?
Muni Madhurappa son Muniyappa sold the land to Madhuramma son of Venkatramana in the year 3/7/1974.
What is sold? 60/6?
60/6.
2 acre 20 guntas.
2 acre 20 guntas. ಅದರಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ 1 acre 20 guntas ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಚೇಂಜಸ್ ಆರ್ 2 acre 20 guntas. 2 acre 20 guntas.
ಯಾರಿಗೆ ಸೇಲ್ ಮಾಡಿದ್ರು ಅವರು?
ಮದ್ದೂರಮ್ಮ.
ಮದ್ದೂರಮ್ಮ.
They said ಮುನಿಯಪ್ಪನ ಹೆಂಡತಿ ಮದ್ದೂರಮ್ಮ ಮಾರಿದ್ದಾರೆ. 12 ಎಕರೆ 20 ಗುಂಟೆ ಆಯ್ತಲ್ಲ, 5 ಎಕರೆ ಅದನ್ನ ಮಾರಿರೋದು. ನಮಗೂ ಆ ಸೇಲ್ ಡೀಡ್ಗೂ ಈ ಸೇಲ್ ಡೀಡ್ಗೂ ಸಂಬಂಧ ಇಲ್ಲ ಅಂದ್ರು. That is not that land. Whatever she purchased under the sale deed 3/7/1974, same land was sold it to the ಮುನಿಕೃಷ್ಣಪ್ಪನಿಗೆ. ಅದರಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಈ ಪ್ರೀವಿಯಸ್ ಸೇಲ್ ಡೀಡ್ ರೆಫರೆನ್ಸ್ ಇದೆ 1974. ವೇರ್ ಮುನಿ ಮದ್ದೂರಪ್ಪ ಸನ್ ಸೋಲ್ಡ್ ಇನ್ ದ ಸೇಮ್ ದೇರ್ ಇಸ್ ಅ ರೆಫರೆನ್ಸ್. ಅದರಲ್ಲಿ ಬರೀತಾರೆ, ಮದ್ದೂರಮ್ಮನ ಆದ ನಾನು, ನನ್ನ ಮಗ ಸುಮಾರು 35 ವರ್ಷ ವೆಂಕಟರಮಣ ಆದ ನಾವಿಬ್ಬರೂ ಸೇರಿಕೊಟ್ಟ ಜಮೀನಿನ ಶುದ್ಧ ಕ್ರಯ ಕ್ರಮವೆಂದರೆ ತಾರೀಕು 3/7/1974 ದೇವನಹಳ್ಳಿ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅವರ ಕಚೇರಿಯಲ್ಲಿ 1ನೇ ಬುಕ್ 1139 ವಾಲ್ಯೂಮ್ ಪುಟ 110 ರಿಜಿಸ್ಟರ್ ನಂಬರ್ 1422 ಆಫ್ 75 ಶುದ್ಧ ಕ್ರಯದ ಮೂಲಕ ಮುನಿ ಮದ್ದೂರಪ್ಪನ ಮಗ ಮುನಿಯಪ್ಪನವರಿಂದ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಪಡೆದಿದ್ದು. ನಾಟ್ ದಿ ಲ್ಯಾಂಡ್. ದೇ ಆರ್ ಕನ್ಫ್ಯೂಸಿಂಗ್ ವಿತ್ ಸಮ್ ಅದರ್ ಮದ್ದೂರಮ್ಮ.
The same land, whatever the sold by the son of Muni Madhurama, same land she has sold, purchased and sold it to AC Muni Krishnappa.
ಈ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಖಂಡಿತವಾಗಿ ಸಾಧ್ಯ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ annexure C1 1965 ಸೇಲ್ ಡೇಟ್ ಬೌಂಡ್ರೀಸ್. ಐ ಆಮ್ ಸಿವಿಲ್ ಲಾಯರ್. ಐ ಕ್ಯಾಚ್ ಇಟ್ ವಿತ್ ಇನ್ ಅ ಸೆಕೆಂಡ್. ಪೂರ್ವಕ್ಕೆ ಮುನಿಗಂತಿಗೆ ಒಂದು ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ಸೇಂದಿ ಮುನಿಯಪ್ಪನ ಜಮೀನು, ಉತ್ತರಕ್ಕೆ ಮುನಿ ನರಸನ ಜಮೀನು, ದಕ್ಷಿಣಕ್ಕೆ ಮುನಿಶಾನಪ್ಪನ ಜಮೀನು. ಇಲ್ಲಿ ಇವರು 74 ಸೇಲ್ ಡೀಡ್ ಹೇಳೋದು ಪೂರ್ವಕ್ಕೆ ಲಕ್ಷ್ಮಮ್ಮ ದೊಡ್ಡ ವೆಂಕಟೇಶಪ್ಪ ಜಮೀನು,
ಶಾಸ್ತ್ರಿ ಸರ್, ಶಾಸ್ತ್ರಿ ಸರ್,
ಪಶ್ಚಿಮಕ್ಕೆ ಕೆಂಚಪ್ಪನ ಜಮೀನು.
ಇರಿ ಒಂದ್ ನಿಮಿಷ
ಬೌಂಡ್ರಿ
ಇಲ್ಲ,
ಬೌಂಡ್ರಿ ಬೇರೆನೆ.
no, just a minute. You all tracing a right through Muni Madhurappa. Muni Madhurappa was granted only 2 acre 20 guntas in 60/6. If Muni Madhurappa has already washed off his hands by selling it to Ramakrishnappa in 1968, how could son of Muni Madhurappa sell it another 2 acre 20?
Sell it, it is wide.
No, but sale ಇದೆಯಲ್ಲ ಅಲ್ಲಿ.
Sale it is there, but it is wide. If you sell set, my lord, it is wide because what is important is the earliest 1965 sale date, followed by 1968 sale date, followed by restoration order passed by the Assistant Commissioner. This 74 sale date, somebody else sells it with some other boundaries. Maybe there may be some other title deed in the same server number, you do not know.
Whatever may
That
happen.
way, my lord, it is very difficult to investigate at this stage. If it was there, they would have been first jumped. After 20 years, they would not have kept up to till today, my lord, suppressing these facts.
No, tell me your brothers have sold it, no?
Please, ma'am.
R6 brother ಅವರು ಮುನಿಶಾಮಪ್ಪ, ನಿಮ್ಗೂ ಗೊತ್ತಿರ್ಬೇಕಲ್ಲ. Parallel see one property
ಪಕ್ಷಕಾರ ಹತ್ರನೇ ಕೇಳ್ಬೇಕು.
ಏನಮ್ಮ ಅದು ರಿಸ್ಟೋರೇಷನ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಸೇಲ ಇಲ್ಲ, ರಿಸ್ಟೋರ್ ಆದ್ಮೇಲೆ ಈಗ
ನಾವು ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೋಬಹುದು ಸರ್, ಪಕ್ಷಕಾರ ಹತ್ರ ಕೇಳ್ಕೋಬಹುದು. ಅದು ಏನಂತ ನಮಗೂ ಐಡಿಯಾ ಇಲ್ಲ, ಅಷ್ಟರ ಮಟ್ಟಿಗೆ ನಮಗೂ ಐಡಿಯಾ ಇಲ್ಲ.
All right, now what is your case now?
Now, my lord, what I would say is, there is a suit, my lord, pending between the parties. My client filed a suit for declaration of title and permanent injunction in OS number 718 of 2022 before the civil judge Devanhalli.
ಏನಿದೆ ಅಲ್ಲಿ ಸ್ಕೆಡ್ಯೂಲ್ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
Otherwise, server number 60/6 with the boundaries 2 acre 20 guntas I have given as per my grant records.
Original R6 filed that suit.
Correct. OS 718 of 2022 on the file of civil judge Devanhalli.
One ನಿಮಿಷ ಸರ್, filed suit in OS
718 of 2022.
R6A filed a suit.
R6A na, all right. 718 of
2022.
2022 fresh suit
Yes.
for declaration and injunction.
Correct.
ಏನ್ ಡಿಕ್ಲರೇಷನ್?
Say owner, title holder by virtue of grant.
Subject matter is 60/6.
Same.
But it has undergone subdivision ಅಲ್ಲ, 140 ಆಯ್ತಲ್ಲ ಅದು.
ಅಂತ ಅವರಿಗೆ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ ಸರ್, ಅವರಿಗೆ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ ಅದು ಸರ್ವೆ ಆಗಿದೆ, ಅದಾಗಿದೆ, ಇದಾಗಿದೆ ಅಂತ ಹೇಳಿ. ಅದು ಇದೇನೋ ಬೇರೆನೋ, ಅದು it is not so easy because the boundaries in the 1974 sale deed is different.
All right,
Subsequent.
we'll take reference point as 60/6 is your property, correct? Now ಇದರಲ್ಲಿ ಅವ್ರ ಪಾರ್ಟಿ ಇದಾರಾ?
ಇದೆ.
ಹೌದು ಅವರ ಮೇಲೆ ಹಾಕಿದ್ರು, ಪಿಟಿಷನರ್ ಮೇಲೆ ಹಾಕಿದ್ರು.
Petitioners.
No, 4/11/2023 civil judge granted temporary injunction restraining
4/11/2023. Yes.
that was confirmed, my lord, in the MA 15029 of 2023.
MFA
Service
1,
appeal
MFA?
15,029
1 2.
15029 of 2023. By the judgment dated 27th November 2024.
Order confirmed.
Again, my lord, same identification problem will come even before the civil court. Without survey, my lord, what is the land granted to me, what is the land which.
Let
they are
there be
paying?
local inspection there, if you want. But you can't alter a sketch, 1980 sketch. That too, by securing an endorsement at the hands of the Tashildar and then take it to Deputy Commissioner. And he is setting aside a sketch of 1980. What is his competency? How Tashildar can set aside?
What all he says, my lord, is look to the, both the grant records, measure it, survey and make a. That's all not he has said.
Allah, how, but
Now, there could be no injustice, nor they could make, need to make any grievance. 1980 body is not without notice to me. I am not a partner.
correct.
But they make surveyors, not one grant record should be sent to the survey department. It will
Out
be
the
there
vacant
for
idea,
30 years. One fine day they make a survey.
Shastri sir, ಈಗ ಸರ್ವೆ ನಂಬರ್ 95 vacant ಇದೆಯೋ ಡೆವಲಪ್ಡ್ ಇದೆ ಈಗ
ಖಾಲಿ ಇದೆ.
ಈಗಲೂ ಸೈಟ್ಸ್
ಅದು ಖಾಲಿ ಇದೆ, ಅದು ಖಾಲಿ ಇದೆ.
ಕನ್ವರ್ಟೆಡ್ ಅಂಡ್ ಅಪ್ರೂವ್ಡ್ ಲೇಔಟ್
ಅವರು ಕನ್ವರ್ಟ್ ಆಗಿದೆ.
Converted
ಅಂತ ಹೇಳ್ತಾರೆ.
ಆಯ್ತು ಅಪ್ರೂವ್ಡ್ ಲೇಔಟ್ ಇಟ್ಸ್ ಅಪ್ರೂವ್ಡ್
Converted layout.
Yes.
Whatever it is. Lord, what area which they have, but land is a vacant land, there is no.
ಆಯ್ತು ಆದ್ರೂ ಒಂದ್ ಸ್ವಲ್ಪ ಸ್ಕೆಚ್ ನೋಡಿಲ್ಲ ಒಂದ್ಸರಿ ನಮ್ ಜೊತೆಗೇನೆ
ಹೌದು, ಎಲ್ಲಿದೆ?
ಅದ್ಯಾಕೆ ನೋಡಕ್ ರೆಡಿ ಇಲ್ಲ ನೀವು
ಇಲ್ಲಿ ನೋಡ್ತೀನಿ ಸರ್, ಎಲ್ಲಿ ಅವ್ರದ್ದು ಯಾವ್ದು ಸ್ಕೆಚ್ ಸರ್ ನಿಮ್ದು? ನೋಡೋಣ.
ತೋರಿಸ್ರಿ ಸ್ಕೆಚ್
ನೀವೆಲ್ಲ ಹಾಕಿರ್ತೀರಿ ದೇವರಹಳ್ಳಿಯಲ್ಲಿ ಸಾವಿರಾರು ಎಕರೆ ಮಧ್ಯೆ ಒಂದು ದೊಡ್ಡದು ಲೇಔಟ್ ಮಾಡಿರ್ತೀರಿ, ನಮ್ ಜೀವನಲ್ಲೇ ಮಾಡಿದಿರಿ ಅಂತೇನು, ಎಲ್ಲಿ ಹೇಳಿ?
1965 ಎರಡ್ ಸತಿ ಮಾರಿದೀರಾ ಬಿಡಿ, ಇನ್ಯಾಕೆ
ಈಗ ಇಲ್ಲಿ ಬರ್ರಿ ಇದು ತೋರಿಸ್ರಿ ಸ್ಕೆಚ್
ಪೇಜ್ ಇವಾಗ ಹೊಸ ಸರ್ವೆ ನಂಬರ್ ಆಗಿರೋದು sir.
Please don't fight with Shastri sir. He's very fair and
Hello,
polite.
my lord, last time when we said, my
Don't
learned
fight
friend said, senior counsel said, we created antedated.
Hello,
They tricked me to search for other documents.
ತೋರಿಸ್ರಿ ಅದು ಸ್ಕೆಚ್ come to page 59.
69,
59.
59. ರಿಟ್ನಲ್ಲ ಸರಿ, ಅದರಲ್ಲಿ
ರಿಜೈಂಡರ್ ಜೊತೆಗೆ
ಇದು ಅಡಿಷನಲ್ ಈಗ ಹಾಕಿದಾರಲ್ಲ
P4.
ಈಗ ಇದ್ರಲ್ಲೇನೆ ಸರ್ ಒಂದು ಲೈಟರ್ ನೋಟ್ ಶಾಸ್ತ್ರಿ ಸರ್, ಈ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಇಲ್ಲಿ ಪೇಪರ್ ಅಲ್ಲೇನೆ ಅಲ್ಲಿಂದ ಅಲ್ಲಿ ಬರೋಕೆ ಒಂದು 3 ತಾಸು ಬೇಕು ಬೆಂಗಳೂರಲ್ಲಿ, ಅಷ್ಟು ದೂರ ಇದೆ ಎರಡು.
ಮನೆ ಮಧ್ಯ ಬಂದು
Now see,
ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡಿದ್ದಾರೆ.
95 it's on the extreme left side
ಯಾವುದು?
and survey number 95
ಹೌದು.
ಆಯ್ತಾ, survey number 140 is at the bottom extreme right side.
Survey number 95 is there, right?
On the extreme ಅದು ಸೆಕೆಂಡ್ 96 ಕೆಳಗಡೆ 95
0 ಕೆಳಗಡೆ.
See ಅದು ನೋಡಿ ಕ್ರೊನಾಲಜಿಕಲ್ ಇದೆ 93 94 95 96 ಅದು ವೆಸ್ಟರ್ನ್ ಸೈಡ್ ಇದೆ ಸರ್.
ಹೌದು.
ನಿಮ್ದು 140 ನೋಡಿ ಎಲ್ಲಿದೆ ಸರ್? 140
ಜಾಗದಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ.
140 ಎಲ್ಲಿದೆ ನೋಡಿ ಸರ್?
140
is at the bottom.
ಅದು ಇದೆ ಸೆಪರೇಟ್ ಜಾಗದಲ್ಲಿ.
They are not the adjoining property.
ಲಾಂಗ್ ಡಿಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಾರೆ.
ಈಗ adjoining ಇಲ್ಲ ಅಂದ್ರೆ ಸರ್ ಛಾತ್ರಿ ಸರ್, adjoining ಇಲ್ಲ ಅಂದ್ರೆ ಒಂದ್ ನಿಮಿಷ
ಸರಿ,
adjoining ಇಲ್ಲ ಅಂದ್ರೆ
ಹೌದು.
the court question is what is their locus to challenge their coding?
ಚಾಲೆಂಜ್ ಅಂತ ಕೇಳ್ತಾ ಇಲ್ಲ, ನಾನ್ ಕೇಳಿದ್ದೆಲ್ಲ ನಂದು ಸರ್ವೆ ಮಾಡಿ ಅಂತಲೇ ಅಷ್ಟೇನೆ.
ನಿಮ್ದು ಸರ್ವೆ
ಇದರಲ್ಲೂ ನೋಡಿ ಅವ್ರ ಲಾಸ್ಟ್ ಗೆ ಕೆಳಗೆ ಹೇಳೋದು ಹೈಯರ್ ಆಫೀಸರ್ಸ್ ಪರ್ಮಿಷನ್ ಬೇಕು, ಇಲ್ದಿದ್ರೆ ಇದನ್ನ ಅಪ್ರೂವ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. ಕೆಳಗಡೆ ಡೌನ್ ಅಳತೆಗೆ ಹೋಗಿ ಅರ್ಜಿದಾರರ ಬಾಬ್ತು ಮಂಜೂರಿ, ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್, ಮಂಜೂರಿ ವಿಸ್ತೀರ್ಣ ಹಾಗೂ ಅನುಭವ ಅನುಸರಿಸಿ ಅಳತೆ ಮಾಡಲಾಗಿ ರೆವಿನ್ಯೂ ನಕ್ಷೆಗೂ ಅನುಭವ ಸ್ಥಳಕ್ಕೂ ವ್ಯತ್ಯಾಸವಿರುವುದರಿಂದ ಬೋರ್ಡಿ ನಕ್ಷೆಗೆ ಸಕ್ಷಮ ಅಧಿಕಾರಿಯವರಿಂದ ಅನುಮೋದನೆ ಆಗಬೇಕಾದ್ರಿಂದ ಅನುಮೋದನೆ ಸಲ್ಲಿಸಿಕೊಳ್ಳುವ. ಸೆಂಟೆನ್ಸ್
ನೋಡಿ, ಆಮೇಲೆ ಸರ್ವೆ ನಂಬರ್ 60 ಅನ್ನ ಅದನ್ನ ರಿಅಸೈನ್ ಮಾಡಿ 140 ಅಂತಾನು ತೋರಿಸ್ತಾರೆ.
ಹೌದೌದು.
And
ಈ ನಕ್ಷೆಯಲ್ಲಿ
ಹಾ.
ತಾವು ಹೇಳಿದಾಗ ಬೇರೆ ಬೇರೆ ಜಾಗದಲ್ಲಿ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ, ನಮ್ದನ್ನು ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ದಾರೆ ಸ್ಕೆಚ್ ಅಲ್ಲಿ
ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ದಾರೆ.
So there is no dispute.
ಮಾಡಿದ್ದಾರೆ ಅದು.
ಅಲ್ಲ, you can seek fresh survey of survey number 60/6. They will not object it. Get your land surveyed 60/6. There is no overlapping. We don't know whether you assuming that survey number 95 60/6 you try to lay a possession and you claim possession. We don't know. But
We don't know. Milord, it can be that the Tahsildar gives such an endorsement. No, you are in possession of 95. Therefore, it has to be cancelled. ಅವರು ಒಬ್ಬೊಬ್ರು ಒಂದೊಂದು ಗದ್ದಲ ಶುರು ಮಾಡ್ಬಿಡ್ತಾರೆ. ನಮ್ಮವ್ರದ್ದು ಇಷ್ಟೇ ರಿಕ್ವೆಸ್ಟ್, ನಂದು 60/6 ನನಗೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ ನಮ್ಮ ಮುನಿಮುದ್ದೂರಪ್ಪನಿಂದ, ಅದನ್ನು ಐಡೆಂಟಿಫೈ ಮಾಡಿ. ನಾನು 60/6
ಅಲ್ಲ, ಈಗ ಇದು ಅಪ್ರೂವ್ಡ್ ಇದೆ, ಇದು ಪಬ್ಲಿಕ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದು.
ಹೌದು
Page 59 is a public document.
ಹೌದು.
Take this document and now that the fact that you now reveal that you have already filed a comprehensive suit.
Right.
I think this exercise is complete futile. All that I will say is, as per these records, 95 and 140 are distinct properties. The 4D obtained by petitioners and erstwhile owners pertains to survey number 95. You are not laying a claim over survey number 95. Your property falls within 60, survey number 60/6. Work out a remedy in pending suit. ಆಮೇಲೆ ಇನ್ನೊಂದು on maintainability. I am going to say that Deputy Commissioner had no competence. He lacked total jurisdiction and authority.
ಸರ್ ಸೆಕ್ಷನ್
ಅದು-
56 ಅಲ್ಲಿ ಪವರ್ ಇದೆಯಾ ಅಂತ ನಾವು ಒಂದ್ಸಾರಿ ನೋಡ್ಕೊಂಡ್ರೆ ಒಳ್ಳೆ.
ಅದು
ನಾನು
ತೋರಿಸಿ
just want to
ಅಲ್ಲ ಸರ್, no. Deputy Commissioner, Assistant Commissioner, they are on the revenue side. ಅದ್ಯಾವ್ದು ಸೆಕ್ಷನ್ 49 ಕೆಳಗಡೆ ಇದೆ ಬೈಫರ್ಟಿಫಿಕೇಶನ್. ಒಂದು ಮ್ಯೂಟೇಶನ್ ಅವ್ರದ್ದು DC, AC, ತಹಶೀಲ್ದಾರ್, ಡೆಪ್ಯೂಟಿ ತಹಶೀಲ್ದಾರ್. ಈ ಕಡೆ ಸರ್ವೇಯರ್, ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಲ್ಯಾಂಡ್ ರೆಕಾರ್ಡ್ಸ್, ಡೆಪ್ಯೂಟಿ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಲ್ಯಾಂಡ್ ರೆಕಾರ್ಡ್ಸ್. So there is complete bifurcation because it's a technical. Survey is a technical. Tashildar can be a non-technical, assistant commissioner can be non-technical. So these are two bifurcated zones. There can't be overlapping. So therefore, deputy commissioner cannot examine the 4D done by a competent authority and confirmed by JDLR. DC even cannot sit over a JDR's order, which your client has suffered. So we'll not get into all those things. This exercise is futile. Fall back, go back to civil court, substantiate your title, prove your case, take a decree. ಇದು ಬಿಟ್ಟು ಏನಾದ್ರೂ ಹೇಳಂಗಿದ್ರೆ ನಾನು ನೋಟ್ ಮಾಡ್ಕೊತೀನಿ ಸರ್. ಶಾಸ್ತ್ರಿ ಸರ್,
ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ಅಲ್ಲಿ ಅದಕ್ಕಿಂತ ಬೆಸ್ಟ್ ಐ ಡೋಂಟ್ ಥಿಂಕ್ ದಟ್
ಸುಮ್ಮನೆ ಇದೆಲ್ಲ ಇದು
ಈ ಸರ್ವರ್ ಒಂದು ಸಾರಿ ಸೆಕ್ಷನ್ 56
ಅದು ನೋಡ್ಬಿಡಿ ಸರ್.
ಜಸ್ಟ್
ಎಸ್ ಸರ್.
ಪವರ್ ಆಫ್ ಡಿವಿಷನ್. The tribunal, any revenue officer not inferior in the rank to an assistant commissioner, and any survey officer not inferior in rank to a superintendent of land records, or an assistant settlement officer in their respective department, make off call.
ಅದೇ ಅಲ್ಲಿ ಈಗ ಸ್ಟಾಪ್ ದೇರ್. ಅದಕ್ಕೆ ರೀ, ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ, ನಿಮ್ಗೂ ಗೊತ್ತಿದೆ, ಕ್ಲಿಯರ್ ಇದೆ ಅದು. ದೇರ್ ಇಸ್ ನೋ ದಿಸ್ ಆನ್ ರೆವೆನ್ಯೂ ಸೈಡ್ ದೇ ಕಾಂಟ್. Similarly, ADLR cannot sit on mutation proceedings. Bifurcation. That's all.
Our right to be protected, that's all.
Of course, of course.
That,
No, I can't protect your right, madam. I'll say that this order has to go. This order has to go.
Still this order will go back because and already my application is allowed. And there is a clear order because we are the most affected party. And even then, our application is still showing as an Impleading application. That your should consider that.
Facts ಎಲ್ಲ ನೋಡ್ಬೇಕಾ ಶಾಸ್ತ್ರಿ ಸರ್? or on the short point it can be. Too many statement ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ.
There are only facts here, no law. Lot of facts are mixed up.
But issue is very limited, sir. Very short point. And your title also will not go. You are entitled to retain 60/6. I don't know why you are linking to that. There is some dispute, sir.
So there is some dispute. What is actually this? What God alone knows. We will not knowing that mixed up with the several realtors drawing this side, that side. They want the sketch to be changed to their wish, to align some add a deletion. There will be several things here. Amending unseen things behind the scene that we will not be knowing.
One submission, against the order of MA, there is already a writ petition is filed.
It's all. ಮೇಡಮ್ ಇದು ಇರಿಟಲ್ಲಿ ಅದೆಲ್ಲ ಪೊಸಿಷನ್ ಬರಲ್ಲ ಮೇಡಮ್. ಮೇಡಮ್ ನೀವು ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು ಬೆಂಗಳೂರಲ್ಲಿ. ಈ ಎಲ್ಲ ಇಂಜಂಕ್ಷನ್ ನಮ್ಮ ಹತ್ರ ತಗೋತಾ ಇದೀರಿ ಈಗ. This court is Assistant Commissioner's Court, Deputy Commissioner's Court, Civil Court. No. I'll just make a passing remark that survey number 95 and 60 are two distinct properties, which can be gathered from the sketch which you have produced. Purported. This petition is filed. Assailing the order passed by second respondent Deputy Commissioner, which is dated 26/3/2011, evidence at Annexure H. Facts leading to the case are as under. The petitioners are concerned with survey number 95, old survey number 60, measuring 5 × 10 guntas. Petitioner is tracing title through one Muniyamma and others.
Muniga,
Muniyamma ಅಂತಿದೆ ಅಲ್ಲಿ.
Muniga.
ಮುನಿಯಮ್ಮನ ಮುನಿಯಗ
Muniga.
Wife of Maniga ಇರಬೇಕು.
ಅದೇ ಮುನಿಯಮ್ಮ
ಆಮೇಲೆ purchase ಮಾಡಿ.
through one Muniyamma and others under registration sealed dated 19/9/2000.
2000.
ಮುನಿಯಪ್ಪನವರ ಧರ್ಮಪತ್ನಿಯಾದ ಮುನಿಯಮ್ಮ.
Correct.
Petitioner contends that erstwhile owner acquired the property in a public auction conducted by revenue authorities in respect of a Goma land in survey number 57, 58 and 60, which totally measured 100 acres. Full stop. Petitioners claim that since grantee violated the conditions for having failed to cultivate the granted land, the authorities cancelled the grant void order dated 22/12/1947, and the land was subjected to auction. Petitioners therefore claim that erstwhile owner Moniga participated in auction and purchased survey number 60, and this land was assigned new survey number 95 while effecting 4D proceedings. Next, fifth respondent, sixth respondent. Submitted a petition on 16/12/2007 before the fifth respondent, requesting to conduct a survey in respect of land bearing survey number 60/P6. The jurisdictional Tahsildar, however, issued an endorsement indicating that such land is now assigned a new survey number 95, and therefore he lacks authority to cancel the Durasti proceedings. This endorsement correct, Annexure C is the endorsement, Allah. This endorsement was assailed before Deputy Commissioner, Allah. Second respondent, Deputy Commissioner. Notary correct. Annexure C na endorsement of
Annexure C. Page number 30.
Deputy Commissioner. Where is the operative portion? What he says now, Deputy Commissioner?
Page number, Annexure D, page.
Annexure H.
Sorry, Annexure H.
What he has done?
Page number 72 is the page.
The second respondent, Deputy Commissioner. While order impugned in the caption petition, evidence at Annexure H has come to conclusion that that the durasti done in survey number 60, which led to reassigning a new survey number 95, ಇಲ್ಲ ಏನ್ ಬರ್ದ್ರಿ? has come to conclusion that survey number 60, which is granted to the ancestors of sixth respondent.
Action, purchased in action.
Huh?
Which is granted to them.
Which is granted to them is part and parcel of survey number 95. ಹಾಗೆ ಅಂದಿರೋದು. And therefore, the 1980 Fodian Durasti conducted by the authority and affirmed by JDLR is set aside. Correct?
Okay.
And matter is remitted for fresh inquiry. This order is under challenge by the petitioner. Are the learned counsel appearing for petitioner? Learned counsel appearing for respondent number 6A. 6A to 6C. Learned counsel appearing for respondents. Madam Yadagiri. Respondent number 7. Respondent. ಇದು ನೀವು ಇದು ಮಾಡಿಲ್ರಿ ಅಮೆಂಡ್ ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ರು.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್
Respondent ಅಲ್ಲ petition.
ಅಂಡ್ ಲೆಟರ್ ಯಾರು ಗವರ್ಮೆಂಟ್ ಕಡೆಯಿಂದ ಯಾರು? ಅಂಡ್ ಲೆಟರ್ ಡಿಜಿ ಅಪೀರಿಂಗ್ ಫಾರ್ ದ ಸ್ಟೇಟ್. The parties in support of their claims have placed on record exhaustive documents to substantiate the respective claims. The petitioner name synopsis alladari. Where is your synopsis?
Synopsis I have not fed. Not fed synopsis. Synopsis. No.
The petitioners contain that they have vendor who participated in public auction purchased 2 acre 20 guntas in survey number 60.
5 acres, sir.
Purchased 5 acre 20 guntas in survey number 60 in a public auction, and after auction, the authorities conducted Fodian Durasti, and the portion purchased our resident of public auction Muniga was carved out and reassigned a fresh survey number 95.
The extent is 5 acre, 10 guntas.
Which measures 5 acres?
10 guntas.
10 guntas, 10 guntas. Next. While the private respondent number 6 is tracing right hand title through her father Muni Madurappa, which is in respect of survey number 60/6. The original respondent number 6 claims that her father was granted 2 acre 20 guntas in survey number 60/6. Sagoli chit was issued on 4/7/1963 in favor of 6th respondent's father Muni Madurappa, which is evidence at annexure B1 to statement of objection. Respondents further claim that Muni Madurappa sold the granted land in survey number 60/6 in favor of 1 Ramakrishnappa under registration sale dated 18/12/1965, who in turn sold to 1 Venkojappa on 19/9/1968. 6th respondent, with the daughter of original grantee Muni Madurappa, however, invoking the provisions of PTCL Act, filed a petition seeking restoration on the ground that that the alienation made by original grantee was clearly in contravention of provisions of PTCL Act. Sixth respondent therefore claims that the application petition filed under section 4 and 5 was allowed, and the land which was alienated by original grantee was restored, and possession was handed over to sixth respondent. Next, petitioners contend that after restoration, however, there was an anomaly in the RTC.
Petitioner, respondent.
ಏನ್ ಬರ್ದ್ರಿ? ಇಲ್ಲ, sixth respondent further contends that pursuant to restoration proceedings, there was some anomaly in the RTC as the property was reassigned a fresh number as 60/P5. As this led to its identification problem, sixth respondent promptly moved an application to the Tahsildar to conduct a survey of survey number 60/6, which was restored to petitioner's possession. ಅಲ್ಲಿ ಮಾಜಲ್ ಡ್ರಾ ಮಾಡ್ಬೇಕಾದ್ರೆ ಯಾವ್ದು ಕೊಟ್ರು ಮತ್ತೆ ನಿಮಗೆ? ಮತ್ತೆ ಅದು ಆನ್ ಗ್ರೌಂಡ್ ಫಿಸಿಕಲ್ ಪೊಸಿಷನ್ ಕೊಟ್ಟಿರ್ತಾರೆ.
ಫಿಸಿಕಲ್ ಪೊಸಿಷನ್ ಇದೆ. ನಮ್ಗೆ ಪಾಣಿ 63 ಮಾಡಿದಿರಲ್ಲ, ಸರ್ವೆ ಮಾಡಿ ನಮ್ಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ನಮ್ಗೆ ಪಾಣಿ
ಕೊಟ್ರೆ ಹೇಗೆ? ಮತ್ತೆ ಸರ್ವೆ ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಕೊಟ್ರೆ ಹೇಗೆ?
ಅದು ಓಡಿ ಮಾಡಿ ಸರ್ವೆ ನಂಬರ್ ಕೊಡ್ಬೇಕು ನಮ್ಗೆ 60/P5 ಗೆ ನಮ್ಗೆ ಸರ್ವೆ ನಂಬರ್ ಕೊಡ್ಬೇಕು, ಅದು ಎಂಟ್ರಿ ಬರ್ಬೇಕು RTC ಅಲ್ಲಿಗೆ ಕರೆಕ್ಟ್ ಆಗಿ.
The Tahsildar, however, declined to entertain this application on the premises that survey number 60 has already undergone 4D Durasti, and therefore he lacks jurisdiction to entertain, to conduct a fresh 4D. This endorsement was challenged by sixth respondent before second respondent deputy commissioner. Second respondent deputy commissioner has entertained a revision, has entertained a revision and has virtually set at naught the 4D conducted in 1990, which was in fact affirmed by JDLR on an appeal filed by ಯಾರಕ್ಕಿದ್ರು ಅವಾಗಲೇ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 6
Respondent, original sixth respondent.
Respond number 6. ಎಲ್ಲಿದೆ ಅದು ಆರ್ಡರ್? JDLR order,
Annexure D.
which is evidenced at Annexure D. Paste it. Next. On deeper examination of the documents which are now produced by petitioner and counter documents furnished by respond number 6A to 6E, the issue on hand needs consideration in two folds. Firstly, this court needs to examine as to whether second respondent deputy commissioner, while testing an endorsement issued by Tahsildar who had declined to conduct 4D, could have set at naught an order passed by the joint director of land records who is superior to deputy commissioner on surveyor side, correct? This court also needs to examine as to whether deputy commissioner, being a revenue head of a division, acting under section 56 of Karnataka Land Revenue Act, could have set aside the 4D conducted in 1990 and affirmed by JDLR, which is evidenced at Annex D. My answer is emphatically no. Deputy Commissioner prima facie had no jurisdiction to examine the legality or otherwise of a 4D and Durasti conducted in 1980, which was affirmed by a joint director of land records via Annexure D. Next, on closer examination of additional documents which are not placed before this court at this juncture is of the view that the property held by petitioners and by respond number 6 are two different and separate properties. Additional document which is at page 59 of memo dated 31/1/2024 clearly demonstrate that survey number 95 and survey number 140 are two different and distinct survey numbers and are placed apart and are not admittedly adjoining lands. Next, be that as it may, learned counsel appearing for respondents 6A to 6C while addressing his arguments has brought to the notice of this court that the sixth respondent, that respondent number 6A has now instituted a suit in OS 718 of 2022 seeking relief of declaration and injunction on a query by this court in regard to the property involved in the suit. The counsel on record fairly concedes that the subject matter of suit filed in OS 718 of 2022 is survey number 60/6. If a comprehensive suit is filed against the petitioners, this court is of the view that parties need to be relegated to work out their respective claims in a pending suit in OS 718 of 2022. These public documents can be relied by the respective parties to substantiate their respective claims. This court, having come to conclusion, the deputy commissioner could not have settled not the Fordian Durasti conducted in 1980, is of the view that respondent 6A to 6C have to establish their title independently by placing reliance on title documents in support of their claim. The respondent 6A to 6C have to also discharge their burden as there is no rival claim over survey number 60/6. On closer examination of the documents cited by both the parties, this court is not in a position to figure out the actual dispute between petitioners and respondents. The core question as to whether the insistence of respondent 6A to 6C to survey 60/6 virtually is an indirect claim over survey number 95 has to be exhaustively dealt by civil court by securing evidence from both sides. While both the parties are laying a claim over a separate and a distinct property, however, there appears to be some remote nexus between their claims and overlapping of the properties from what can be gathered from the pleadings made by both the respective parties. However, the sketch at 59 gives an insight in regard to the location of survey number 95 and survey number 40. Next. One being conscious about survey number 140. 140. This court being conscious of scope of inquiry under Article 227 deems it fit to relegate both the parties to substantiate their claims in the pending suit. At the same time, this court is of the view that the impugned order passed by second respondent lacks jurisdiction and authority and same is not sustainable and is accordingly liable to be set aside. For the foregoing reason, this court passes the following order. Writ petition is allowed. Impugned order dated so and so is hereby quashed and set aside. All contentions are kept open. Parties to seek redressal of their respective claims and rights in the pending suit bearing OS number 718/2022. ನಾನು ಶಾಸ್ತ್ರಿ ಸರ್ ನಿಮ್ದು ಮತ್ತೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ನೋಡಿ ಸ್ವಲ್ಪ ಆಡ್ ಮಾಡ್ತೀನಿ. ದಿಸ್ ಇಸ್ ನಾಟ್ ಪಾಸಿಬಲ್. ಅಷ್ಟು ಸ್ವಲ್ಪ ಆಡ್ ಮಾಡ್ತೀನಿ ನಿಮ್ಮ ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲ. ಏನೂ ಇಲ್ಲ. ಯಾವ ಸೂಟು Burden, I said the burden is on them. Allah, you can't, no, see, you can't injunct them from laying a claim over survey number 95. Let them prove. You file an impleading application to be on the safer side. ಏನ್ ಬೇಕು? Respond number 7. If respond number 7 chooses to contest, liberty is reserved.
Very, very short issue, Your Lordship, arises for Your Lordship's consideration.
ಯಾವ್ದಿದು serial number?
Serial number 4, Your Lordship.
ಹಾ.
Your Lordships have heard it for some time. We had filed written synopsis also, but I take Your Lordship's pronounce it is.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ, ರವಿಶಂಕರ್ ಎಲ್ಲಿದ್ದಾರೆ? ಅದರ್ ಸೈಡ್ ಇದ್ರೆ ತಗೋತೀವಿ. ಬರ್ತಾ ಇಲ್ವಾ ಅವರು?
Last time ಕೂಡ ಬಂದಿದ್ದಿಲ್ಲ.
Why they are not coming? ಯಾರು? ಸ್ವಾತಿ ಅಶೋಕ್ ಯಾರು?
Boardಗೆ ಯಾರೋ ಹೊಸ
ಹಾ? 5 times ಬಂದಿಲ್ಲ.
ಅವರು ಬರ್ತಿಲ್ಲ. ಅವ್ರು ಒಂದೇ ಒಂದ್ಸಲಿ ಬಂದ್ರು. ಅಬ್ದುಲ್ ವಹಾಬ್ ಅನ್ನೋದು ಅವ್ರಿಗೆ ಒಂದೇ ಒಂದ್ಸಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದ್ರು ಅಷ್ಟೇನೆ. ಆಮೇಲೆ ಮತ್ತೆ
And you want early disposal?
Yes.
ಅಲ್ಲ, you want early disposal? No, ನಾನು DNP ಮಾಡಲ್ಲ. My difficulty. I would rather lock it by taking it parted and decide it, but no DNPs.
No, sir, I just take Your Lordship because.
ಅಲ್ಲ, but are you sure that the lawyer is there ಅಂತ ಅವ್ರು ಮಾಡ್ತಾ ಇದಾರ? ನಿಮ್ನ half an hour 1 hour ಕೇಳ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅವ್ರು ಬರ್ಲಿಲ್ಲ.
Your Lordship, of course.
Land reforms matter.
This was argued by me and the senior counsel who had appeared.
ನಮ್ಮ ಮುಂದೆನಾ?
ಹೌದು, ತಮ್ಮ ಮುಂದೆ ಕ್ಲಿಯರ್ ಆಗಿತ್ತು ಮ್ಯಾಟರ್. ಕ್ಲಿಯರ್ ಆಗಿತ್ತು ತಮ್ಮ ಮುಂದೆ. ಆಮೇಲೆ ಅದು ಈಗ ಬಂದಿದ್ದು ಒಂದ್ 2 ನಿಮಿಷ ತಗೋತೀನಿ. ಆಮೇಲೆ Your Lordship may give a date. Lies in a very short compass. Lordship may kindly take writ petition 4874 of 2012. Any one of this writ petition.
ಹಾ.
Page number 73 is the earlier writ petition order. Everything revolves around this order. It's an order of remand. This is a Qazi service Inam as entered in the quit rent register and the Inam register. Section 1(3) of the Personal and Miscellaneous Inams Abolition Act includes Qazi service Inam as a miscellaneous Inam. Jurisdiction, by virtue of the amendment, is vested in the tribunal. That there is no difficulty. Then Your Lordship may kindly take page 73, the orders dated 26/6/1997, where the regrant of land in my favor was challenged by Abdul Wahab, who is the present petitioner. Lords, I'll just take Your Lordships to the operative portion at page 76. 76. The impugned order of 31/7/82 passed by Land Tribunal, whereby it had rejected the claim of petitioner, is granted and further granted occupancy rights to respondent number 1 is quashed. Matter is remanded to the Land Tribunal Anekal, respondent number 3 herein, with a direction to afford an opportunity to the petitioner to adduce additional evidence, both oral and documentary. In view of that opportunity to the petitioner, let the tribunal also afford reciprocal opportunity to the respondent number 1, 2 to adduce additional evidence, if any, from his side. Land Tribunal is further directed to pass considered order thereon by taking into consideration the evidence that was laid in by both sides earlier to the appeal, and further by taking into account the additional evidence, if any, by the parties to adduce evidence before it in the future. Land Tribunal shall hold that limited inquiry after issuing notice to all parties concerned by following Rule 17 of the Land Reforms Act in strict compliance. Now kindly have a look at the cost item. One of the writ petitions will go because of this order. Page 73, second respondent is Waqf Board. They were represented before the court.
Yes.
Now, one writ petition, that is WP number 26096. That is the first writ petition. 26096 is filed by the Waqf Board.
26.
Yes. If the specific remand order is only to give opportunity to myself and the petitioner Abdul Wahab and then conclude the proceedings. It's a limited remand order, limited inquiry. This order is not challenged by the Waqf. Notes the principles of constructive res judicata explanation.
Petitioner to petitioner to the additional evidence. Only reciprocal opportunity. only
Reciprocal
to
opportunity. ಆಮೇಲೆ ಕೆಳಗಡೆ limited enquiry. The court consciously uses the word limited enquiry.
ಈಗೇನಾಗಿದೆ now what is it?
Now, work board now files the writ petition challenging. Now, after this remand order, further evidence was adduced. Then occupancy rights is granted in favor of the present contesting respondent. Work board challenges the order saying that after the vesting of property in 1954, subsequently in the year 1968, we have declared this as a work property.
What is the law on that point?
But that division bench has already spent with this issue. But that is Karnataka Work Board versus State of Karnataka.
And who are you? You are the tenant?
But I am the tenant. Now it is already tenant under a registered instrument of 1953.
From the holder?
Yes. Now it's a Qazi service Inam. So whoever was the Qazi at that point of time, he is executed a registered document. He admits the receipt of Vara. And there are two independent witnesses who are examined to show that we are cultivating the property and Vara was given. There is an admission that Vara was being received. And revenue documents from 62-63 when they have maintained clearly shows that we are in cultivation of the property. All these documents are relied for the purpose of giving a finding that we are the tenants in respect of the property and re-grant order.
And who was opposing you?
But now only the work board strictly because last
No. Who is R1?
R1 Milords is the Qazi, is the legal representative of the Qazi. So far as Qazi is concerned, he came before the court, the LRs of the Qazi came before the tribunal and when adducing the evidence, they admitted that their ancestors had received Vara.
Now, Inam was to an individual or to the institution of the
Inam, that distinction is there. Not Inam when it is to a service, then it is not a dedication to the mosque.
Not a dedication.
Not dedication to the mosque. This is a very question Milords came up for consideration before a Madras court. Of course, a very old decision. But it distinguished as to why it becomes a service Inam and not an Inam which is attached to the institution as such. That distinction is there. I have filed the synopsis, I have referred to the judgment. I have given the copy of the judgment also.
Because I have relied and now I have written a judgment ಅಂತ ಬರ್ತಾ ಇಲ್ವಾ ಅವರು?
ಈಗ ತಮ್ಮದೇ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
ಅದಕ್ಕೆ ಬರ್ತಾ ಇಲ್ಲ ಅಂತ ಅವರು.
ಬಹುಶಃ ಅದೇ ನಾವು ಅದನ್ನ ಸೈಟ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಸಿನಾಪ್ಸಿಸ್
ಅಲ್ಲ why already I'll take it as part of then short point.
This is the short point.
And what are the other two petitions who has filed it?
Now Work board challenges the order passed granting occupancy rights in my favor. The interim order is not granted by your lordships. When the writ petition is pending and the order of the land tribunal is in force, they initiate proceedings saying that I am a trespasser. So those are the two orders.
Yes,
those two orders are subject matter of challenge in the writ petitions filed by me, where interim orders are granted. So far as Abdul Wahab is concerned, he was a Qazi.
Earlier it was filed by whom? You only?
Only Abdul Wahab.
Who is Abdul Wahab?
He is the person who claims to be the Inamdar or the person who was rendering Qazi service.
Now you appear for tenant, are there?
I appear for the tenant in whose favor the present order is granted. Right?
Who is
the second order?
You appear for respond number?
In this WP number 487, I am respondent number 2. I'm sorry, respondent number 3.
Reddy alva?
Reddy.
3 and 4. Earlier.
Once the first.
No, just a minute. There is a technical issue. I think you didn't notice it. Even on earlier occasion, land tribunal conferred occupancy rights on you?
Yes.
Holder challenge, Waqf tribunal did not challenge.
That's the rise. Waqf tribunal never came before the court and challenged, but they were made as a party respondent.
But first order was not challenged by them.
No. That's the reason why I said constructive adjudicator operates against them. And once in the first writ petition, this is a contention which might and ought to have taken for giving them an opportunity.
On the brief synopsis.
I've given
synopsis ಹಾಕಿದ್ದೀರಾ?
I've filed a synopsis. Yeah.
ರವಿಶಂಕರ್, ನಿಮ್ಮ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡ್ರಿ ಅವ್ರಿಗೆ. Adjourned by imposing a 10,000 cost on the council appearing for petitioner. Payable to work out this yesterday adjournment agidare without repetition. And tell them that this money will go on adding up. ಸರ್ ಆಗಿದೆ ನಾನು.
ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅವ್ರು ಬಂದಿರ್ಲಿಲ್ಲ.
ಆಯ್ತು ಬೇಡ ಇರಿ, ಇದು ಒಂದ್ಸರಿ ಬೇಡ ಇರಿ. There is no representation on behalf of petitioners. By way of final intelligence, matter is treated as part heard. Registry is directed to release this matter next Monday revision kar.
Please.
All right, part heard, treated as part heard.
Lords, as a matter of fact, we cited when the matter was heard that your lordships have passed the judgment in the matter. That is in writ petition 103351 Kotraya's case, following the division bench judgment.
Correct.
Saying that moment there is a vesting of property under the Inam's Abolition Act, all rights including the declaration as a work vanishes. So two situations. One declaring it as a work prior to the act coming into force. One declaring it after the act comes into force. After the act comes into force, it has no significance because property is vested. It will be fully regulated under the provisions of the Inam's Abolition Act. That is the view taken by a coordinate bench. There are two judgments which said that after vesting, whatever notifications you make is subject to the final outcome of the decision to be taken by the tribunal. Prior to that is decided by the division bench, and your lordships have followed it, saying that prior to that gets merged with the notification for vesting the properties under Inam's Abolition Act. So either of the ways, lords, work will not have a case.
ಎಲ್ಲರೂ application ನೋಡೋಣ. Yes, sir. Yes, 5.
For respondent B.
Yes, sir. It is the land reforms.
Equal application.
Compromise.
We are making one submission on behalf of KK Vasan sir. He is well today, but tomorrow may be meeting. Today it is been difficult.
ಇದ್ರು ಅವರೆಲ್ಲ every date ಇದ್ರು. ವಸಂತ್ was there on each date.
ಒಂದು ದಿವಸ ಮಾತ್ರ ನಾನು ಹುಷಾರು.
Today we are asking.
ನಾನು ಅವ್ರನ್ನ ಕೇಳಿಲ್ಲ.
ಹೇಳಿಲ್ಲ.
And I always come to the soul.
ಇಲ್ಲ ವಸಂತ್ was there all the times. ಇದ್ರು ಅವ್ರಿದ್ರು. Now Shivkumar, you have an interim order.
As a respondent.
You took interim order when I was in Kalburgi, correct? All right. Kodri. A short judgment is sought on behalf of KK Vasant, who is not keeping well. Prayer is allowed. Yavaga, Shivkumar avare. Is the short point idea? What is this problem?
So far as
You said there is some fraud and you point.
Yes, what happened is, but I was a party in the proceeding. And the respondent died. On his death, the petitioners filed a memo before the court that he has no right in respect of the property. His legal representatives are not property. The legal representatives are now filed an application saying that you have not been given an opportunity. After removing me from the records, they compromise the petition. I have a right in respect to the property is what I say. But the legal representatives ought to have been heard.
ಅಲ್ಲ ಈಗ ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ ನೀವು?
ನಾನು impleading ಹಾಕಿದ್ದೇನೆ as legal heirs.
ಅಲ್ಲ to recall that order.
Recall the compromise. And I don't get an opportunity. The legal heirs are to be heard.
Because this court has recorded compromise, it has to be dealt and heard by this court.
And the Land Reforms Tribunal has categorically held that the petitioners have no right in respect of the property.
Or a tenant.
Order is passed.
They are tenants.
They claim that they are tenants.
Yes.
But the Land Reforms Tribunal contends that they have no right, accordingly rejected their claim.
You appear for landlord.
I appear for the landlord. And there I have also taken an objection, saying that Jairam's signatures were forged in two documents.
All right. Now this recalling application is contested. You have filed objection.
I have filed my objections, yes.
You have filed or are going to file?
No, I have already filed.
Filed.
Yeah,
Out.
objection.
ಹಾಕಿದ್ದೀನಿ.
You know, what are your objections?
His objection is, Manoj, the Jairam Manoj claims to be the subsequent purchaser under whom I was the tenant. Manoj, he appears before the land tribunal, records a statement that yes, it can be given to me and that I am a tenant. Manoj, occupancy price were determined. He files an application for withdrawal.
And thereafter,
No, who died and you?
no, that's what happened is there was first tribunal's order is 75 granting me occupancy rights. That was never challenged by him. That Narayanamma, who's the sex respondent, she files an writ petition after some 19 years, and at her instance, matter was remanded. At the second instance, my application was rejected. That is why I am before the Supreme Court. So during the pendency, that
We are on a
Jairam
shorter
died.
point, we are on a
Yes.
shorter point, whether you could have secured a compromise without bringing a laws of contesting.
Yes, because Manoj, I had filed a memo saying Jairam had consented for it being given to me. And
No,
the
no.
first order where Manoj, I was confirmed with the occupancy rights was never questioned by him. And Manoj, I produced documents to show that Manoj, he had consented for it. There are documents to substantiate
That may
that. So-
not be the reason. What the tribunal holds is that Muniswamy Reddy who had no possession at all. He had not even a record of rights to show that he was in possession.
They are on mental ability of recalling, we'll examine, we'll hear you.
One more aspect, my lord. Same day, what my lord, was on the same day, there was a confirmation deed was been executed, giving the entire 4 acres to the consent to the petitioners. But the 30 guntas, so far as 30 guntas has been relinquished to the BBMP. If it is 30 guntas has been relinquished, there is the extent of mismatch, my lord. The 3 acres, 10 guntas has been with the confirmation. But the entire extent has been confirmed and same day has been disposed of. That document has not been placed by the petitioners, my lord.
ಅವರಿಗೆ ಇದೇ ಇಲ್ಲ ಲೋಕಸೇ ಇಲ್ಲ ನಾರಾಯಣಮ್ಮ her mother has Manoj seized the purchase. She has signed the compromise. So now the daughter wants to come and say my mother was dumb, she did not have any idea, and that I have a right.
Safeguarded, my lord, that is
Audit,
the only endeavor. We have given consent, that doesn't mean that the entire extent is not money.
Audit.
Grateful.
The interim order has to be extended. Interim order granted early is extended till next date of hearing. List it on so and so date.
Senior cell is on 11th.
ಅದೇ 11th ಬೇಡ ಅಂದಿದ್ದು. Any date
You take your
other than
choice.
12th.
12th.
Hearing for the petitioner, my lords. May I request for 12th, my lords?
Request for me is the land in question has already been the subject matter for interdiction and the reconsideration. That has not been truly set out by the petitioner before this court. The issue that is litigating has already been disposed of. I have produced the application, or the oral copy is also passed by this court and the division bench. That's not reflected in the writ petition. They don't even make a whisper about it. Fairly, they should have brought it to the notice of. And it has a direct bearing, according to it, has a direct bearing on. Absolutely.
My lords, I'll make submission in so far as.
I'll
the
adjourn it, but let me go through and then
Please.
I'll adjourn. Matter ಒಂದ್ಸರಿ ಬಂದ್ರೆ ಸ್ವಲ್ಪ ಹೇರ್ ಮಾಡ್ಬೇಕು. What is Javli sir, ಏನದು what is the issue involved in? Involved in this land is within the 18 kilometers radius. Petitioner contends that he is in occupation, wants to regularization. That matter was referred to the committee says that it is within 18 kilometers, it can't be regularized. That land incidentally had been auctioned by the government. I was the auction purchaser. Oh, you are the auction purchaser. And his issue is already dealt and decided. That is issue is already granted. And why this second? Evidently, it is more than 18 kilometers. That issue is covered here. Yes. That your lordship will find on page. Oh, same parties, Amayamma and others. Page 13, bottom of the page. 30. Yes. Where is the distant issue dealt? The last but one. The committee also decided that the application of this would have to be rejected, even if the petitioner's case has been decided. It is contrary of the prohibition of such recovery of land is provided under the Kerala Act. And the distance described is 18 kilometers. The contention of the petitioner, which is only from the year 2007, And what was the earlier round of litigation act? Why did they come up with the the? refusal to regularize there. So that was affirmed. This is the order against this event. And the second round, ನಿಮ್ಮ auction ಆಗಿದ್ದನ್ನು challenge My ಮಾಡಿದ್ದಾರೆ. auction has been also set aside. I must be fair to the. No, correct. But why they have come? What is the second round of litigation? Prayer relief is.
time is on different footing, claim that his land is Hinduri land and Pada entry has been entered. For that, there are no basis, madam. I'm ready with the statement of objection, sir. Fine.
What heard?
Lords,
ಆಗಿದ್ಯಾ?
and-
What heard ಆಗಿದ್ಯಾ?
Please, my lords.
Yes, Mr. Arnab, you have to be ready.
My lords, in fact, as rightly submitted by the learned senior counsel,
Yeah,
these
it may-
weren't produced in the writ petition, however, separately were handed over to the court, my lords.
What?
The orders of, in the writ petition and the writ appeal were separately handed over to the court and submissions were made, my lords,
When?
on the previous occasion itself, my lords. Anyway, my lords will have,
After they notified.
my lords, in fact,
No,
be-
that has to be reflected in a writ petition. You can't suppress. That may incur cost also. I'm putting your notice. Come prepared, be careful when you make submissions
Great.
on the next date.
Date
Yes,
will-
sir. Yeah, sir.
Wednesday, my lords.
Fifth, all right. Mention ಮಾಡಿ ತಗೊಳ್ಳಿ.
Right.
Next.
Very important point. There's too much time to file objection.
ಯಾಕ್ರಿ ಇದು ಡೇಟ್ ಗಿವನ್ ಯಾಕೆ ಇದು?
I appear for petitioners.
ಯಾಕ್ರಿ ಡೇಟ್ ಯಾಕೆ? ಯಾವ್ದು ಬಂದಿದೆ?
Parted matter.
ಮಾತಾಡ. ಏನ್ರಿ ವಿಜಯ್ ಕುಮಾರ್ ಏನ್ರಿ ಏನ್ ಮಾಡ್ರಿದು?
I filed an appeal for number 785. That was
Seven.
allowed. That was confirmed by the appellate tribunal.
Appellate tribunal.
That was challenged.
My lord, in this case, my lord, the tenant, my lord, he has to, the paramount consideration under the section 77A is he has to lawful tenant. He has to prove he is a lawful tenant. That has not been done, proved by the,
For my side, that is in the record. They are not.
ಸ್ಟೇ ಅಂತ ಕೊಟ್ಟಿದೀವಿ.
They could.
my lord, I am the purchaser.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ತೀರಾ?
Purch-
ಹಾಕಿಲ್ರಿ 2025 ಮ್ಯಾಟ್ರ್ ಇದೆ. Maybe I assured your senior that this can be disposed of, there is nothing ಅಂತ, but Vijay Kumar
ಅಲ್ಲ, ಇದು ಮಾಡ್ಬೋದು.
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು. ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲಿವರೆಗಿದೆ?
ಇದೆ till disposal of.
Absolute. ಬರ್ಕೊಡ್ರಿ 4 weeks time to file statement. Leave this
ಅಲ್ಲ
matter.
ಇದ್ರಲ್ಲಿ ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ 2 weeks.
Correct, ಇದು 2 weeks time to file statement.
Oblige.
Yes. Seal number 8.
Responded.
ಏನಿದು?
The last case, my lord, is substituting the arbitrator now. Ready?
ರೆಡಿನಾ?
Ready.
All right.
If it is not taken.
ಎಲ್ಲಿ ವೇರ್ ಇಸ್
DCA ಅಟೆಂಡ್ ಮಾಡೋ ಒಂದು ಮ್ಯಾಟರ್ ಇದೆ, ಮುಗಿಸ್ಕೊಂಡ್ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಹೌದಾ? Let us see. ಪಾಸ್ ಮಾಡಲ? Or some other day?
ಏನಿದೆ?
7 Friday. Designate ಅದು ನಮ್ಮ Friday is a CMP matter ಅಲ್ಲ? You want it on some other day?
Can it be 6th or 14th?
You don't want on 7th?
7th something.
All right, go down, date.
And for the response.
ಯಾವುದು? ನೈನಾ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡ್ರೆ?
And for respondent.
ಹೌದಾ?
Attend ಆಗಿಲ್ಲ.
ಯಾವ ಡೇಟು? 7th. ಯಾರು ಇವರು? ಬರ್ತಾರ ಇವರು? ಯಾರು ಜಿ ವೆಂಕಟಾಚಲ? ಹಾ. ಇದು ಪಾಟೆಡ್ ಆಗಿದೆ. ಕೊಡಿ 2009 ಏನ್ ಮಾಡಿದ್ದು? On what ground rejected? Records, India. You have to secure records, madam, whether there is a court order or not, 2009 matter.
Nande madam. Why don't I know it's why? Miller,
Yes, madam.
is that serial number 10, Miller?
Yes, serial number 10, madam. You appear for whom?
Miller, I appear for the petitioner. I want to tell your lordship this story. Miller, on 10/19/2009, Miller, I am the tenant before your lordship. My application was dismissed. So, Miller, the land tribunal order was on 19/2/2009. A writ petition was filed, and the present writ petition was allowed. Then, my lord, the other side took up the matter in appeal. Then he withdrew the appeal. Then he filed a review petition and ex parte order obtained. Against that, my lord, I filed a writ appeal. Writ appeal was allowed. Calling upon this honorable court to hear the matter. What has happened, unfortunately, on 15/3/2024, when the matter was remanded, it says it has been allowed for fresh consideration. In other words, it is about to recalling the order. Then, my lord, I have filed a writ appeal because this honorable court should have heard instead of studying. So, my lord, my writ appeal is 8549 of 2024 is pending. But, my lord, I am not worried about it. If your lordship would hear me on the merits, my lord, I am ready. Because it's my bounden duty to bring to your lordship notice that I have filed the writ appeal. If your lordship is hearing, I am ready. But records are necessary.
Records are necessary, and you have preferred an appeal on what order?
Well, this honorable court on 15/3/2024.
15/3/2024 only.
That's why, my lord, when the matter was remanded by the appellate court, that the review was wrong. All that the court could have done, my lord, should have heard me on merits. The review copy is also not given. I am not worried. But they came to be allowed for fresh consideration. Well, I felt that legally what was the order was wrong. So, I filed the writ appeal. Then I am not bothered. Even irrespective of it, I am ready to argue the matter.
15/3/2024 order.
Yes, my lord.
15/3.
It was restored. 15/3 to in RP 350 of 2017. It was given a different number.
Oh. It restore right on that. Correct.
Yes, well. In RP 350, restored. My contentions review was not maintainable, and there was no error apparent on the face of the record, and it should have been dismissed. But anyway, my lord, I do not want to quarrel over those things, technical matters.
Opportunity, my lord, your lordship is also one of them.
How that? Early bench.
Lordship allowed the writ appeal, my lord, and it was remitted back to the review petition. And review petition, my lord, heard on merit.
I've given those details I've given.
I've allowed and restored to the original file, my lord. Writ petition has to be here on merit.
I am party to that order, madam. Division bench order.
Earlier.
Oh, my lord.
For portal number 1.
Earlier order. ಯಾವುದು ಬರೀ ರಿವ್ಯೂ ಮೇಲೆನಾ
122, 2021. Only on the order of the review. For the order.
ಹಾ.
ರಿವ್ಯೂ ಮತ್ತೆ ಮೆರಿಟ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತು, ಈಗ
ಮತ್ತೆ restore ಆಗಿದೆ.
ರೆಸ್ಟೋರ್ ಆಗಿದೆ against which ಅವರು
Restore ಬೇಡ. But no, madam is ready now. She says that even she is ready to argue on merit.
And technically, I felt that the order was, that's why I had to
Correct,
later
you are
on.
right.
That's
If there is no stay, if
Yes,
there is no stay, you
yes,
can argue also.
yes.
So London AG
I, anyway, irrespective of the fact, I have not taken a stay in the
Yes.
appellate court. I am
Yes.
ready to.
Yes.
Records, my lord, I need the records. If government bid is having the records, will not pass it.
Secure records, London AGA is hereby directed to secure records forthwith. Release this matter. Yes.
Next week, my lord.
Next week, madam.
Grateful to your lord.
Is the 11 to report settlement?
My lord.
happy for
It,
Only this matter maybe have it on 12th now.
12th, my lord, reporting settlement. my lord.
List it. List it on 12th.
Yeah.
ಬೆಳಿಗ್ಗೆ ಬಂದಿದ್ರೆ ಬದುಕನಾಥ್, please mention. ಇಲ್ಲ 2:30.
We'll mention around 1:30.
ಬೆಳಿಗ್ಗೆನೆ ಬಂದಿದ್ರೆ mention.
Please, please,
Yes, sir, next.
12th.
ಇದೆಯಾ?
And for the petitioner, Manoj. May I submit, Manoj?
Yes, sir. What is this matter?
Sir, ಏನಾಗಿದೆ? There is an order passed in the year, I am basically the owner through a registered sale deed. My predecessor in title got the property through a grant. That property was given in auction by the government itself in the year 2006. That was challenged by me. 2011, there is an order by this honorable court that I am the owner of the property. ಯಾರು ಆಕ್ಷನ್ ಪರ್ಚೇಸರ್ ಇರ್ತಾರಲ್ಲ ಅವ್ನಿಗೆ ಅಲ್ಟರ್ನೇಟ್ ಲ್ಯಾಂಡ್ ಕೊಡಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ. Based on that, special DC orders in 2011 that Khata and RTC has to be put in my name. Now in 2024, without hearing me also, they issue a notice through WhatsApp. I go and give my documents. They pass an order in Annexure A, special DC. What he says that I have not given any documents. And in the notice it says, survey number 18 ge adjacent land, survey number 58 ಮತ್ತೆ 59, ಅದರಲ್ಲಿ ರೋಡ್ ಒತ್ತುವರಿ ಆಗಿದ್ದ ಜಾಗನ ಖಾಲಿ ಮಾಡೋ ಸಲುವಾಗಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ಇನ್ ದ ಆರ್ಡರ್ 58 ಮತ್ತೆ 59ನ ಬಿಟ್ಬಿಟ್ಟು ಬರೀ ನನ್ನ ಸರ್ವೆ ನಂಬರ್ 18ನ ಮಾತ್ರ ತಗೊಂಡು ಅದನ್ನ ಬಂದು ನಾನೊಂದು ಕೌ ಶೆಲ್ಟರ್ನ ನಡೆಸ್ತಾ ಇದ್ದೀನಿ ಅಲ್ಲಿ. ಅದನ್ನ ಮೊನ್ನೆ ಬಂದು ಪಾರ್ಟ್ ಡೆಮಾಲಿಷ್ ಮಾಡಿದ್ದಾರೆ. And the order is also sent to me through WhatsApp. I produced the WhatsApp screenshot also.
Also, as per the directions of this honorable court.
ಯಾವುದು?
This order came to pass upon the observation made in the one of the petition by this honorable court.
There is a PIL, Manoj. ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, he refers to one PIL. I verified everything. It is with respect to lake properties. Lake encroachment ಎಲ್ಲಾಗಿದೆ ಅಂತ ಆ ಎನ್ಕ್ರೋಚ್ ಪ್ರಾಪರ್ಟೀಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇವ್ರು ತಪ್ಪನ್ನ ಹೈಡ್ ಮಾಡೋದಕ್ಕೆ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಬಂದು ಒಂದು ಗೋಶಾಲೆ ಡೆಮಾಲಿಷ್ ಮಾಡೋದು ತುಂಬಾ ತಪ್ಪಾಗುತ್ತೆ.
ಇಲ್ಲ, but look at the madam. ಒಂದು ಖಾತಾ ಮಾಡಕ್ಕೆ 5 ವರ್ಷ ಬೇಕು. ಡೆಮಾಲಿಷ್ ಮಾಡಕ್ಕೆ ಒಂದೇ ದಿವಸ.
ನಾನು ಫೋಟೋ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್.
He holds a title. Court has declared him to be owner. This court has declared him to be
Yes.
owner. ಅದೇನು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಅಲ್ಲ, ಇದು ರೋಡ್. we want to
ರೋಡ್ ಅಲ್ಲ ಏನು ಅಲ್ಲ.
why it is demolished?
It is exactly opposite to Mysore Road, opposite to this Bangalore University gate. ಅಲ್ಲಿ ಯಾವುದು ಲೇಕು ಇಲ್ಲ, ನಾಲೆನೂ ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ.
why he demolishes on what?
Don't know.
No reasons are assigned.
No reasons. ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಕ್ಕೂ Annexure A may kindly be seen. Annexure A, which is at page number.
Who has done this? Tahsildar has done this.
The special DC.
For the direction by this honorable court has conducted an inquiry, hold an inquiry.
ಇದರಲ್ಲಿ ಹೇಳ್ತಾರೆ
to know that they have encroached the government property, he passed the order for take back.
ಯಾರು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ? ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ? ಎಲ್ಲಿದೆ ಸ್ಕೆಚ್? ಎಲ್ಲಿದೆ ಸ್ಕೆಚ್? ಎಲ್ಲಿದೆ ನೋಡಿ ತರಿಸಿ.
I'll secure, they have not produced, I'll secure.
ಅಲ್ಲ ನನಗೆ ಕೊಡ್ಬೇಕು, ನನಗೆ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ನನ್ನ ಆರ್ಡರ್ ನನಗೆ ಅವ್ರು ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಕಳಿಸ್ತಾರೆ.
ಹೇಳ್ದೇನೆ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Page number 20 Swami, page number 20 may kindly be seen the
And,
order.
You're held to be the owner in which order?
Malats, it is at page number 30, Malats, the order of this honorable court, page number 29. While considering the said aspect, fourth line from the above in page number 29.
Page 29.
Page number 29, ಮೇಲ್ಗಡೆಯಿಂದ 4ನೇ line. While considering the said aspect, the deputy commissioner shall also look into the government records and thereafter pass an appropriate order after arriving at a finding of fact with regard to the ownership of the property. Next page is the order of 2011 passed by the special DC. He looks into all the material placed on record. He passes an order at page number.
Order, this was remitted back to
35.
Deputy Commissioner to
Yes,
Hodening.
yes.
He says that
Yes, page number 35.
you're the auction purchaser.
No, I am not the auction purchaser.
Your vendor is the auction purchaser.
Well, Malats, there are two people in this. I am the original purchaser from the original grantee.
Correct.
My property was auctioned off.
You are the
Then-
purchaser from the grant.
Yes,
So in this inquiry, grant is held to be genuine.
it is confirmed, Malats. It is, my grant is confirmed here. At
Your
page number
vendor's grant.
35.
Your vendor's grant.
Yes, my vendor's grant is confirmed. And I am deemed as the owner of the property.
ಅಲ್ಲ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಅಂದ್ರೆ ಎದ್ರ ಮೇಲೆ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ?
Sketch produced by the survey authority, only this facilities.
ಅಲ್ಲ ಎನ್ಕ್ರೋಚ್ ಅಂದ್ರೆ ಏನು? ಅವ್ರು ಇಡೀ ಜಮೀನನ್ನೇ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದಾರೆ ಅಂತೀರಾ? ಏನು ಅವ್ರಿಗೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ, ಗ್ರಾಂಟ್ ಇಸ್ ಅಫೆಲ್ಡ್, ಈಸ್ ದ ಪರ್ಚೇಸರ್.
They have not produced all those documents.
Sure, ನಾನು ಎಲ್ಲ
They
ಕೊಟ್ಟಿದ್ದೀನಿ.
kept the documents.
ಇಲ್ಲ ಡಿ ಸಿ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ,
ಅಲ್ಲ
ಇನ್ನು
ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ DC ಆರ್ಡರ್ ಇದೆ.
The order came to pass.
ನೋಡಿ ಡಿ ಸಿ ಹೋಲ್ಡ್ ದಟ್ ಗ್ರಾಂಟ್. ಎಲ್ಲಿದ್ದೀರಾ ಗ್ರಾಂಟ್ ಇಸ್ ಜೆನ್ಯೂನ್ ಅಂತ ಎಲ್ಲಿ ಹೇಳ್ತಾರೆ?
Let's order page number 35. In a nutshell, considering the above actual facts and circumstances of the case, in the first instance, Sri M.V. Patel, that is the petitioner, and others, the respondent herein cannot be evicted without notice from the land in question, that is 1 acre 22 gunta situated at Kenchanalli village, so and so. Since they have acquired the right title and ownership, the same under registered sale deed by virtue of the land,
ಓದ್ಬಿಡಿ.
grant in favor of the predecessors in title.
ಬರ್ಕೊಡ್ರಿ. Pursuant to remand order, pursuant to direction issued by this court in WP 4470 of 2008, Deputy Commissioner has conducted a detailed inquiry and has come to conclusion that petitioner is the owner in possession, which is based on registered sale deed obtained by petitioner from the original grantee. The Deputy Commissioner has also come to conclusion that the auction purchaser has to be allotted some other land.
Some other land.
Some other land. This being the factual matrix, the Deputy Commissioner, wide impugned order
Annexure A, Malats,
as per Annexure A,
dated 18/1/2025.
without notifying the petitioner and following the principles of natural justice,
No, he has issued a notice, but through WhatsApp. Malats.
has hastily issued a notice through WhatsApp message and has taken prescriptive action of demolishing cattle shed.
Yes, Malats.
Photographs are produced to substantiate the handedness of Deputy Commissioner. Having examined the inquiry conducted by Special Deputy Commissioner, which is evidenced at Annexure C. Annexure C.
Annexure C is the order, Malats, yes, in my file.
Annexure
Yes.
C. Pursuant to direction issued by this court is of the view that petitioner is entitled for some protection. London AGA shall secure instruction from Deputy Commissioner for having,
LDC has passed.
ಅಲ್ಲ ಅದು ಎಲ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲ ಅವ್ರಿಗೆ ಕೊಟ್ಟು ನೋಡಿ, ಅಲ್ಲ ಈಗ
Let them conduct the inquiry properly.
ಮೇಡಮ್ ಗ್ರಾಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಆಗಿಲ್ಲ. ಈ ಕೋರ್ಟು ರಿಮಾಂಡ್ ಮಾಡಿದೆ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ಗೆ, ಎಂಕ್ವೈರಿ ಮಾಡಿದ್ಮೇಲೆ ಗ್ರಾಂಟ್ ಜೆನ್ಯೂನ್ ಅವ್ರು ಓನರ್ ಅಂತ ನಿಮ್ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಇದೆ ಇಲ್ಲಿ. ಇದು ಯಾವ್ದು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಅಂತ ನೀವು ಡಿಸ್ಪೋಸಸ್ ಮಾಡ್ತಾ ಇದೀರಿ ಈಗ?
Based upon the report.
ಯಾರು ಆಕ್ಷನ್ ಪರ್ಚೇಸರ್ಗೆ ಕೊಡ್ಬೇಕಂತಾನೆ, ಯಾರಿಗಿದು? ನೋಡಿ ಸೆಕ್ಯೂರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಏನ್ ಬದ್ರಿ? Instructions as to how Deputy Commissioner, without following due process, would have taken prescriptive action. A specific explanation shall be offered by way of an affidavit. It is also open for learned AGA to secure relevant documents to justify Deputy Commissioner's action of demolishing petitioner's property without inquiry. Meanwhile, Deputy Commissioner is hereby directed not to take any further prescriptive action till next date of hearing. Learned AGA is directed to accept notice to 1 to 5. Yes.
Unless I may be permitted to comply with the office objections.
ಏನಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್?
ಅದರಲ್ಲಿ ಕೆಲವೊಂದು ಮಿಸ್ಟೇಕ್
ಮೈನರ್ ಇದೆಯಾ?
ಮೈನರ್ ಇದಾವಿಲ್ಲ.
ಬರ್ಕೊಡಿ. Counsel for petitioner is permitted to rectify office objections in the open court. Yes.
ಏನ್ ಮಾಡೋದು?
Next. Yes, Ravi Shankar. Oh, yes. Is extension of time. ನಾವು ಮಾಡ್ಬೋದು, ಅದು ಯಾರ್ದು ಸಾಹೇಬ್ರದ್ದು
Coordinate bench was passed the order
ಅವರೇ ಮಾಡ್ಬೇಕಾಗತ್ತಲ್ಲ.
with reserving liberty, that observation will come in the order, my lord.
ಈಗೇನ್ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದಾರ ಅವರು?
Contempt, yes, they have filed contempt and for the vast land, my lord, hilly rock area, 1,600 acres are there and 610 grantees are there, my lord. Now nearly 400 something grant survey has been conducted, my lord. Only 200 something is there.
ಬರ್ಕೊಡ್ರಿ.
1 month time is required.
ಬರ್ಕೊಡ್ರಿ. This court, while disposing of the writ petition, reserved liberty to state to seek further extension by filing appropriate application. In the light of liberty reserved, state has moved an application and application seeking extension of time. This court having perused the reasons assigned seeking extension, ಯಾಕೆ ಏನ್ ಕೇಳ್ತಾ ಇದೀರಾ?
Because of the, my lord, hill block survey number, 1,600 area vast extent ಇದೆ.
This court deems it fit to further extend the time by another 4 weeks. Another 4 weeks, for another 6 weeks. It is made clear that state shall not seek any further extension. Is not entitled for any further extension. ಯಾವ್ದಿದೆ ಪಾಸ್ವರ್ಡ್? ಎಲ್ಲ ಕೊಡ್ಬೋದಾಗಿತ್ತು. ಡೇಟ್ ಏನು ಅರ್ಜೆಂಟ್ ಇದೆಯಲ್ಲ? ಕಲೆಕ್ಟ್ ಡೇಟ್ಸ್.
Day after tomorrow.
ಕಲೆಕ್ಟ್ ಡೇಟ್ಸ್ ಕೊಡ್ತಾರೆ ಡೇಟ್ಸ್.
The preliminary hearing.
ಯಾವ್ದ್ರಿ? 36 ಯಾವ್ದು? ಲಾಸ್ಟ್ ಟೈಮ್ ಮೂವ್ ಮಾಡಿದ್ರಾ? ಹೋದಾ? ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ನಾ? 36 ತಗೊಳ್ರಿ. ಏನ್ ಮ್ಯಾಂಡಮಸ್ ಮೋಹನ್ ಕುಮಾರ್? ರೆಸ್ಟ್ ಆಲ್ ಡೇಟ್ಸ್.
3 senior citizens.
ಯಾವ್ದು ಸರ್? 30
30, minus 30.
13 ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 13 ಅವೆಲ್ಲ ಶಾರ್ಟ್ ಡೇಟ್ಸ್ ಕೊಡ್ತಾರೆ ಸರ್. 2015 ಮ್ಯಾಟರ್ ಅವೆಲ್ಲ ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಶಾರ್ಟ್ ಡೇಟೇ ಕೊಡೋದು. ಅಮೆಂಡ್ಮೆಂಟ್ ನಾಟ್ ಕ್ಯಾರಿಡ್ ಔಟ್.
30, last kindly, serial number 30.
ಅದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ serial number 13 petitioner is permitted to carry out necessary amendment in the open court.
Serial number 30 also not on the same list. 3 senior citizens. A request was made last time. Last time also it was in the list, but it could not reach. This second
ನೋಡೋಣ,
time,
I'm trying
some
hard.
short
What to
date
do?
note.
ಕಷ್ಟ ಬೀಳ್ತಾ ಇದೀವಿ, but ಏನ್
86,
ಮಾಡೋದು?
86, 72 years old.
ಫ್ರೆಶ್ ಫೈಲಿಂಗ್ ಸ್ವಲ್ಪ ಕಮ್ಮಿ ಮಾಡಿಬಿಟ್ರಲ್ಲ. ಅಲ್ಲಿ ಸ್ಟೇ ಬೇಕು, ಈ ಹಳೆ ಮ್ಯಾಟ್ರು ಬೇಕು.
Kindly.
ಸೀರಿಯಲ್ ನಂಬರ್ 26 ಅಲ್ಲಿ,
ಪಾಟೀಲ್ ಸರ್,
ಸೀರಿಯಲ್ ನಂಬರ್ 26 ಅಲ್ಲಿ ನಮಗೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ, ಸಾಗುವಳಿ ಚೀಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಅದರ ಸಂಬಂಧ ಪ್ರಿವಿಯಸ್ ಅಕೇಶನ್ದಲ್ಲಿ ಬಂದಿದ್ವಿ. ಆಮೇಲೆ ಒಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ರು, ಇಲ್ಲ KDBಗೆ ಅಕ್ವೈರ್ ಆಗೈತೆ, ಅದ್ರ ಸಂಬಂಧ ನಿಮ್ಗೆ ಕೊಡಕ್ ಬರಂಗಿಲ್ಲ ಅಂತೇಳಿ. ಅದಕ್ಕೆ KDBಗೆ ಅಕ್ವೈರ್ ಮಾಡಿದ ಜಮೀನಿಗೆ ಕೊಟ್ಟ, ನಾವೇನು ಪರಿಹಾರ ಸಂಬಂಧ ಕೇಳ್ತಾ ಇದ್ದೀವಿ. 2 ರಿಲೀಫ್ ಆಯ್ತು, ಒಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕ್ವಾಶ್ ಮಾಡೋದು, ಇನ್ನೊಂದು ಮ್ಯಾಡಮ್ ಅಷ್ಟು ಇಶ್ಯೂ ಸಾಗುವಳಿ ಚಿಟ್ ಅಂತ.
ಅದು ಅಕ್ವೈರ್ ಆಗಿಲ್ವಾ? ಅದು
ಅಕ್ವೈರ್ ಆಗೈತೆ, ನಾವು ಜಮೀನ್ ಬಗ್ಗೆ ಕೇಳ್ತಾ ಇಲ್ಲ, ಕಾಂಪೆನ್ಸೇಷನ್ ಬೇಕಲ್ಲ ನಮ್ಗೆ.
ಅದೇ ನಾನು ಅದು ಕಾಂಪನ್ಸೇಷನ್
Grant ಆಗಿದೆ.
ಬರ್ತದೆ ಅನ್ನೋ
ಬೇರೆಯವ್ರಿಗೆ ಎಲ್ಲರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವನ್ನೆಲ್ಲ ಹಚ್ಚಿದ್ರು,
ಬೇರೆಯವ್ರು ಕೊಟ್ಟಿದ್ರು.
ಬೇರೆಯವರಿಗೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಟ್ಸ್ ಮತ್ತೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳ್ತಾರ, ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಫಾರ್ ಟೇಕಿಂಗ್ ಕಾಂಪೆನ್ಸೇಷನ್ ಫ್ರಮ್ KIDB ಅಂತ.
ಆಡಿಟ್ ಅದು ಡೇಟ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಶಾರ್ಟ್ ಡೇಟ್. ಎಸ್ ಸರ್, ಇದು ಮೇಡಮ್ ಪ್ಲೀಸ್ ವೇಟ್. ನೋಡೋಣ ಅವ್ರು ಕೊಡ್ತಾರೆ, ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಎಸ್ ಮೋಹನ್ ಕುಮಾರ್ ಆಯ್ತು, ಕೊಡ್ತಾರೆ ಡೇಟ್. ಅವ್ರು ಮ್ಯಾಂಡಮಸ್ ಇದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ ಕೊಡ್ತಾರೆ. ವೇಟ್. ಎಸ್ ಸರ್,
Page number 42, my lords. I challenge the writ
Yes,
of
ಯಾರೀಗ?
mandamus for 4D, my lords. My lords, in page number
In similar matters, this Honorable Court has passed an order of 32.
ಹೌದಾ? ಯಾವ್ದು ಪಾಸ್ ಅವರು? ಅದು ಗಿರೀಶ್ ತಗೋತೀನಿ, ಒಂದ್ ನಿಮಿಷ ಇದೆ. ಕರೆದಾಗ ಇರ್ಲಿಲ್ಲ, ಎಲ್ಲಿ ಹೋಗಿದ್ರಿ ನೀವು?
my lords, in
ಎಸ್,
page number 41, my lords, I have filed an online application also. It has been
ಈಗ ಏನು ಗ್ರಾಂಟೆಡ್ ಲ್ಯಾಂಡ್ ಇದು?
granted land. Granted in 2005, my lords. 25 guntas.
ತಗೊಳ್ಳಿ ಚೀಟ್ ಎಲ್ಲ ಇದೆಯಾ?
ಎಲ್ಲ ಇದೆ ಸರ್, ಹಾಕಿದ್ದೀನಿ. ಪೇಜ್ annexure A, my lords. Annexure C, page number
ಇಲ್ಲ
20.
ಬರೀ ಯಾವ್ದು?
Serial number 36.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲ?
Second list. ma'am.
KLR court will be there, Prasad. What is this? ಎಲ್ಲ ಇದೆ. ಯಾರು ಮಂಜುನಾಥ್? ಮಾಡಿ. ಟೇಕ್ 3 months, 4 months, 5 months, 4 months. ಆರ್ಡರ್ ಬರ್ಕೊಡ್ರಿ ಮೇಡಮ್. Caption petition is filed. Feeling aggrieved by the inaction on the part of second respondent in not conducting 4D proceedings, in not conducting 4D in durasti in respect of subject land. Though repetition is submitted on 15/4/2024, which is evidence at Anagaram. Next, the counsel for petitioner learned SCGP. Petitioner based on a grant order in survey number 92 to an extent of 25 guntas is seeking 4D in durasti in respect of his portion that is granted to him. Petitioner has submitted an online application accompanying annexing all requisite documents. Petitioner is before this court feeling aggrieved by the inaction on the part of second respondent in not conducting 4D. Next, learned SCGP on instruction submits that petitioner's repetition will be considered in accordance with law, provided some reasonable time is granted. Recording the assurance of learned SCGP, this court passes the following order. Petition is allowed. For number 2, 3, 4 ಅಂತ ಯಾಕೆ ಬರ್ತಿದ್ದೀರಾ?
My lords, we have made a representation to Tahsildar, Assistant Commissioner, Deputy Commissioner, and also ADLR and DDLR, my lords.
Respond number Tahsildar and
Respond number 2 and 5, 6, my lords.
respond number 2, 5 and 6 are hereby directed to accomplish the 4D proceedings by considering petitioner's repetition dated 15/4/2024 in accordance with law. Next, this exercise shall be accomplished within a period of 4 months from the date of receipt of motion. ಅದೆಲ್ಲ ಅವರು ಆನ್ಲೈನ್ ಹಾಕಿದ್ದಾರೆ ನೋಡಿ.
What's up?
1977 Agwadi pending, my lord.
ಅದು ತಗೊಳ್ಳೋಣ ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹಾಕೋಣ. ಮ್ಯಾಂಡಮಸ್ ಇದ್ರೆ ಪ್ರಿಲಿಮಿನರಿ ಹಾಕ್ಬಿಟ್ಟು, ಮ್ಯಾಂಡಮಸ್ ಇದ್ರೆ ಅವ್ರು ಪ್ರಿಲಿಮಿನರಿ ಹಾಕ್ತಾ ಇದ್ದಾರೆ ಕೋರ್ಟ್. ಪ್ಲೀಸ್ ಬ್ರಿಂಗ್ ಇಟ್ ಟು ಹಿಸ್ ನೋಟಿಸ್.
My lord. Item 41, my lord. That is some other court. Can you have this matter?
ಶಾರ್ಟ್ ಡೇಟ್ ತಗೋ.
Tomorrow.
ನಾಳೆ ಆಗಲ್ಲ, ನಾಡಿದ್ದು.
Please, 41, my lord.
ಅದಕ್ಕೆ ನೋಡಿ ಒಂದು ಏನು ಸೈನ್ ಮಾಡಿದ್ದೀನ? ಇಲ್ಲಲ್ವಾ? ನಾಡಿದ್ದು ಮಾಡಿಬಿಡಿ, ವೆನ್ಸ್ಡೇ.
26 ಒಂದು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಹಾಕಂತ ಹೇಳ್ಬಿಡ್ರಿ, ಯಾಕಂದ್ರೆ ಅದ್ರಾಗ 2 ರಿಲೀಫ್ ಐತೆ ಅಂತ ಹೇಳಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದ್ರೆ ಹಾಕಕ್ ಬರಂಗಿಲ್ಲ ಅಂದ್ಬಿಟ್ರು. ಅದೇ ಎಂಡ್
ಇಲ್ಲ ಪಾಟೀಲ್ ರೀ, ಯು ಮೆನ್ಷನ್ ಇಟ್ ಅಟ್ 2:30. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನಾನು ತಗೋತೀನಿ.
ಆಯ್ತು.
ಇಲ್ಲ ಆಫ್ಟರ್ ಕೋರ್ಟರ್ಸ್ ತಗೊಳ್ಳೋಣ ಅಂತ. ಮೋಹನ್ ಕುಮಾರ್ ವೇಟೆಡ್ 3 dates and I have passed orders ಅಷ್ಟೇ. ಅವ್ರು ಡೇಟ್ ಕೊಡ್ತಾರ್ರಿ, ಪ್ಲೀಸ್ ಡೋಂಟ್ ಅಡ್ರೆಸ್ ದಿಸ್ ಕೋರ್ಟ್. ಲಾಂಗ್ ಅಲ್ಲ, ಅದ್ ನೋಡಿ ಕೊಡ್ತಾರ ಅವ್ರು.
42, 43 tomorrow.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
ನಾಳೆಗೆ ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಬರ್ತಾ ಇದೆ, ನಾಳೆ ಹಾಕಿದ್ರೆ
ನಾಳೆಗೆ ಈಗ ಆಗಲ್ಲ, ನಾಡಿದ್ದು ಹಾಕ್ತಾರೆ.
ಸರಿ.
ಇಲ್ಲ ಸೀರಿಯಲ್ ವೈಸ್ ಕರೆದು ಕೊಟ್ಬಿಡ್ತಾರೆ. ಇಲ್ಲ ಕೊಡ್ತಾರೆ, ಸೀರಿಯಲ್ ನಂಬರ್ ವೈಸ್ ಆಗಿ ಕರೀತಾರೆ.
ಮೇಡಮ್ ಅಲ್ಲೇ ಇರ್ತಾರಲ್ಲ, ಇಸ್ಕೊಂಡ್ಬರ್ತಾರೆ. ಯಾರೇ ಇಲ್ಲ ಬಿಡಿ.
ಕೇಶವಮೂರ್ತಿ ಅವರೇ ಏನ್ ಬೇಕು?
ಸರ್ ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಹಾಕ್ಬಿಡಿ.
ಹಾಕ್ತೀನಿ ಬಿಡಿ, ಚೆಕ್ ಮಾಡಿ ಹಾಕ್ತೀವಿ. ಓಕೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಚಂದ್ರಶೇಖರ್ ಅವ್ರು ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 18.
ಆಯ್ತು.
18.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಸರ್. ನೆಕ್ಸ್ಟ್